Sometimes I know that I was worse off.
Good morning, ladies and gentlemen, and welcome to the second day of the European Data Summit Ready for Competition. We have great full program for today, and I would like to make a small overview over the program before us. We're going to start with Winfried Weil and the blind spot of the GDPR, following the discussion with the Digital Minister of Taiwan, Audrey Tang, and as we already discussed yesterday, we are continuing with the Data Governance Act at 10:45 with a focus on data markets and data intermediaries. And in the afternoon, we're starting the discussion regarding open data and the use of data in the public administration with the French Minister of Public Administration, Amélie de Montchalin, and CEO of the German government, Dr. Markus Richter. In the afternoon, we have the Privacy Director of Apple, Mr. Gary Davis, following a really passionate discussion when it comes to the biggest data breach in history, real-time bidding, again with Johnny Ryan. In the late afternoon, we're talking about the digital strategy of the European Union, from strategy to execution, and we are closing the day with the data usage during the pandemic. But now it's my greatest pleasure to introduce Winfried Weil. We have many data specialists in Germany, but I believe nobody can explain the complexity of the data world as Winfried does in a landscape way. So dear Winfried, what are the blind spots of the GDPR? The floor is yours.
Thank you, Pencho, and thank you for inviting me to this great conference. And yeah, dear ladies and gentlemen, it's early morning, and my task is to wake you up a little bit, and I hope that I will succeed to do so. The content of my remarks come close to heresy, so maybe I will succeed in being able to wake you up a little bit, which is criticizing the GDPR. I have to make a disclaimer. I'm working for the Ministry of the Interior, but here I'm only on my private expenses. I took a day off even today, so it's just vacation for me. I took part in the GDPR negotiations from 2013 to 2015, but since then I'm dealing with data protection only on a scientific and private manner. So let's start without delay. If you're reading Commission papers, you could think, is it there now? It's there now. Okay, great. If you're reading Commission papers, you could think everything would be fine with the GDPR. You are reading about... No, it's not. Okay, sorry. You are reading about the GDPR as a gold... I can't see the... Sorry? You have to use the clicker. Sorry. Yeah, thank you. There it is. If you're reading Commission papers, you could think everything would be fine with the GDPR. You are reading about the GDPR as gold standard. You are reading that it is a fabric of a success story. You are reading that the GDPR created a global upward convergence. You are reading about a thriving data-driven economy created by the GDPR. And you are reading about a common European data space. In sharp contrast to that, my opinion is that the GDPR has to be reformed and repaired urgently. The GDPR creates tremendous problems. Here is the case for fundamental criticism. We observe huge legal uncertainty. Still, 3.5 years after the GDPR came into force, there are about 30 preliminary ruling procedures at the European Court of Justice right now, with an uncounted number of questions. We have enormous bureaucracy, We observe an impressive unwillingness to obey the legal regime, what we call in German the Vollzugsdefizit, the enforcement deficit. We heard yesterday an impressive lesson by Ryan and about the Vollzugsdeficit. During Corona pandemic, we had the clash between data protection and health protection, which with lots of unsolved questions. My impression is that voiced GDPR criticism is only the tip of the iceberg. There is even more displeasure about the GDPR that remains unvoiced. One reason for the silent displeasure is that the structural deficits of the GDPR are not recognized and therefore not named. Let me reveal 13 of these structural deficits, and don't be anxious, it will be only a 15 minutes lecture. The GDPR follows the one-size-fits-all approach. The same obligations apply to every controller. GAFA, Google, Amazon, Facebook, Apple, have to fulfill the same obligations as the bakery around the corner. The tax authority has the same obligations as the internet blogger, as the hobby photographer, and as the sports club. The pharmaceutical industry has the same obligations as non-profit organizations. And not only the same obligations apply, but the same obligations apply to every processing, regardless of whether money is earned with the processing or not, whether the processing is self-interested or serves the common good, whether private or public purposes are pursued, whether it is an everyday process or a complicated algorithm. This one-size-fits-all approach is far too undifferentiated, and it is unfair. It does not take into account the capabilities of controllers. It does not take into account whether the processing itself is protected by fundamental rights. And it is unnecessary. It basically treats low-risk and high-risk data processing the same way. Often the one-size-fits-all approach has the effect of a sledgehammer to crack a nut. The GDPR follows an all-or-nothing approach. That is my second basic criticism. If there is personal data, all rules of data protection law apply. If there is no personal data, there is no regulation. That is very undifferentiated too. The GDPR more or less knows only two categories of personal data and sensible personal data. That I wear glasses is a sensitive date. My credit card number is not under GDPR. Pretty undifferentiated as well. By extending the concept of personal reference, for example, to IP addresses, personal data becomes boundless. There is almost no longer any non-personal data in the GDPR world. On the other hand, the GDPR does not cover if anonymous data are used to enable the re-identification of data subjects or to discriminate against certain groups of people. Third point, in the GDPR, the principle of prohibition applies. Processing personal data is generally prohibited unless there is a legal ground for permission. This regulatory technique requires numerous exceptions. These are regularly the subject of disputes and legal uncertainty. This regulation technique is, as a matter of fact, hostile to processing. Its basic idea is behavior control. Processing of personal data is somehow regarded as socially undesirable. The consequence is that even processing that is protected by fundamental rights and socially desirable is under constant pressure to justify itself. The general suspicion against every controller has a symbolic effect. that triggers so-called chilling effects. That means citizens no longer make use of their fundamental rights, although they would be entitled to do so. Here is an extreme example. That's a kindergarten in the German city of Dormagen, and this picture was part of the documentation. The blonde girl in the middle was given when she was leaving the kindergarten. In this case, technically, the kindergarten was probably even right to do so under GDPR. It was a public kindergarten. They did not have a legal ground for processing pictures. And obviously, they spared the effort of obtaining and documenting consent from 38 parents, if I have counted rightly. The principle of prohibition inevitably leads to such aberrations, even if they were not intended by the GDPR. The principle of prohibition also leads to the privatization of the social, as you can see, and it leads to the juridification of the everyday. Fifth point. The data protection law is input focused. It primarily regulates the collection of data and the storage of data. Therefore, different protection needs of individuals are hardly taken into account. The input orientation of data protection law prevents the urgently needed political debate on the question of which exact uses of data should be permissible or maybe forbidden. We rarely discuss whether a specific data processing operation should be permitted or prohibited. The input focus also prevents the recognition of the output as valuable. Focusing on data collection input blinds us to the benefits of data processing output. The GDPR knows purposes of processing. It knows interests, legitimate interests by private actors, public interests by authorities. It knows risks, and it knows harms. But the GDPR does not know benefits of data processing. Benefit is not a legal category of data protection law. The term does not appear in the legal text. The GDPR is blind to the benefits of processing personal data. The fact that data processing can also have benefits is only recognized in a few recitals in the GDPR. The focus is on the individual processing interest of the controller on the one side and the individual prevention interest of the data subject on the other side. Of course, the public interest appears in the provisions, but in a very incoherent way. And there is another problem. The public interest cannot be pursued just like that. If public bodies want to serve the public interest, there needs to be a specific law, usually a sector-specific law, that specifies under which conditions the public interest may be pursued. And if private individuals want to process data in the public interest, it becomes even more difficult. Reporting a criminal offense is just provided for in the GDPR, but not data altruism, data donation, and other things. It is only foreseen that a private individual acts in his own interest or in the interest of a third party, but not in the public interest. 8. The GDPR is based on old-fashioned concepts that are no longer problem adequate. The GDPR is linked to the processing of individual data. They are treated like stones. They are treated as if they were objects. They are treated as if they were a commodity that could be kept in short supply, and this invites many misunderstandings. All personal data appear to be equally worth of protection, and many think their data would belong to them. This all fails to recognize the nature of data as information, which is data are incorporeal, data are non-consumable, data can be reproduced at will, and data are non-rival. That means that they can be used by numerous persons at the same time. The information content and the economic value are context dependent. The individual date is irrelevant in many data processing operations, such as big data, algorithms, and artificial intelligence. Thus, it is not adequate that the GDPR concentrates on the single date. 9. The GDPR is linked to processing by a single controller, and it's linked to processing in a central local processing facility. This is not adequate for today's data processing as well. Think of cloud computing, the Internet of Things, platforms, blockchain, and other complex actor networks. The legal institutions of the GDPR that regulate responsibilities when multiple actors are involved, processors and joint controllers, are insufficient. This has become obsolete due to global networking. In many cases, data processing can no longer be attributed to a fixed physical resource. The principle of purpose limitation excludes accidental discoveries in the field of science, for example, the discoveries of correlations. And the principle of data minimization excludes a priori processing based on the retention of data that is in the public interest. 10. The GDPR does not even know what it wants to protect. It is based on the fundamental right to data protection, and according to pure doctrine, any processing of personal data is an interference with this fundamental right. However, data protection alone does not indicate when such interference is justified. This can only be determined if another protected interest is added. The Data Protection Directive from 1995 still saw this protected interest in particular in the privacy of natural persons, so in the privacy right. The GDPR no longer even mentions privacy or private life. It remains unclear whether the GDPR protects privacy, the right to personality, the right to informational self-determination, or other rights. Instead, the GDPR postulates that it protects the fundamental rights and freedoms of natural persons. The term rights and freedoms is mentioned 77 times in the GDPR. However, if the GDPR is supposed to protect all rights and freedoms, this leads to an overload for controllers, as they have to take all these rights into account. Moreover, uncertainty leads to disappointment for data subjects when their expectation that the GDPR will protect all their rights cannot be met. 11th point, the GDPR contains 82 balancing tests. That means there are 82 provisions in the GDPR according to which every controller has to do a balancing of rights and interests. There are 3 fairness tests, 8 balancing of interest tests, 2 compatibility tests, 11 suitability tests, 30 necessity tests, 12 appropriateness tests, 3 proportionality tests, and 13 risk assessments in the GDPR. The GDPR contains these obligations for every data processing citizen, not just for powerful companies and authorities. In the absence of a precise definition of the protected good, of the Schutzgut of the GDPR, there is also a lack of clear standards for these various balancing tests. 12. The basic assumption of the GDPR is that there is no longer such thing as trivial data. The law therefore never sees the processing of personal data as risk-free. It imposes obligations that must be fulfilled preventively, that is, before any processing can begin. Controllers must determine the purpose of their processing. They have to define their interest. They have to seek a legal basis for their actions. They have to balance, as we have seen, rights and interests. They have to comply with transparency requirements. They have to cite legal basis. They have to provide information on legal remedies. They have to comply with the requirements of written form. They have to comply with the obligation to state reasons. They have to meet the requirements of certainty, and they have to document everything. The GDPR has a largely preventive character. If you are a controller and if you want to process personal data, there is not just one current legal obligation, but a cascade of 68 legal obligations in total. Of course, depending on how you count, I counted 68. This is a hypertrophy of obligations. Keep in mind, the less is more paradox. Too many obligations lead to the erosion of the will to compliance. And in addition, many of these information, documentation, and verification obligations cause bureaucratic costs for citizens, business, and administrations that is hardly offset by any measurable benefit. In summary, it can be said that the obligations of the GDPR probably represent an encroachment on private autonomy. It is true, last point, that the economic or social power of a private party can lead to threats to fundamental rights. This is particularly debatable because of the information power of certain internet companies, but also of insurance companies, credit agencies, and so on. However, in the GDPR, the existence of informational asymmetry is irrelevant. Market dominance, discrimination in mass transactions, or the provision of public communication spaces do not create stricter rules for the controller. The GDPR does not contain any regulations that are specifically linked to an imbalance of power between controller and data subject. On the contrary, the GDPR even strengthens the large companies. Established and large companies obtain consent more quickly and easily than newcomers and SMEs. And they have the money and the manpower to fulfill the rather prescriptive obligations of the GDPR. What can be done in the face of this unfortunate legal situation? Well, the law is what it is. A major data protection overhaul or reform or even a revolution is unlikely. It is politically unenforceable. Unfortunately, it also fails because of the European Commission's monopoly on legislative initiatives. This is, of course, a democracy problem. No national parliament, the European Parliament, no citizen has the chance to change the law. We are dependent on the European Commission's will or unwillingness to do a reform. But perhaps a creeping process of rethinking is just beginning right now. At least we currently see a move away from the one-size-fits-all solution. Rules that treat all data-related matters the same are definitely not sensible. Sector-specific regulations would be better. The EU data spaces point into this direction. In the legal policy debate, I also observe a shift towards the benefits of data processing. Data trusts, we heard about yesterday. Data donation, data altruism are the key words. These are still tender shoots, but the opening clauses of the GDPR allow for the enactment of sector-specific regulations in certain areas. The EU Commission will not like to hear that, but there are around about 70 opening clauses in the GDPR. Data use regulations could be enacted. Data use in the public interest could be privileged by law. Benefit could be introduced as a category of data protection law. The GDPR could also be interpreted in a different way. Perhaps it will be possible to see data protection law not only as a right to prevent, but to transform into a right to enable. At least is to be hoped. Thank you.
Many thanks, dear Winfried, for this great overview. It was really great presentation, and I think all those who were a bit sleepy have definitely waken up in the meantime listening to his arguments. Now I have the greatest pleasure to invite Christian Swambeck from Denmark. Yeah, Christian, please join us. Christian was involved, please, in the negotiation during the drafting of the GDPR. How many years ago, Christian? It was 2012. Together with Winfried, and we have a similar company joining us virtually from London. I hope that Elizabeth is with us, Elizabeth Stanford, who is, hi Elizabeth. Elizabeth is currently in charge of the consultation that is going on in the UK. I'm also having on the screen Eline Chivot, who unfortunately couldn't join us because of the travel ban. She is a senior expert at the European People's Party. Hello, Eline. And
Hello.
last but not least, we have a representative from the European Commission, Karolina Moskowicz, who is going to tell us and confront the arguments that we have heard today in the morning by Winfried. Great to have you today in the morning. Maybe let's start with a small reflection. Christian, what are your first thoughts listening to Winfried?
Yes. Well, my first thought is that I've worked in data protection for 19 years, and I think Winfried's presentation now is the most coherent and well-founded criticism of not just the GDPR. I think that's an important point to make, but data protection law in Europe in general. I think just to add to all the points he made, and I basically share all of them, all the criticisms. I think an important reason for why this is the case, that we have these arguments against the GDPR's current model, is that to a large extent, the GDPR copied what was in the previous directive, which was originally proposed in 1990 and adopted in 1995. And if you draw the conclusions from those dates to say that the answer for the next 20 years on how we should govern a digital society, processing of personal data in massive amounts, the invention of the internet and all the innovations that have taken place since 1990, to say that the model for regulation someone came up with in 1990 is fundamentally still the same we want to apply today, either means one, that was a brilliant model that really was future-proof, or maybe that it wasn't. I think we're arguing that it wasn't. To say that you can assume that everything that someone does with personal data should stand a test of legality, even if it's in private sector, public sector, and that those rules could be put into one single document and applied. And then also, I think that's an important point, made subject to criminal penalty if you fail to comply with these rules that are so general that almost no one can give you a clear answer beforehand. And then the final point I was saying, that's one of the final points that Winfried made, was that at the end of the day, the actors that we wanted to control or regulate to a large extent with this was the big tech companies. When we were negotiating the GDPR, it was a daily occurrence that when a new provision was being tabled or described by the Commission, they would say, this is necessary to confront the practices of Google and Facebook, etc. I just have to say, I think they're doing fine right now. I don't think we've managed to actually regulate them and contain them in any way. And I think that's why we're seeing new regulation coming along. But we can't just leave this on the table. I think we need to have a discussion. I share your skepticism about whether or not a GDPR reform is likely, but the Commission can probably answer that. I think I know the answer. But I think we need to be open to say, okay, this was an important legislative act, but it definitely wasn't the solution to everything.
Many thanks, Christian. Maybe we continue with Eline. Dear Eline, what could be the adjustment to some provisions of the GDPR that would make a difference? And also, maybe you could reflect on Winfried's thoughts as well.
Yeah, thank you very much. I hope you can hear me well. I think there's a little echo for me, but just let me know if it's difficult. So thank you very much for, first of all, for allowing us to join remotely this time, and for the Konrad-Adenauer Foundation, and of course to you, Pencho, for having me. I really enjoyed Winfried's talk and the interesting analogies that he's used, and as I actually heard and learned a few things that I had not come across yet. I very much like the part discussing the understanding of what data is and its value as well. And indeed that our strong focus on privacy, which is an important value, shouldn't overlook the importance of other critical values and dimensions that should be in the balance, like security, competitiveness, which is about economic security in the end. But I'd like to offer some comments to complement his very thorough analysis. I think we indeed haven't made it yet to achieving this one continent, one law, or sort of becoming a data Switzerland, which can explain why the EU is pushing ahead with other policies like the data strategy for industrial data in particular, which may be indirectly recognizing that we haven't managed to harness the potential of personal data with the GDPR. So we needed something more or something else. At the EPP, there's more and more conversation about how we can address the GDPR's limitation. There's been this report by MEP Axel Voss, who took a brave stance looking at a law that he himself crafted a while ago. But revising the GDPR is not actually an argument that big tech makes anymore, that it should be revised. They have the money for the lawyers. And it's good they've been regulated, but the argument that's often dismissed because it would be a big tech argument is the fact that it is limiting our SMEs and our startups' agility. If you talk to data scientists, not lobbyists, not lawyers, people who are not in Brussels, people that are not ideologists, but work with data every day, they can tell you, we sat down for hours discussing whether we were in the clear with the GDPR, whether we were compliant, because we were trying to do things with pseudonymization, for instance, and they still couldn't figure it out. So I think another thing that's interesting, I mentioned the data strategy, is GDPR can limit what the EU is trying to do now and the policies that we're trying to implement. The data strategy, and especially in the DGA and the creation of data spaces, encourages the sharing of data. Industrial data, but when you talk about data space like in healthcare or in the financial space, inevitably you will have to deal with non-personal and personal data and sensitive data. That means a lot of companies are going to have to do an arbitrage between what one law limits what you can do, collecting personal data in certain ways, while at the same time wanting to sort of participate in this data economy, which encourages you to share data. Now, of course, there's few things that I could add that the law took a while for some countries to implement GDPR, to incorporate it in their national laws. There's been this a difficult situation still for various DPAs in terms of their resources, their performance, the effectiveness. Monitoring the application of the GDPR has proven difficult. In fact, I think there's a complaint that's been filed earlier this week because saying the Commission hasn't been using the right data or doesn't have the appropriate indicators to be able to monitor how the law is implemented. Also saying that the Irish DPA isn't actually delivering, and there's perhaps an impatience also regarding DPAs, especially in Ireland, a call for them to wrap up their investigations more quickly, to really come up with bigger fines for companies. I think the Parliament even called for infringement proceedings against governments that had failed to provide regulators with sufficient resources to fulfill their duties. Now, in a nutshell, delays, insufficient enforcement also have to do with the complexity of the law. There's also a problem of cooperation between DPAs, mistrust between regulators that's been highlighted, cultural, language differences, outdated information exchange systems, and of course diverging legal systems. Now, again, I think this was mentioned, this is also costly in terms of innovation for businesses. There's a survey of Bitkom in which close to 80% of respondents, which were German businesses, said that innovation projects have failed due to concrete requirements of the GDPR. So as you probably all know, the EDPS will host a conference to address some of these issues related to the GDPR, but I'm not sure we can expect radical changes. But there is a recognition that we need a stronger common framework to tackle the digital economy. Companies and some policymakers want to see an increased standardization of regulation at the European level. But many still think it's not the time to be thinking about whether the GDPR should be amended. But the wait and see approach is just not going to work in the digital age, because technologies are moving faster than our ability to legislate. So hopefully there will be some progress made in the conversation in the margins, but I doubt that it will address some of the critical issues that including MEP Axel Voss has identified. So I'm happy to get back to later what we could do to revise the law, but I think I should probably leave the floor to my fellow panelists. Thank you.
Many thanks, dear Ellen, and thanks for reminding us to the paper of Axel Voss, who really, I think, made good remarks where should we start when it comes to the GDPR and regarding reform points. Now, I would like to welcome Elizabeth Stanford. Elizabeth, the consultation in the UK is of special interest to all of us. We would like to learn a bit more for the reasons for the consultation, and maybe exclusively to find out what was the feedback that the UK government has received. Where do you see room for adjustment, and what do you think? Could it jeopardize the data sharing agreement with the Commission, maybe?
Thanks. Gosh, that's quite a lot of things to cover. Hello everyone, my name's Elizabeth Stafford and I work on data protection reform in the UK. It's 8 AM here, so Winfried's speech definitely woke me up, especially the mention of GDPR heresy. Don't think I'm a GDPR heretic here. I worked on the negotiations of the GDPR along with Winfried, Christian, and even Carolina for a short time in the Commission team. I think the GDPR has been a success story in terms of the impact it's had on data protection rights and awareness, but as Winfried said, it's not been a perfect instrument. There were various pressures and factors at the time. For instance, 4 years that we had wasn't actually enough to get into detail on a lot of very complex issues that affect different diverse aspects of our society and economy. We were also, as Winfried said, shooting at a moving target. Technology was developing and growing as we were drafting and debating. We also had, I think, the challenge of thinking about the need for uniformity in the single market. So not just what's the impact on data subject rights, what's the impact on controllers, but what's the impact on uniformity. And that can be difficult when there's many different opinions in member states at the time. I think considering those factors, it probably, I think, was the best it could have been at the time. It was a great achievement. In fact, in the UK, we did vote for it and we brought it into our law. I think now that we're 5 years on, it's definitely not heresy to look at what the impact of some of our choices were at the time when we drafted and agreed the GDPR, to look at, is it indeed technologically neutral? I think during the talks there was quite pressure to reach compromise, so a lot of important information ended up being put in, say, recitals. Winfried mentioned the purpose limitation principle. The exemption to that is contained only in the recitals, not in the operative text. And what's the impact on researchers there? I think it's something to celebrate, but it's not beyond criticism. And there's a number of issues that Winfried mentioned that, of course, we've been thinking in the context of our reform. So as you mentioned, we published a consultation in September. We closed it a couple of Fridays ago. It contained a number of proposals for driving innovation, particularly in the research space. It looked at lessons learned from the COVID pandemic. What ways could we improve the GDPR there? And it looked also at accountability. Winfried mentioned sort of a one-size-fits-all approach in the GDPR. So we're looking in particular at the accountability framework and seeing, are there ways that we could achieve the same outcome, achieve the same level of protection, perhaps through less prescriptive processes? And can we give the controller space to achieve the same outcome in their own way? I think if I want to describe sort of our aim and our consultation in one word, well, it'd definitely be long. It's 146 pages, but the word I'd like to pick would be thought-provoking. We're asking people to reflect on a number of questions. Firstly, as I mentioned, can we achieve the same level of protection through different means? And secondly, we're often asking ourselves, and indeed the public, what does this mean? So Winfried mentioned a lot of uncertainty in the GDPR, legal uncertainty 5 years in. And we're wondering, what does this provision, this requirement mean? What would a regulator say? What would a court say? And that's not good for data subjects, it's not good for controllers. So we're asking ourselves and the public, are these problems of uncertainty really causing issues? Can we solve them through legislation? Can we clarify them? What are the risks and benefits? I think a lot of those sort of problems or lack of clarity are ones that maybe Winfried already identified. So purpose limitation, as I said before. We've spoken to many sort of data controllers, data subjects, privacy activists, and there are quite divergent views on when you can do further processing, especially for research. Indeed, what is further processing? We've seen some sort of uncertainty in the UK around university research. What is the legal basis? Winfried mentioned that you need to find a law supporting that public interest to use the public interest basis. If you're a university, is your founding charter, your statute there sufficient? Does it have to mention research? That's a question that we've been asked before by universities. The COVID pandemic also has been driving our reform. I think, again, Winfried mentioned that that's shown up some possible, again, uncertainties or problems in the GDPR that could be resolved. We had a number of telecoms companies who were asked to deliver messaging about the COVID pandemic, about the requirements. Again, there was concern, what's the lawful basis for this? Can they use legitimate interest? How do they do the balancing test when it's not actually their purpose? They're being asked to do this. Can they then use the public interest? Are they exercising official authority? Does it count as their public task, even though it's actually the government's public task? So there was, I think, quite a lot of uncertainty about what the proper lawful basis was there, but everyone was in agreement that it was in the public interest for that processing to take place. Yet there's still uncertainty about how it can be lawful in the GDPR. So I think that and various other issues, we really wanted to get people thinking on these problems and solutions, because ultimately confusion doesn't benefit anyone. It's not good for data subjects. It's not good for controllers who won't want to have to wait for a test case. I think in terms of the consultation, I have to be careful about sort of saying what kind of responses we've got. We have got 3,000, and it's a bit too early to say anything yet. So it's 3,000 responses for us to read through. We also had 40 round tables where there was quite a number of themes. Some of them did pick up on issues Winfried mentioned. We were also asked about what would be the impact of our reforms on data subjects, and to what extent should we actually legislate to correct any of these issues? Is guidance a better alternative? So we have to read through all of those 3,000 responses. That will take quite some time, and I can't say until we've done this whether there will indeed be a reform bill, but I can say with certainty that there will be a government response, and we're going to publish that in spring 2022. Lastly, I think you asked about adequacy. That's indeed been a question that we've had throughout the roundtables and the consultation. I think it's important to recognise that the European Commission themselves have said that when they're doing adequacy assessments, the third country's law does not have to be a carbon copy of the GDPR. We currently do actually have a carbon copy. We brought the GDPR into our law, made almost no changes other than relabeling it the UK GDPR. But yes, it doesn't have to be a carbon copy forever. And indeed, the current range of adequate countries show quite a sort of diverse, different range of laws. And I think well, I use the word difference. I think divergence certainly probably isn't the right word here. When I think of divergence, I think of us going in different directions, and we don't see ourselves as going in the different direction of the EU GDPR at all. We see this more as clarifying various matters. We're trying to reach the same outcome, the same level of protection through different means. We're seeking to clarify things that are uncertain in the text for the benefit of data subjects and controllers. But we're still wanting to build on the same foundation, the same data subject rights, principles, enforcement mechanisms, because there's the very same principles that have indeed made the GDPR such a success. It is world-leading regulation at the moment. But as I said, and I think as Winfried's presentation showed, it's not without faults. There are areas that could be looked at, and that's what we're hoping to do with our reform.
Many thanks, Elisabeth. You made great overview, and now I think it's much more clear why are you doing this and what we may expect in the coming months. I'm glad that also we have a representative from the European Commission with us virtually today, dear Carolina. Obviously, no one wants to put in questions the relevance of the GDPR. However, there is obviously some room for improvements. Yesterday, we heard also by Johnny Ryan that enforcement matters. How do you comment the presentation of Winfried and the thoughts of Christian and Aline and Elisabeth, please?
Good morning, everybody. And thank you very much for having me here. I'm very happy to indeed address at least some of the points which were made in this so entertaining, let me call it, presentation. Well, just to start with, and I think that I have rarely seen and heard, even not only in the morning, but throughout the day, so many simply wrong propositions. To start with, one size fits all. It's completely not true. It's just wrong. GDPR is a principle-based legislation. Yeah. And this is precisely the reason Winfried made afterwards the comments that there are still so many preliminary rulings and the need to clarify the application of certain rules. Why does this principle-based approach help us so much? Because it provides for scalability of the obligations. It provides for more that the controllers should impose on themselves, more obligations depending on the risk the processing signifies to individuals. So precisely no one fits all approach, precisely scalability, precisely dependence on the risks, and precisely accountability principle of which other speakers were talking. Then another point, encroachment of private autonomy. We do not need the law because we have already fundamental right. Well, this is very entertaining because I wouldn't know how to enforce a fundamental right if I would not have been equipped with enforceable rights in the GDPR in order to enforce my fundamental right. That every processing provides for, or every processing triggers information obligations. This is precisely therefore so that my fundamental right can be enforced, that I know what's going on with my data. Now, in context with this goes this allegation that it's so individualized. Well, it's enough to have a look in the GDPR recital 4. The processing of personal data should be designed to serve mankind. The right to protection of personal data is not an absolute right, but must be considered to its function in society and balanced against other fundamental rights. This already shows how much the GDPR provides for calibrations between the individual right to have his, her personal data protected and to which extent this processing serves the public interest. Well, I could go on, and just to start with this really remarks concerning the definitions and that we have anonymized data not protected under the GDPR, and that because what happens if this anonymous data is being rendered personal data? Well, if it's personal data, then it's under the GDPR. If it's anonymous data, then it does not allow to identify an individual, and therefore it does not fall under the Charter and the fundamental right of freedom of right to protection of personal data. Finally, privacy not mentioned in the GDPR? No, because the GDPR is about protection of about a different fundamental right, protection of personal data, and not privacy. About privacy, Winfried, it's e-privacy directive and regulation. Well, so much because I think I can even not cover all the imbalance of power. Since when was the GDPR supposed to cover aspects which are covered under consumer law and competition law? The GDPR is about giving the control back to individuals, to data subjects, with what is going on with their fundamental data, with their personal data. Their right to protect their fundamental right, and putting it in context of function of this right in the society. It is open. It is not one size fits all. The controller should assess the risk the processing they undertake is presenting and impose on themselves more obligations if they have a processing which can have more impact on the individual. That the size of that undertaking does not matter was extensively discussed in the council. Very big undertakings can have a very non-intrusive processing, and a very small undertakings which are in processing, for example, very sensitive DNA data, although very small, will have very high obligations, because what they do and when they do it, if this goes wrong, can have very important impact to the individuals. So I think this would be so much to some of the most striking points I found in the presentation. Now, I was a little bit surprised also by the comments I've heard here that and also from Elaine. So, and I hear that. So, what finally are we complaining about? About the law or the lack of enforcement of this law? Yeah, because I'm a little bit lost. I'm a little bit lost there. That the enforcement takes some time. Indeed, we are speaking about very complex cases, and cases which require very far-reaching investigations. We as the Commission, we have experience with such cases because we deal with this kind of undertakings in the competition area, and these investigations do take time. We had effects of the enforcement actions of various data protection authorities during the summer, and we have seen very important enforcement actions, including fines during the summer. Now, again, because I think this is also something to what Christian referred. The GDPR is not about reversing the imbalance of power. The GDPR is not about potential, if proven, or abuses of dominant position. It's not Article 102. The GDPR has a different function. And it's the reason the competition law, consumer protection law, and the GDPR, data protection legislation, are complementing each other and not replacing each other. As broad the GDPR is and as principle-based it is, it's not about rebalancing of powers of different different undertakings. It's ensuring that when personal data is being processed, this data is processed legally. What else? All the comments made and the need, the further, let me call it specification or legislation which the Commission proposes in the area of DMA, DSA, DGA. Well, precisely, we are providing for very targeted solutions in order to address other aspects. DMA is about fairness in markets. Yeah? So DAA addresses the imbalance of powers. All this, and here all the three instruments which I mentioned, are based and embrace the principles which are provided for in the GDPR. They all refer to the GDPR. They all refer to the concepts established in the GDPR. And if at all, they build on the solutions already provided for in the GDPR. Now, very shortly to Elizabeth's statement. So again, it's very nice that somebody from the UK comes and explains us that we have a success story on the GDPR. Thank you very much, Elizabeth, because it seems that it's, here we had some other voices. Indeed, as far as awareness, as possibility to enforce this right, we are sure, also as far as establishment standards throughout the world. Now, some reflections upon what is going on now in the UK and how do we see it. So we observed, of course, with a lot of interest this consultation. And the consultation is really a very diverging bag with different thoughts, which can lead to very different solutions, beginning with providing for more guidelines or leading to indeed legislative proposals. Of course, as you said, and I think it was a question a little bit raised before, the whole question for us, should this materialize, should this concepts be endorsed? The question is to which extent it would significantly impact the level of protection provided by the UK. Of course, this is the UK sovereign decision to decide whether the businesses should now comply with two sets of legislation. We hear more and more voices that it's just adding on compliance cost and adding on the red tape, but well, I will leave it there. Now, the elements on which there were a variety of elements on which we had already some discussions. But indeed, the question of the independence of the ICO is a very interesting one. And here I'm drawing attention to the comments made by the ICO itself. And going back to the comments we had about enforcement and so on, I suppose that it will be very interesting and important to everybody, because the Data Protection Authority should not only be equipped with sufficient amount of resources, and we've heard this call from the European Parliament, and we engaged in certain actions with the member states as this call is concerned. But this DPA should be also fully independent. Concerning, I was not sure to be able to follow the comments you made on the legitimate interest, because the legitimate interest as provided for in the GDPR allows the controller to take into account the interest of the third party. For somebody as knowledgeable in data protection law, you would know that already the Working Party 29 and now the EDPB works on additional guidelines embraced very much this idea of processing, which undertaken by the controller, which pursues, which takes into account the interest of a third party. And the guidelines provide for very interesting examples in this respect. I'm here referring, for example, to the possibility to process personal data as far as the protection of children for various abuses is concerned, or for some kind of cooperation with law enforcement authorities. Let me see, because there were so many interesting and entertaining thoughts that I would like to maybe
Dear
address.
Carolina, maybe I have a suggestion.
Yeah.
Since I'm really, I would enjoy listening to you the whole day, and I think it's
Thank you
not,
very much.
I think it's not appropriate to have 10 minutes for such a debate, but keeping in mind that we have a call with the Digital Minister of Taiwan, Audrey Tang, my suggestion is to continue the discussion right after maybe the call with Gary Davis and during the presentation of Johnny Ryan in the afternoon. And I think we have enough arguments for short reaction to Winfried and Christian, and then we have to close the discussion. But I really appreciated your words. We wanted polemic debate, and this is what we get. And I'm really sorry that you couldn't join us in Berlin, but there will be enough opportunities to invite you and to come and to visit us in person. Would you agree with that?
Yes, of course.
Many thanks.
In your hands.
Many thanks. So please, Winfried, we have 10 minutes, and let's somehow sum up the discussion.
Yeah, I will keep it really briefly. First of all, I would like to say that I appreciate that we are sitting in this round together, which we did years ago when we were negotiating the GDPR. So Christian, Carolina, and Elizabeth were there, and we had maybe the same discussions in these times. Just a short reaction to 3 points. I agree completely with Carolina, not surprisingly. In one point, the GDPR is not about informational asymmetry. I was reacting with this point to a large fraction of the data protection people in Germany. There are many of them who say it is about informational asymmetry. And if you look into the history of data protection law, when it developed in the 1970s in Germany, it was about the relationship between state and citizen. And of course, one idea was that automated data processing by the state is dangerous for the citizens, and therefore the idea of data protection law developed. So one of the basic ideas was to deal with this informational asymmetry between state and citizen. And nowadays, the data protection law applies not only in this direction, but also between citizens. And that is my second point. When I'm talking about individual autonomy, I'm talking about the blogger, the street photographer, I'm talking about the researcher, and I'm talking about the artist. All of them are using their fundamental rights when they are processing personal data. If I'm taking a photo in the street, I'm a street photographer, I'm within the scope of the GDPR. And I think that should not be the case. And in Germany, we have data protection authorities who say even taking photos, not publishing them in the internet, but even taking photos of strangers in the street is forbidden under GDPR. And these are the unintended consequences. And I would probably, Carolina, you would agree with me that this should not be forbidden under the GDPR, but these are the consequences of the law, even if it is interpreted in the wrong way. Last point, scalability, calibration. Yes, you are right. We have the risk-based approach in the GDPR, but not the obligations are risk-based. Not the obligations can be calibrated. The means to fulfill the obligations can be calibrated. But
I disagree there, I have to say.
if you count the obligations, you have 68, I would say. Maybe it's only 50, depending on how you count. But the obligations is you have to search for a legal basis, you have to inform the data subject, you have to document, and so on and so on. And these obligations are not risk-based. They have to be fulfilled. Only the measures with what you fulfill the obligations are risk-based.
Christine, your final
I disagree there, yeah. I will just say that, yeah.
Your final remarks. What was the intention when you drafted the GDPR when it comes to enforcement? You also could listen to Carolina, maybe to sum up in a minute or two.
No, yeah, I'll keep it brief. So I don't know if I'll get around all aspects of your question, but I think the intention was definitely that there would be something that addressed the technological development that everyone had observed, made it necessary. Society was changing, and the rules needed to be updated. But I think to defend the observation that the GDPR is in fact one size fits all, I would say we just need to go back to the motivation by the Commission, by Viviane Reding, who was the Commissioner back then for Justice, the godmother of the GDPR, if you will, and her clarion call was one continent, one law. And that is just another way of saying.
But it's a completely different idea. It's one law, one interpretation of the law, but it does not mean one size fits all. Accountability, risk-based approach. This is what the GDPR is about.
But still, I think some of us are lawyers and have worked both
but
as
this
private counsels.
Is a completely different idea. When that it's a one interpretation, and it's precisely what Elaine was saying, that we want to have one interpretation of the law. What she was complaining about, what she was alleging is that we do not have sufficient uniformity in the application, in the enforcement. Yeah,
well, and I think we're making the point.
Scalability. Are you not telling me, Christian, that there is no scalability in the GDPR?
No, I think scalability of law is an absurdity. You don't scale law.
It's not a scalability of law. It's a scalability of obligations. Are we now having really a discussion about whether the GDPR is a principle-based regulation, which is technologically neutral and embraces variety of businesses and graduates in the obligation, a part of the very basic one, like legal basis and information rights, so that I know that my data is processed. As far as technical and organizational measures, safeguards, as far as all these elements are concerned, the GDPR sends one message to the controller. Check what you are doing, and if it has a lot of risks, you have to impose on yourself more obligations. This is the scalability about which I'm talking.
Yeah, but I still think that if you claim that, and I think I agree that is what the GDPR contains. It does contain principles, and it's principle-based, and it has these different assessments, but that's the problem. That's the problem by design.
Well, but then what? But
please
then
let me finish.
No,
Let me finish.
One size fits
please
all.
Otherwise
there is
we'll never finish.
one or the other.
No, but I can have my opinion, and my opinion is I think that is a problem. And I would also argue if we want to look forward and see how do we solve this going forward, I think we need to recognize what went wrong and to make another bold statement to make everyone know what to do. I would say that some of the dysfunction that we are claiming, at least, is in the GDPR is by design. And by that I meant that because the Commission insisted on one regulation for the entire public sector, the entire private sector, with 99 articles and all these obligations, a process began immediately in 2012, whereby carve-outs was added, balancing was added. A lot of the things that Winfried spoke about were added during the negotiations in order to give a surety to politicians, to companies, to lobbyists, that what they were dealing with in their everyday life would still be allowed. Because if you make it principle-based, no one knows what is exactly the rule that applies to them. So that was sort of by design, done both by the governments, because they wanted to make sure that what they wanted to do was still legal, and by lobbyists. But anyway, I think it's not that this wasn't said out loud back then. In fact, I even had the pleasure of co-authoring an article on this in 2013 with Peter Blume, a very well-known European forerunner researcher, professor, You can also go read it. It was published by the Cambridge Yearbook of European Legal Studies, and it's called The Illusion of Harmonization.
Having in mind that the digital minister of Taiwan is online, I would just kindly ask you, dear Elizabeth, Aline, and Carolina, with just one sentence to close this session. And I'm kindly inviting you to follow the discussion and also to be involved in the discussion in the late afternoon with Johnny Ryan. So please, Aline, your final sum-up comments.
Thank you, Bencho. I really enjoyed the conversation. I think it's nice to see some disagreement in Brussels. It's often consensus-based. So, and thanks, Carolina, for pointing out what you thought were limitations of my arguments. I think there's different schools of thoughts that point to different problems and want to see different types of progress. On the one hand, something more future-proof, friendlier towards innovation, and allows more healthcare research, keeping in mind the recent examples with the pandemic, and others that want to see just more teeth and more fines, more credibility in enforcement, more coordination among the DPAs. I think, maybe the GDPR hasn't reached its potential yet, but definitely a discussion should start on how to adjust it with clearer definitions, more specific rules for different areas, adding more speed and flexibility, of course, without compromising our privacy and our standards. Thank you so much again to the Konrad-Adenauer Foundation and to you, Bencho, and to my fellow panelists. It was very interesting.
Dear Elizabeth, and your final remarks, please.
Thanks, and thank you to everyone. I think this was a very enjoyable, thought-provoking panel, especially Carolina's views. I think, I'd agree with Aline. The GDPR hasn't quite reached its full potential, but I think we can, in the years to come, work on building on its successes and try to maybe bring more transparency for data subjects and certainty for data controllers. And we'll be thinking over these issues when we assess all our consultation responses. So look out for our future response in the new year and spring.
Many thanks. Dear Carolina, it's your pleasure and our pleasure to close the discussion.
Well, just maybe saying that with all the complaints I've heard today about the research, it's still nevertheless that we were able in the EU to have a very effective response as far as COVID or as far as the possibility to process data for COVID combating purposes is concerned. And we do have solutions which are, on the one hand, GDPR compliant, and which allow us to travel across Europe with the same pass, which is recognized in all the member states. Now, I'm very happy that somebody from Singapore can listen maybe even to that, because we were able to have the take-up of this COVID pass just because the citizens trusted in the solution we offered. Yeah? Otherwise, people were not willing to have their personal data on such a sensitive matter processed. So, thank you very much. It was a pleasure.
Thank you very much to all of you. It was a great debate. I'm inviting you to continue the discussion maybe next year in person in Berlin. Hopefully, the COVID is going to leave us alone. Thank you very much. Now we have to continue, and it's my greatest pleasure to welcome Audrey Tang, the Digital Minister of Taiwan, who is an inspiration for many, many governments around the world. Audrey Tang has done so much in the field of open data, in the field of open government. She was involved, and she is involved in the Open Government Partnership. And as we know, she has done a great job during the pandemic. Taiwan is a success story, and we would like to learn a bit more when it comes to digital social innovation. Why digital social innovation is so important for democracies nowadays. Dear Audrey, we are happy to see you. Thanks for your time. The floor is yours. Hello from Berlin.
Good local time, everyone. Can you see my slides?
Just a second, we need to adapt a bit, I think. Now it's better, now it works. Many thanks.
Excellent. Right. So again, good local time, everyone. I'm really happy to share with you some stories about how we countered the pandemic with no lockdown and an infodemic with no takedown, essentially, for the past couple years. And the root is that we work with the people, not just for the people. And that's the root of social innovation. It always begins with transparency, and I'm a minister that practice radical transparency. You're looking at my office, literally my office. It's a public park. Anyone can walk in and book 40 minutes of my time. And because we've not had a lockdowns, some of this are face-to-face, and the journalists, lobbyists, and so on all visited me on one condition, though, that everything that we said is of the public domain. It's either published as a transcript in the Say It's website pictured above, or as a YouTube a Creative Commons video allowing free remix. And in this way, people add on each other's idea, they build upon each other's components. And the lobbyists that talk to me always speak from an angle of global sustainability and partnership and benefiting the next generation, because if they say something that is only good for them but not for the next generation, it will look very bad on public record. And so that is the kind of ground for social innovation, the social innovation lab. That the social innovations that I outlined begin to sprout and help us in the counter-pandemic works. For example, we have a digital equivalent of that town square in the digital realm called the PTT. For the past 25 years, PTT is run by academic network, free of advertisers or shareholders, enjoying tremendous freedom of speech. Of course, the code is free as in freedom, GPL v3, and the governance is also distributed to all the constituents of the PTT. And that's the place when at the end of 2019, when Dr. Li Wenliang's message that there were 7 SARS cases in the Wuhan, Huanan seafood market spread to PTT, immediately people triaged the message so that we began health inspection the very next day, the first day of 2020. I would argue that it's because in this pro-social social forum, the people concentrated not on polarizing hatred and other divergence of conversations, but rather on a convergent conversation that builds a good enough consensus, a rough consensus on what a virus is, so that we establish the Central Epidemic Command Center or the CECC almost immediately on the January. Now, of course, it's not just limited for people who have the habits of accessing online forums. I'm sure that many young people or many senior people do not have the habits of frequenting such forums. So we also built a toll-free number, the 1922, that everyone can call and just speak to someone with a lot of empathy from a call center or from a professional charity. For example, last April, there was a young boy calling saying, hey, you're starting to ration out masks, which is great, but all I got is pink ones, which is not great. I'm a boy, I don't want to wear pink to school. All the boys in my class have navy blue masks. Well, the very next day on the daily 2 p.m. press conference, all the officers were pink, and that's at the suggestion of the participation officer, the officer embedded in each and every ministry in charge of civic engagement, that a Minister of Health and Welfare, Chen Shizhong, said that Pink Panther is his childhood hero. So the boy become the most hip boy in the class, for only he has the color that the heroes wear and the heroes hero wear. Of course, it's not just about fashion statements and pink and rainbow mask. It's also about data trust, collaboratives, and altruism, right? So when we start rationing out mask, already there's hundreds of different tools that's prepared by the social sector, the civil society, the most prominent of which called G0V or Gov0, to look at all the government digital services, something that GOV, the TWM fork. It's to build something that G0V, the TW, who's an alternate imagination of how it could work. And we maximally trust these civic hackers by opening up the open data in a real-time fashion. So every 30 seconds, like a distributed ledger, we publish the real-time inventory of all the spots, pharmacies, and so on that sells those masks, so that people do not have to queue in vain. And indeed, when they queue in line, they can see the person before them purchasing a few masks, and actually the number deducts. So while it was a scarcity at that time of the 2020, people do not panic, and there's no conspiracy theories and things like that, because people can participate in the auditing of the data themselves and also analyze the data bias and suggest, as per the OpenStreetMap community, a better distribution algorithm for the mask that enable the rapid adoption of mask wearing and so on. And now, come this year in May, when we first are really the only wave so far, we also work with Gov0, who made this excellent system where you just point your building camera to this QR code without having to download any app. And it sends a toll-free message to 1922. Again, no input needed. So what it does is that this is multi-party computation. Your telecom carrier keeps this record for 28 days and then delete it. But they do not know what those 15 digits correspond to. Only the venue owner knows that. So in this way, privacy is not compromised because it's securely stored in 7 or more different federated entities, and none of the data stores have this complete whereabouts that's reserved for contact traces. And we rule that it's for epidemic control use only, not even the wiretapping laws and so on can have the access to such records. And each and every one of our citizens can verify it's true by going to this website, entering their phone number, and look at this reverse audit of which municipalities, which contact tracer, look at those SMS posts in the past 28 days. And out of the almost 3 billions now sent, only a small fraction, like 12 million or so, have been accessed this way, and a complete record kept. And so this transparency report generate again on the fly, not every quarter or something, assures people that it is only being used for its originally declared purposes. And that's what allows us to shorten the contact tracing time for each infected case from 24 hours or more to less than 24 minutes. That immediately let us squash the alpha and then later on delta wave, so that it's been a few months now with essentially no locally confirmed cases. So I think one of the main lessons that we have learned in the past few years working with social innovators is that they prefer reverse procurement. That is to say, the solutions appear not from some company or from the state, but rather from the free software community, like this one, the AI assistive intelligence powered conversation method that is from AGPO3 Polis. And then we reverse procure it, meaning that we supply the necessary data and computational resources and so on, so that the social sector continue to run the public infrastructure, just like PTC, but the state benefit from the co-creation with civil society. So for example, on Polis, the gov.tw, which is essentially the same code as Polis.tw, so dual use, what we're using is basically a way to crowdsource the people's feelings around the same sort of facts. Now, of course, the people's feelings will diverge, but this way we can converge it rather quickly. For example, there was a real conversation in 2015 about UberX. Now, I can see my friends and families in different opinion clusters, but when I share my feelings, like I prefer passenger liability insurance to be mandatory regardless of Uber classification of gig economy or sharing economy, if you agree with me, you move forward to me. If you disagree with me, you distance away from me, but there's no reply button, so no room for troll to grow. And in this assistive intelligence-powered pro-social media, the trolls don't have a field day. If you get 2,000 people voting exactly the same way, it doesn't increase the plurality, and so the area of each cluster will not change. But we only hold ourselves to account to answer for the crowdsourced consensus that are on the left side. So on the right side are those ideological statements like platform versus gig versus sharing economy. But on this side, it's not undercutting existing meters, empowering local temples and churches in their local fleets, surge pricing and things like that. And these actually more people agree with each other, with their neighbors on those topics than they originally imagined. So that allows us to quickly crowdsource the key performance indicators in a way that is truly democratic and increasing the bandwidth democracy from, just a few bits every 4 years called voting to essentially continuous day to day. Anyone who collects more than 5,000 signatures can start such a interagency collaboration meeting. And I think this is a democracy of agency, not just of vote. Of course, I don't have time to go into the other parts in the Radical Civics, but you can check it out at radicalcivics.cc. So to close, I believe my own work as a digital minister is kind of tying together the collaboratives from the economic, environmental, and societal sectors through effective partnership on reliable data with open innovation. So I'll just quickly read through my job description, and I look forward to the conversation that afterwards. So this is my job description. When we see the Internet of Things, let's make it an Internet of Beings. When we see virtual reality, let's make it a shared reality. When we see machine learning, let's make it collaborative learning. When we see user experience, let's make it about human experience. And whenever we hear that a singularity is near, well, let's always remember the plurality is here. Thank you for listening.
Audrey, are you here or?
I'm here.
Yeah, perfect. I think it was really a remarkable story that it's not that easy to replicate. How come that, I mean, you have regular contacts with many governments. You're telling all around your success story of open government and open data, but it doesn't work elsewhere. Why? What do you think?
I think to give no trust is to get no trust. So really the key to make all this happen is for the public service to trust our citizens. Whenever in a smaller jurisdiction like a town or a municipality, we see this kind of trust from the public service to the citizens, we see this kind of data-based partnership thrive.
I have a question that I'm going to ask later in the afternoon to the French digital minister and to our CEO and state secretary in the Federal Ministry of Interior. And that's, do we need a socially functioning compromise between personal data on the one hand and innovations and public interest on the other? Thinking again of the pandemic and issues related to data protection.
Well, this is like asking, do we need to trade off between sustainability and development, right? Which at some point in the past, it may be necessary to make such trade-offs. But nowadays, under the umbrella of sustainable development, we're now thinking of ways like circular economy and new types of energy sources and so on that takes care of both the sustainability and the development. So in the field of personal data protection, privacy enhancing technologies plays the kind of role that a kind of, I don't know, impossible burger and beyond meat plays. It's basically taking care of both sides. Our National Center for High-Speed Computation recently worked with me to popularize a set of basically videos, memes really, about federated learning, split learning in particular, homomorphic encryption, post-quantum in particular, about the synthetic data via differential privacy and so on. And we have utilized these ideas. I've talked about multi-party computation in our contact tracing part, and I'm really excited to think of the latest improvements of post-quantum homomorphic encryption, because that means that we solved the very old dilemma of me trusting the health agency trusting the high-speed computation center, but it's not transitive, right? I don't trust the NCHC. And now with homomorphic encryption, you don't have to make this compromise. The health data can be encrypted, send for the high-speed computation, do all the computation it needs without looking into the encrypted data, and then sending data back, and then we decrypt and receive the personalized computation results. And I think these new forms of technologies allow us to maximize the usability of data without any compromise on the personal data protection mandates.
Many thanks. There is also possibility for questions from the audience. Think of it while I'm asking Audrey something else in the meantime. You know that some people in Europe consider the GDPR as a barrier for innovation. What's the relationship between your data protection regulation and the European one? In what relation are we currently?
But we're at the moment seeking GDPR adequacy because our Personal Data Protection Act was adapted from the European one pre-GDPR. So our root concerns are very similar. I think the only thing that's the difference is that in Taiwan, each and every ministry, each and every competent authority is its own data protection office, whereas the GDPR mandates a single independent body, and we're still working on that. But in Taiwan, this federated way, I would argue, also creates a stronger data norm. That is to say, instead of saying that all the data related to personal issues need to have the same norm, the Ministry of Health and Welfare works very differently as compared to the Ministry of Interior or Environmental Protection or things like that. And the reason why is just like there's no single textual technical norm, right? What's the text norm? There's a norm for journalism. There's a norm for peer review, academic publishing, and things like that with different competent authorities. So it allows us to take essentially the European ideas around data, dignity, altruism, coalitions, and trust, but interpret it in a way that is fit for the norm on the competent authority based previously on text, just turning it to data instead of seeking one unifying data norm around all sorts of different kinds of personal data.
You're quite aware of the principles of the GDPR, thinking of the first place of the purpose limitation.
Yes.
How would you commend it in respect to innovation?
Mm-hmm. Yeah, I would say, for example, when we roll out SMS-based contact tracing, because we're, after all, not Singapore, it's not mandatory. That means that people can choose to use paper and pen based or even stamp their way into the public venues, which admittedly made contact tracing harder, takes longer time to collect from those decentralized paper-based registries. But if they trust the local venues with the pen and paper records more than their telecom carriers with secure multi-party computation, well, we can't say no. And that's the real difference, because we're a pluralistic democracy. All the innovations need to be done in a way that has a graceful relationship with the people who prefer the previous generation of privacy enhancing technology, in this case, kind of slips of paper put into a box, right? And so I believe that this clear sense of purpose mandated us to basically work in the government, but on the norm that's set by the social sector. So when they say each and every SMS message need to say for contact tracing purpose only, we have to implement that. When they ask for interpretation that the wiretapping people, the people investigating even major crimes cannot look at the SMS check-ins, we have to do that, because after all, the specification is set by the civil society, not by a company, not by a state. So I call this a people-public-private partnership. So if the social sector have a reliable way to come up with the norms and habits, I would argue, of course, we need to be specific to that purpose.
Thank you very much. Before asking you something regarding the Open Government Partnership, maybe we have some question in the room. Oliver Rack from the Open Government Network, Germany. Please, short, Oli, introduce yourself and you have the opportunity for a question.
Okay, thank you. It's Oliver Rack, Open Government Network, Germany. Hello, you said it's about building trust, that's for sure. And isn't it, in addition, a question or a factor of collective learning, an intersectoral learning, which is the benefit of open government? And have you special experience with that in Taiwan? Thank you.
Yeah, definitely. In Taiwan, in our basic education system starting in 2019, a couple years ago, we switched from the term literacy, like digital literacy, media literacy, data literacy, to the term competence, data competence, media competence. The difference is that literacy is in the age of radio and television, where people just consume the messages. And competence is when people make the messages themselves. So for example, in our primary school, I think all of our primary school have something called the airbox, where people in a very young age, primary school people, can learn about climate science by measuring PM 2.5 and other air qualities and so on, and contribute to a ledger, distributed ledger, maintained by our National Academy. And that ensures that people learn about making an impact to their community. Previously difficult to teach concepts like stewardship, bias, right? Joint controllership become very easy to learn when the kids understand that the decision of their family members on whether to go to jog this morning actually depends on the accuracy of their data contributed in the airbox. Or in the middle school, the school children basically can check the presidential candidates as they're having the presidential debates and forums in real time, so that it's their media competence assignments. When they fact check the presidential candidate and they discover something is missing, the public TV and other public media work with them immediately so that the fact checks are displayed in real time. And for example, more than 1/4 of our join.gov, the TW Citizen Initiative platform is raised by the people under 18 years old, like banning plastic straws from our bubble tea drinks, takeouts, and so on. And again, when I asked the 17-year-old, why are you bringing this very impactful petition? She's like, oh, it's our civics class assignment. So I hope these 3 anecdotes show how the competence education works and how it's easier to learn rather than to be taught proper data stewardship.
Many thanks. We have one member of European Parliament that would like to ask you something. Damien, please, the floor is yours.
Yes, first of all, thank you, Minister. This has been extremely inspiring to see how you work and how you dealt also with the COVID crisis. And I have a question on that, and which is a bit more out of curiosity than fully connected to what you have been discussing, which is how do you work with the other ministers in your government? How do you ensure that you actually have the power to implement these solutions across different sectoral, if you want, competences? I would just like to learn also for our German context, and I think almost all European contexts. Thank you.
Definitely. Well, I work with the government. I don't work for the government. So again, I work with the people, not for the people. So I'm kind of at this Lagrange point where the social movements, the civic technologies on one side and the career public service on the other. I found that the most useful way to work with other ministries is ask for voluntary association for them to send secondments to my office and also to build something like my office within their ministry, what we call participation officers. And then we switch the roles of the breakout groups and facilitators. So for example, in 2017, when we crowdsourced ideas on how to change our tax filing service for the better, the breakout groups were facilitated by not the tax agency participation officer, but maybe by the coastal guard. But when we, a couple of years later, talk about the ocean policy, how to navigate the surfing and amateur fishing and professional fishing concerns and things like that, well, the breakout groups are facilitated not by the coastal guard, but maybe the tax agency participation officer. And the reason is very simple, because the coastal guard also files their own tax, right? And the financial ministry or the tax agency participation officer is also an avid surfer or amateur fisher. So by putting them in the role of citizens, facilitating such cross-sectoral conversations, citizens feel for the first time that a central government officer is actually taking their side, because it's not their business to defend a silo, it's their business to advocate to the actual citizens' need. So that's just one of the very concrete way for us to trust the citizens.
Many thanks. Maybe the very last question to our CEO of the Konrad-Adenauer Foundation and the former president of the German Parliament, Professor Lahmann, the floor is yours.
Thanks. Whenever we talk on data regulation in Germany, we necessarily talk about European solutions, whether we get it or not, but we are at least aware there is a need for supranational solutions. What about supranational solutions in Asia or even beyond Asia, global perspectives? Do they exist at all, and under which potential framework conditions?
That's a great question. Of course, in Taiwan, we're part of the Global Cooperation and Training Framework, or the GCTF, where we work with the US, Japan, Australia, and so on the kind of enabling competence conversations around many different matters, not just data. So there is something like that that we're a part of. But frankly speaking, I think when I talk about data altruism, trust, data trust, and dignity, and so on, I sometimes say that, you know, is the European spirit. So the work that you're doing in Europe, I think, has a very inspiring contribution to the conversation in Taiwan to inspire us to look beyond the kind of false dilemma, as I said, between large corporations on one side and a very large state on the other, to remind us it's not about making the citizens transparent to the state or to some companies, but rather to make the companies and the state transparent to the people. So in that sense, I think we're also very European in attitude.
Many thanks. Dear Audrey, thinking of transparency, participation, collaboration reminds you immediately to the Open Government Partnership. We had difficult birth in Germany. Now we have the second action plan. How do you consider the movement? Why is so important?
Yeah, in Taiwan, we're now, of course, on our first national action plan, but not just the open government plan, but also the open parliament plan. Actually, today is the Open Parliament Forum, and we talk about open innovations in terms of bubble tea this lunch. But what I'm trying to get at is that in Taiwan, this is not a partisan matter. All of our 4 leading parties signed on the open parliament proceedings and crowdsourced with the civil society. So it's very important in Taiwan because that's one of the very few truly nonpartisan issues, deepening our democracy, linking to international counterparts. Personally, I'm going also to share something that I just shared with you on the Summit for Democracy. That's a US-led multi-participant forum and things like that. So I think this is something that truly unites everyone in Taiwan. And we also very much unite under this banner called Taiwan Can Help, meaning that we can and we really want to share the models that I have just shared to really any democracies around the world.
Many thanks. I said in the beginning, you're inspiration for many governments, but also for many young people. Please keep on your mission. Please visit us one day in Berlin. I know half an hour is not enough for such a discussion with you. You matter to us. Many, many thanks and best wishes to Taiwan.
Definitely. Live long and prosper.
Dear guests, dear follow us in the live stream. Now we have to have a small break and we come back in 15 minutes with the Data Governance Act, and we are happy to discuss data markets and data intermediaries. So we continue the discussion from yesterday in a bit different direction. Many thanks.
was I to know that I was worse off? Keeping you around, that's why I go away. Feeling how it ends is just the worst part. I was in the man, but there was still no way. How was I to know that I was worse off?
passiert, dann wird man mir schon sagen,
our next session, and it's about the DGA, data markets. Tuesday night, there was an agreement reached on the DGA, and yeah, the idea is to boost the data economy in Europe, to create a framework to help and facilitate data sharing, especially with data intermediaries. And we want to talk about that today. We have here Damien Böselager, who's a member of the European Parliament with Volt and the group of the Greens, and was involved and reached some, or helped to reach some changes in the last minute. He can maybe talk about then. And Martin Semberger from Austria, from the Federal Ministry for Digital and Economic Affairs. He's head of the task force on open data and public sector information, which also is an important aspect of the DGA. And the German counterpart, somehow, Andreas Hartl from the ministry, head of division artificial intelligence and data economy and blockchain, and yeah. And from from Brussels or Luxembourg, representing the European Commission, Malte Bayer-Katzenberger with DG Connect. Welcome. So, the Commission and the EU wants to boost the data economy with this new instrument of data intermediaries. Maybe we can start a bit, and I would be interested, what is your general opinion about this tool, and do we have the right framework now with the DGA? So, yeah, you said we start with the Parliament, so Damien, maybe.
Makes sense to start with Malte, since he proposed, or the European Commission proposed this in the first place. But I can give just maybe a very quick answer to what you just asked, whether we have reached a good agreement. I think we have reached a good agreement that actually will help structure data markets. And I think for this we can relate a lot to the discussions that we also had yesterday, the whole question of what's the role of data intermediaries, and can we horizontally even regulate them or not. And I just want to maybe take a little step back and think about this question of data intermediaries, like why is there even a need to regulate that in the first place? And to look at that, I think it's important to understand that we had the consumer data revolution, where a lot of, or like a couple of small companies basically won the race, and then there's a lot of talk about digital sovereignty in European digital sovereignty in Brussels, and now there's this obviously the revolution of industrial data happening at the same like now as we speak. So a lot of companies are making the journey from being completely analog to being completely digital, and then maybe also have machine learning somewhere at the end of this process in their business models integrated. And in this journey, I think the question is still up for grabs of how do we what's our approach from a European level to how to structure that. Can we what will happen if we don't do anything, and so on. And then there are some people, mostly from France, who think that we should somehow make sure that the few companies that are winning this race should be French or European. But there's another side, and that is the question of not of digital sovereignty, but the question of digital competitiveness. And that's the one that I'm actually interested in. How can you make sure that the data markets that will develop or are developing as we speak when it comes to industrial data are functioning, and how can you make sure that they're not going to be just oligopolized again, potentially even by the same players that won the consumer data revolution, or I don't know, whatever you want to call it. And so I think there are a couple of steps to making sure that this doesn't happen. The first one is you have obviously a high concentration in the data storage market. Okay, cloud service provision is very concentrated. And these people are the most likely to potentially become data intermediaries because they have already all the data stored, and some of them are already building data exchange platforms. So they could easily fulfill this role and then bundle their services and then basically force everyone and take the market power that they have in data storage into the data intermediation market. Once they have done that, they can obviously also take this power via the data intermediation market into the next market, which is all the services that will follow based on data. And this is a chain of oligopolistic power and market concentration that will almost automatically happen. And here, for me, the data intermediaries, to come back to the Data Governance Act, a crucial point where we can say, like, how can we make sure that data intermediation itself as a market is neutral, is open, has no barriers to entry, and is unbundled. And that's the key for me of this whole DGA, is commercially and also legally unbundled from other services provided within this digital framework. And so the key achievement, and then I also, the others come in, but like for me of the Data Governance Act is that we managed to ensure neutral brokerage in the future data economy, which will then enable a lot of different, or hopefully enable a lot of different actors to become data intermediaries, data stock exchanges, if you want, and also hopefully a lot of startups and new businesses that then can buy this data or like get it for free, whatever the business model is of these data intermediaries, and build the very diverse European competitive landscape that we need.
Great. So yeah, Malte, maybe you can add your expectations on data markets and intermediaries under the new framework.
Yeah, let me first say good morning to you all, and thank you for allowing me to participate remotely. Interrupt me kindly if the sound or the quality is not good enough. I'm really happy about the agreement, and thank you to Damien and the entire team at the Parliament side, but also on the Council side, to Andreas, Martin, and all the delegations that helped us to shape this. I think we indeed propose a very innovative framework, especially on the Chapter 3 intermediaries. And I'll get to that maybe in a little moment, but let me also say that we have also innovative frameworks for the use of certain public sector that you cannot open up as open data. That's very known in statistical microdata access. The German audiences know the concept of Forschungsdatenzentrum, of which there are 38 in the country. And we want to really also roll out this approach that the algorithm, so to say, can come at some point to the data in the public sector as well. So we unleash the potential. And if you read the AI strategies of France and maybe UK from a few years back, that's also part of the contribution that the public sector unlocks registries, databases that contain valuable information. Then we also have data altruism, and we also hope that we have what we call Datenspende in German will take place. Here we also want to professionalize the organization of Datenspende, of data altruism, by focusing on organizations that can do this in a correct manner without over-regulating any instance of altruistic behavior, so that university centers can continue to collect data without being bothered by too much regulation. But if you want to be, so to say, the Red Cross for data altruism, you should be able to get a European label. Now, on the intermediaries, I think this is the really innovative part, and I can fully subscribe to what Damien has said in terms of the concepts. We think that it's really important to supplement the existing business model that we know from the personal data economy. I give you a service, you give me your data, and let me play with it, with an alternative model that at least supplements this, this first model, and in particular in the industrial value chains. And that's all to do with Gaia X, with Datenräume, data spaces, where we hear a lot of fear from industry that if they basically play it against the same playbook as we have seen it for the personal data economy, all the value of the digital data will go away. And it's correct that the traditional industries of Europe are not born digital, so they have a lot to catch up. And if we want to also look a bit at the lessons learned from the personal data economy, it's very important that we give them time to adapt. Otherwise, the monopolization trends in the digital economy will just aggravate anymore. And I think everyone around the globe recognizes that this is a tendency that we have to address. So we have Digital Markets Act for core platform services of what we could call gatekeepers. But I think data intermediation is such a crucial and such a distinct feature in the digital economy that we need to look at them almost as we look as banks, at financial institutions, in their neutrality as a neutral player. And that's really the message of chapter 3. We want division of labor in the data economy. We want a little less bundling, a lot less bundling if you want, if you use a data intermediation service. So the economies of bundling and of scope, we feel for a traditional player like Volkswagen, Siemens have a bit gone too far. For Bosch, for all the industrial players, so they would never subscribe to that thing. Would the market be able to do this themselves? Possibly. With the neutrality rules of the DGA, we really want to make this, advance this call for neutral intermediation. And then maybe also already anticipating a question on the business model, I think here we also have to go to very basic economic models. I mean, money is still a good currency. We have learned in the data economy that data is the new currency, and we're looking at, oh, wonderful. But I think there's also some disconcern, not only on the consumer side, but also on the industrial side, that with the data, all the value and also the intelligence about what happens inside the factory, inside the firm goes away. So this is really what underpins the chapter 3. But I'm very happy that we got to manage this in 1 year with a very dense schedule for everyone. National ministries had to really work hard on this, and also on the parliament side, there was a very intense work. So I spent half of my November in Brussels to get to the finalization, and really thankful for all players to support this.
Great. Andreas, are you happy as well? And so will we see a lot of new German companies or existing offering data exchanges and act as data intermediaries in the coming years?
Well, this is, of course, the huge promise we see and have. Let me first of all thank you for having me to this very distinguished panel. I would have loved to see maybe a female panelist too, but just on the side. Now, let me maybe just start with also a disclaimer. I'm currently representing an organization that is in a state of caretaking. We now know the draft for a coalition treaty, and this is why I see that also data, usage data is a huge issue when it comes to digital policy, but still I would like to have a little bit of legway to have an expert opinion, so please do not all that I will say on this panel as the official opinion of the sitting or the incoming federal government. That is very important to me. Now, let's start maybe with the data strategy of the European Commission. And the overall paramount goal was, we need more data. We need to unleash data. And the Data Governance Act was the first instrument, and it was supposed to create an enabling framework for data. And our understanding, and of course we had also some informal contacts when we were in the Council presidency in 2020, in the second semester, our understanding was that the Data Governance Act as an enabling framework should set flourishing guidelines and a framework that, creates trust, because trust was seen as the major obstacle. No, not having trust is the major obstacle for the development that we all like to see, for artificial intelligence, for fighting huge crises we have with climate change. At the moment, pandemic that wasn't foreseen when the data strategy was set up. Now, when we first read the Commission draft for the Data Governance Act, I had the impression that this is maybe more of a competition law. And I was looking for the aspects where really, data usage is supported. Because what happens is that what is currently allowed for under the primary law, under the treaties, now will be obliged to a license regime. Let's be clear. We will have for the intermediation services a prohibition with the preservation for a registration. And the authority that will monitor, they will, of course, check if the requirements according to Article 11 are abided with. So, you know, I started my career in the telecommunications arena, and we were fighting for the delicensing, for the opening up of the markets. Now maybe the political instrument is more to, you know, shut markets and look for entry doors. That's a political decision. I also would like to underline that we have to have in mind the interplay of the legal acts in place, in force, currently debated and coming up. And I think it's very often very interesting to see, and I heard that the discussion we just had on this panel was much like, we are in charge of data protection, privacy, competition affairs should not be a part of the objectives or instruments according to GDPR. I see that point, but to be very honest and frank, I think that this is a semi-permeable membrane, because privacy, for good reasons, is always prevailing according to the policymakers. And I don't see a discussion that GDPR can, of course, also be, for good reasons, maybe be just changed. If there's a need for change, that's on another discussion. But I think that is something we have to bear in mind. Then the Data Act will come up with complementary to regimes like the Digital Markets Act and the competition law we have in place, where significant market power and asymmetry of power is the necessary threshold for the regulatory instruments. We will have horizontal instruments. And the question is, what is the legitimation for these limitations to fundamental rights of researchers and companies? Not only I as a human being have fundamental rights according to the European Charter of Fundamental Rights, there's also this fundamental right for businesses, for enterprises, and for research. So, and this is a very difficult trade-off policymakers have to do. Now, I would, you know, just see that as a starting point for maybe what we will see in the upcoming discussion. So maybe to put it short, I think that we saw a shift in the objectives in the policy arena combined with the Data Governance Act.
Martin, yeah, what do you think about it, and what do we have to think about this first step?
Well, first of all, thanks a lot for the invitation, and yes, let me first and foremost say congratulations to the negotiators for this result. We, the member states, will of course first of all have to scrutinize this, but hopefully this will all end up well, because it is in our view, and I think this has been undoubtedly the opinion among member states, that there has not been a great kind of resistance to this act, actually, that we need some kind of governance act for data. I personally come from the corner of open data, and the Data Governance Act is actually an act that is complementing the Open Data Directive now at the European level. And as you mentioned, Andreas, quite controversially maybe also, I think that European legislation is going ever more from this kind of reactive path onto a proactive path. And instead of having regulation, when something bad happens, well, then we have certain laws, but whatever happened, happened. And this is especially fatal in the sphere of data. So therefore, we need proactive regulation. And in this regard, for us as a smaller member state of the European Union, I would say, it is competition on the one hand, of course. We need to foster competition. We need to look at the smaller players, not only the big players. Damien, you mentioned, well, the kind of concentration we see in the data sphere. So, and the Data Governance Act adds exactly to this kind of, to this emptiness that we see. I think we all need a European approach, an own way we want to go. Therefore, we need to strengthen the laws in this regard that Europe wants to pursue. And the Data Governance Act essentially adds the notion of soft infrastructures. I mentioned the openness, so the government has to think not about closing down data, but on how to enable the reuse of data in kind of secure processing environments or for the purposes of data altruism altogether. And first and foremost, with regard to the private sector, I think, and to all of you when handling your personal data, the role of data intermediaries will be crucial in enabling, in kind of representing an enabling framework on the one hand, and also building the fundamental foundation for the emerging data spaces and data ecosystems. And I see that Europe here is going a different way than maybe other continents are doing it. And yes, we still don't know what the real implications will be of all of this. We see currently an abundance of legal acts, of course, so it is also difficult for us regulators, so to say, to know is it really good what we're doing, what are the intentions. But I think the intentions are good, and we're starting, I would say, with a lightweight approach, not too heavy regulation, and we need to carefully assess how these ecosystems will flourish and whether we're on the right path. Thanks a lot.
Yeah. Malte, so what are the chances in this ecosystem for new players? And or is there maybe a risk that as well the big ones, Amazon Web Services, Damien mentioned it, already is offering a data exchange, that they get now a framework, a legal framework, which provides trust and helps to get more companies using it that are still reluctant, and in the end we see the gatekeepers having a new business model added.
Let me say, I fully subscribe to what Martin said. We have to be really proactive in our intervention. That's probably also a lesson learned. If you have to remedy a rigidified market ex post, you have a lot of headwind and you have a lot of resistance. Now you show the market a bit the direction it wants to travel. For a very specific type of service, which we call data intermediation services, the rules are admittedly strict. The other model that give me your data, Volkswagen, and I give you a service, continues to exist. So also industrial players are free to basically play this old model. Only when you are presenting yourself as a neutral middleman, as a neutral broker, if you want, then you are bound to do the rules. So it's the many-to-many data intermediation situations that we have. But the other model still exists, and if people are happy with that, it's fine as well. So are we confident that businesses will pick up? By the way, it's happening as we speak. I mean, there are a lot of startups in the personal data intermediation field, but also in the business-to-business intermediation field. And what we are first and foremost doing here is leveling the playing field, in the sense that any has the same chances to compete, and no one necessarily can benefit from vertical integration bundles anymore. That's, I think, an important amendment that came from Damian Böselager's office. And on the Amazon Web Services and Microsoft, let's be very clear, according to what I understand to be their current business offering, is that they're offering you software tools to do it yourself. So the tools that Amazon Web Services have on offer and Microsoft are a turnkey software that you implement in your firm, but you basically intermediate on your own behalf. Amazon is not intermediating for you. But they could have gone there. They could have gone there without the Data Governance Act, and they can do so after, but not benefiting from the effects of scale and networks effects that they have, so that we also leave room for other startups. But let me also say one other thing. We're staring, I think, in the discussion very often at the 5 big techs, abbreviated commonly as GAFAM. But in many traditional industries, there are big players that are also can easily become or are already gatekeepers. And I mean, those who work on many industries know exactly what I'm talking about. So as we are transposing also the platform model into traditional industry sectors, we're risking to replicate the same kind of evolution towards big companies, and that can really disrupt also the industrial landscape of Europe, which is still a very SME-driven landscape. And that's not necessarily by size of member state. I mean, it's in every member state you have big and large players, but maybe in the large countries you have the larger players because the markets were always larger. But to be seen. So let's only look at Amazon Web Services and others. There are many players, also European players, that could risk to become the gatekeepers in their respective ecosystems. And with the data spaces, Gaia X-driven or funded by the Commission or both, we really want this open ecosystem where the data sharing happens among peers and no player can exercise any power. And the kind of integrating organizer of the data space would be a regulated, well, with most of its facets, probably a regulated entity under Chapter 3. And that means we're ensuring peerness in these open industrial data ecosystem. I think that's really important for the data economy. And then the competition is not so much, can I amass data more than the other? It's that I have the original service that makes sense of the data. And I can really also pool in a completely different fashion among equals. I can pool my data among equals, but I keep the value of the data that I chipped into the pool. And it's not that the pool is administered by the third party who then skims off all the value. I think that's really the message of Chapter 3. Thank you.
How do you see the incentives for new players, for small companies, and also what could a business model be for them, and do we have the framework to support that?
So Johannes, who also helped me negotiate the act, and myself, we often joke that if we wouldn't work in the European Parliament, we would open a data stock exchange, because actually stock exchanges are highly profitable businesses, as we know. So if we believe that there is a market coming for this intermediary, basically, I think I would enter it instantly. So I think there are some questions of how can we explain how this market can be interesting, but I think players already understand that, and there are some ways via Digital Europe and other tools where you can try to incentivize setting up such a data stock exchange to a certain extent, but I think it will come. And I also don't believe that the regulation is extremely hard or strict or inhibiting, to be honest, because it doesn't forbid anyone from entering the market. It just says, and it doesn't even tell you if you have to do it for free or if you can take extremely high prices for the service that you're providing. It just says you can't use your market power from adjacent markets to bring people there and to somehow offer it for free so that the market would never come, because you can finance that with a 60% EBITDA margin of the cloud service provision. So I think that's, for me, why I believe that we actually ensured that the market could be created. And I very much agree also with Malte on saying, look at the DMA. We have been discussing this yesterday. We talk about a completely contorted market that we are trying to somehow remedy with ex post regulation. So does it really work that we always are 7 years too late, or can we potentially, I think you said this as well, can we somehow already learn from what we've seen before and just say, we're not stopping anyone from entering a market, or we're not stopping anyone from working with this, but let's try to pre-structure it. Not only because the data or the market for data intermediaries will be lost if we don't do that, but because this is such a key turn function for the future data economy, and it can be, and that would be bad to let it just fall down. I mean, if I talk to startups here in Berlin, or also in Paris or in other cities that work on algorithms, or with algorithms, and have some form of machine learning programs or services that they want to offer, a key issue for them is access to data. And so we have to somehow set up these data markets so that it's not only, then also, as I said, in the later markets, that it's not only the big ones that can have the data and then analyze it and then offer the services and all the value add that will come from that, which will be a huge part, hopefully, of our European economy, but that this data is actually accessible for people to buy on markets. And for this, we need these intermediaries to be neutral and to be trusted. And then I think that would also answer the question of, you know, if you're a business owner and you have the feeling that your data is being lost, you know, if you share it, maybe competitors can take it and so on. I think there is a strong point in saying if you know that the intermediary is neutral and you can always stop the licensing of the data that you have been doing with real-time data about your production processes or so on, if you can stop that anytime and you trust the intermediary to, you know, to help you do that, I think there's a trust-building element in that as well. And just one comment on the, sorry, but I'll make it very quick, on the overall legislative structure. I think it's good to bring that in. I have long discussions with Axel Voss about, you know, GDPR and whether we should open it or not. I'm like, I sit with the Greens, but I'm not a Green Party member. I'm not ideological about most things, maybe about Europe being a European democracy, but like, that's another thing. But like, I think we can have discussions on whether and how that there are issues in GDPR, and we had them yesterday, and we can, I mean, I'm happy to have these discussions. I'm not an expert on it, to be quite frank. But I think overall, to bring these points into other acts, like the Data Governance Act has been tried many times, or to bring them into the, you know, Data Act, and it's just mixing up things that should not, you know, you shouldn't try to solve problems elsewhere. I think we should be very clear, and I think the setup is not so bad. You know, GDPR does all the personal data stuff, and the DGA, at least Chapter 3, somehow structures the market for data intermediaries, and the Data Act will maybe talk about some things that we already saw in the impact assessments about, you know, co-created data sets and how can we, you know, somehow support that. So I think overall the setup is not so bad, Malte.
Yeah, but yesterday in the discussion when it comes to personal data and personal data management services, the PIMs that could help me as a user with my rights I have under the GDPR. Louisa Specht and Professor Kerber said the problem is that she misses an obligation for the gatekeepers then to comply with the instructions the PIMs are giving them, and then that's something, yeah, because of the consent in GDPR, which lacks. How do you see that? And can PIMs for personal data really act now and are helpful with the framework we have?
Thank you. First of all, Damian, it's really good to see that there's not so much GDPR fatigue anymore in the European Parliament. And I would really like to see that, as in the Artificial Intelligence Act, where specific provisions are proposed from the Commission to have specific allowances for processing data. Maybe that could be something also for, you know, the data regime. Because I think I'm not a real expert, so I would not never fuss with people who are really deep experts. But what I understood and what we discussed internally when it comes to the Data Governance Act and data intermediaries and data trusters, this aspect of general consent. And there is no consent if general consent is possible. And maybe, you know, a clarification in a legislative act would help. That a service provider who helps me as a data subject in executing my rights, my right of data self-determination. I would love to have that. And maybe if we could have this clarification that I can generally consent, give general consent to a PIMS, and he, with a much larger market or negotiating power than I could have as an individual, can really execute the rights I have. I think that's a nice idea, and I would love to see that discussion.
Maybe quickly jump in. I mean, I think, you know, also came in late. I think the panels before probably would have been much more, valid in discussing this. But I mean, I just know that even though I might not be in the details as you are, I know that broad consent in general is not really something that the Green Group will ever be, accepting. So I think even there, if I would be negotiating this, there would also be my hands would be bound.
Okay, thought there was no fatigue. No, but but maybe coming back to the DGA, and I would like to, not that you get me wrong. I really hope that the promise of the Data Governance Act will realize. I really do. The thing I just see is that, it was for us at least. Maybe you had better access than we had. It was very hard for us to find existing businesses that would fall under the scope of Chapter 3. In most cases, the main objective, or now what it's called aims to, the main purpose of companies is data analytics, but not orchestrating data sharing as a main objective, as a main service of a service provider. So, to be very simplifying for the sake of the discussion, we are talking about a market of data intermediaries which is really hard to examine because I don't see so many companies. And this is, because we now have a new instrument of this data intermediation service providers, and I really hope that there will be investors, as you maybe would have been, but I don't know. We discussed this a lot internally, and it was very controversial within the federal government. But the main point was, for on one side it was not enough. On the other side, it was too much. It is really a hard trade-off. And in the middle, we were good. Yeah, I hope so. I really hope so. But the thing is, we don't know. I don't want to say experimental. It's trying to set the ground for a promise of having globally significant data intermediation service providers. We try that with Gaia-X, and we really hope that this will support initiatives as Gaia-X, and especially Gaia-X. But still, I don't know if there will be companies that will voluntarily, what they could do until now do under the requirements of Article 11. I don't know. Again, I hope this will happen, but we don't know. And what I would like to see also is a bit of an open-mindedness to maybe in 2 or 3 years, when nothing happens, we could evaluate this, and also the interplay with all the policy objectives we have, and then to be open-minded for a reassessment of what are the best instruments for the undisputed, for the, we have a so broad consensus when it comes to the objectives, but we have huge discussions on the instruments and what are the specific objectives of what legislative act, and that's the point. But again, I don't see the incentive for investors at the moment, and especially not with the DGA. And I don't know if trust is a huge reason or obstacle, but I don't think it's the sole obstacle. For instance, maybe just another sentence, Oliver. Maybe one of the hurdles that we don't see a market for data sharing, if it's about intermediaries or not. And by the way, the intermediation is one of the streams I see. Also being in charge of blockchain, I see also the stream of disintermediation, like Ocean Protocol, for instance, who also try to facilitate a marketplace for data sharing the other way around. Not have an intermediary, but to have a protocol that, in a way, serves as an intermediary. But what I wanted to come back to is, I think that when it comes to incentives for data holders, I'm not talking about data subjects because that is a special discussion, but especially when it comes to IoT data, B2B data, what is the incentive for an SME to share data? I think it would really help just one. Right. So, and you know, sometimes when I say we need a market price tag, I don't mean that, you know, individuals should sell their data. That's not the point. But for a business, it could be helpful if we would have some kind of a principles or maybe even a regulation, legislation on to what extent data can be a non-tangible asset in the balance sheet of a company. We are currently having a project, Future Data Assets, where we examine this. Our colleagues in Japan having a similar project at the moment. They see the same problem with this price tag incentive problem.
Can I raise my hand as well? I'm a bit in the outside, but after Martin, maybe.
Yeah, sure.
May I?
Martin,
Yeah, there quite a lot has been said.
And afterwards, if you have questions, of course, we open.
I would kind of try to summarize it in this kind of way that you either have the classical perspective or a new perspective that is emerging here. The classical view is, and we have kind of data stores, data analytics happening in a silo, and the big players in the data economy are those players who agglomerate data and use it for their own purposes. But people more and more distrust this form of data economy, this monopolization, and this is the way why we regulate. And the other vision here we want to kind of perpetuate is a decentralized ecosystem that links all those smaller players and forms trust among them. I think trust is a key question in this, but not only. And I would say, I would interpret the DGA in a quite pragmatic way. A lot will depend upon the actors themselves, especially the data intermediaries, on what they will do. Andreas, you mentioned there are no companies on the market. I wouldn't say there are no companies there, but if you look at the global scene, where are those data intermediaries emerging? It is in Europe. Thus, it is a European idea, and maybe we can build upon this to create a ecosystem that is more alike with the roots of the internet than we see it today. This kind of network thinking, the decentralized thinking, and the collaboration thinking. And well, yeah, it's going to be difficult, but I think, and I think Audrey Tang, the minister from Taiwan, also mentioned it. Many things, many pragmatic solutions cannot be done by regulation, but will build upon the services of the data intermediaries, either on the basis of the GDPR, or facilitating data sharing. We're talking now about business-to-business sharing, business-to-government sharing, business-to-consumer sharing, all these kind of aspects. Because in this regard, you need this special link, because else you will always have only monopolies. And I think you also mentioned kind of the gatekeeper role, or it was discussed yesterday. Yes, indeed, I do see personally kind of a big chance to kind of also and Malte mentioned it actually, the classical models will persist. They can still, there is no, well, it can happen. There is no limit to that. But we're pursuing a more liberal approach here, and I think the role of the gatekeepers might shift ever more to other kind of gatekeepers, or at least to say, giving back control to the users is key. Thus, I, as a data subject, can more easily control my own data. We're talking about data is unavailable at the moment, or if it's available, it's only available for the big players. Thus, we need to work on this. And I guess if we do it right, and if the data intermediaries really build upon the foundation of a strong GDPR and these acts, then we can contribute to a flourishing data economy where people and companies trust those neutral intermediaries and establish the necessary links also to the big players, and then let the markets decide on which services will prevail in the end. It's a market economy, and I guess that, well, those users that are aware of this will more and more shift rather to these data intermediaries. That's at least the big hope in it.
Yeah, Malte, you wanted to add?
Yeah, there's so many fascinating aspects. I will be quite brief. one of the selling points of a company like Darbex was, if you trade through me, I'm the notary. I confirm that you traded your data for value X, and then you can add it to your balance sheet. That's a function. So fully with Andreas that we need that, and that is one of the services that actually implicitly the data intermediation service can offer. Now, on the question, do we see enough companies? I think that has to do with the sexiness of the market, and I am perfectly happy that the DGA as well as the intermediation services are not as sexy as the big techs that we're all constantly mentioning in our conversations. If these are discrete companies in the background, it's perfectly acceptable for me. And we see them here and there and everywhere. We see them in farming ecosystems. I mean, that farmers bracket, SMEs, end of bracket, could independently of the tech providers that sell them farming equipment, pool data among themselves to further improve the operations of the farm. Maybe form a farming data union if you want. I mean, that's the great innovation that we're bringing with the DGA. We're having the legal framework for that, and it will happen. SMEs want to also benchmark themselves for operations optimization and things like that. That's when they want to share their data, and the intermediaries will make it happen without the farmer feeling being ripped off because they are small players that cannot master this. So in the automotive, the neutral intermediary is an integral part of the competitive discussion around who accesses in-vehicle data. So there's a critical function that intermediaries could play. There's tons of technical reasons that I can't discuss here today why certain things don't happen, but we have them on the market. They're called Autonomo, they're called HERE, they're called Caruso. These intermediaries actually exist because here the aftermarket specifically wants a neutral intermediary. But that's a separate conversation of a very nice panel. Now, final point on the PIMs. And I have high esteem for Luisa and for Wolfgang on this, and we regularly converse. But we're hitting, well, we will continue to hit a certain limitation under the GDPR, and Damian alluded already to it. But it's not only in the Green Group of the European Parliament that people are very skeptical about not only broad consent, but also about exercising on behalf. And we discussed this with the supervisory authorities in the Data Protection Board. We discussed it with our internal colleagues, and people are quite careful to make a bit more flexibility on both fronts. And I fully regret it. I'm fully with Andreas that we need to go there, and with Luisa and Wolfgang. But under the current GDPR enforcement situation, we will not get there. So, and that also applies to the obligation to use an intermediary. I mean, that's really difficult. So some more headwind to go. I wish we could flexibilize. I'm also calling on the supervisory authorities that may listen to this and are here in the room to really consider this. The French CNIL has made a small step. The right to data access and to data portability can be exercised by a third party. That's a first step for the benefit of a player like Cozy Cloud. And if you have that, actually these services make sense. But they will also make sense, the PIM services make sense because our lives will get more digital. And we need services that wrap around our life, that integrate the data from all the different places that they currently are. We're digitizing banking, we're digitizing our travel, our mobility cards, but we're digitizing this in the silos that we're presented with as consumers. And this will not go on for very long. People will want a personal data cloud to have everything in one account, in one cloud, and not in 15 or 25 or 55. I think Martin Schallberg from the Competition Law Commission 4.0 mentioned 256 user accounts in a previous panel on this same stage. That's probably for a geeky professional a high number, but all of us will have these 255 user accounts, and it's completely untenable that we manage them with 255 different logins and passwords.
Okay, you wanted to add something? Or?
Yeah, maybe to Malte, thank you very much that at least you we have broad consent in many aspects we discuss here. I just wanted to take up one idea from the discussion, and I would like to make the point that with the adequacy we see for international data flows for GDPR, and now we also have a stipulation in the Data Governance Act. I see the point, I see the reasoning, but representing a ministry that is also in charge of trade, I just want to make the point that we have to be really careful that we as the European Union do not enter in something that others could see as unilateral steps to make provisions when it comes to data, and data is global. We see that in the current G7 presidency of the United Kingdom and Japan, G20, free flow of data with trust. Just saying that, with this approach of we set the rules, we are the regulator, and others have to abide. We have to see this international trade aspect too. We are, as European Union, highly competent, and we have a high welfare with multilateralism. So my point would be that we do not see this, that we have to bear in mind this multilateralism aspect also when it comes to data policy. That would be just something I wanted to also make on this panel today. Thank you.
Great.
If I can just, sorry, I have to come in here because there's a lot of confusion that we also hear in stakeholder. The adequacy decisions that we talk about pertain to data in public registries that are coming there because the law forces companies and consumers to give the data to the public registry. They have no choice. And where now there's a question whether to reuse them outside the union. And best regards to your trade colleagues, if they listen here today, I think regulating how we use public sector registry data is perfect because other countries, big countries, take very unilateral decisions as well. So let's be clear what we're talking about. We're talking about the transfer in very, very limited circumstances of data forced give by companies into public registries.
Malte, thank you. I don't want to be misunderstood. You're perfectly right with your argument on Chapter 2 and Article 30, I think it is, on the international flows when it comes to public sector informational data. That's right. I just want to make a general comment because this international aspect, international data flows, at least is worrying us that I think Francesca Bria, who will also be there today, I have a quote of her in my mind, which goes like maybe I don't remember it word by word, but in essence it was, does Europe want to be significant or relevant as a regulator or as an innovator? There must be a trade-off. Please, both, but not only one aspect of that.
If I might just chip quickly, I think we can see it as two sides of a coin. We have been talking a lot about data protection. That's one side of the coin. And here exactly in the Data Governance Act and in the upcoming Data Act, it's the other side of the coin. Actually, we're talking about how to grant access to others or to transfer data abroad. So therefore, we are actually talking about opening up channels, being multilateral. And as you mentioned, Andreas, correctly, I think the innovation is key, and the right path for Europe is to develop new innovative solutions. And I think that in this regard, Europe can be regarded as a startup nation, kind of. It's a new idea, and we're trying to push forward with these data intermediaries, so that others can grasp this up. There is no limit that it's only possible in Europe, but it's enhancing intra-European data flows and also maybe, or we have to see, global data flows as well. But of course, we in Europe, we will further develop European data spaces in which certain conditions will prevail.
Yeah, I don't know if there are any questions outside, but maybe just to quickly react, I also believe that when we talk about data flows, and you said we have a multilateral system, the bigger issue is, for me, at least from my perspective of the Industrial Policy Committee, for the data flow within Europe that you also just mentioned. Because obviously if you talk to, as I said again, an algorithm-based startup here in Berlin, then they say, look, we always hit national borders when we try to scale when it comes to data usage. So we have to open up another company, we have to somehow understand the national regulation. There's a lot of legal cost that comes up for understanding how you can use the data that is there and so on. So in general, I think it makes sense to look at this from a European level, and also, as Malte also said, I mean, I think the high sensitive public registry data that we're talking about is somehow like a very special case. Yeah.
Do you have questions here in the room? Pinto.
If I may.
Yeah.
Thinking one concrete question, maybe to Damien or to Malte, thinking of Article 11.1 and neutrality, how it responds or how it relates to the incentives. What's your comment? Or
I mean, as I said, for me, the neutrality was like the core point, and actually brings me back to the question of regulation or innovation that was mentioned. I think we try to regulate to allow for innovation. That's basically exactly what this DGA and Article 11 is about. What this chapter is about is to try to say we don't just, I mean, I said it before, so like we don't just say like if you're already big and you have a lot of data already that you're somehow maintaining or controlling or whatever it is for others as a cloud service provider, you just enter the next market and it's yours, but you actually say, look, the incentives of like going in there and trying to actually compete and maybe even compete with a price will be given because the market is not just flooded with a zero price somehow offering, yeah? So where you don't have any chance to make any profit because it's just for free. So I think that's for us one of the core elements, and it also brings me back to the question of why do people not share data because they don't get money for it. Yeah, I mean, you said we are in a market economy, but the market often doesn't exist yet. And I think the only thing that this DGA is trying to do is to actually help build that market so that you can share your data and see what kind of money you get. You know, like, I mean, let's see, because obviously the issue is that when you share it, you have the fear that maybe a competitor will use it, but you also don't know what the potential upside will be because nobody knows yet what value this data could bring if it's analyzed correctly by some form of a use case. So the only thing that we somehow need to ensure is that this data is somewhere lying around on a data exchange, sitting there waiting for someone to say, hey, I actually think that, you know, sensor data of laundry machines is super interesting to do something with it, you know? So maybe I'll just buy that or license that for like a couple of weeks in real-time flows and see if I can pair it with weather data to understand if my laundry, you know, is drying better or whatever, if it's raining, I don't know. But like, I think to have all this innovation come forward, and I'm super excited to see it for all these, I don't know, verschränken, you would say in German, like for all this data to be combined and analyzed and new services to be built of it. But for that, it needs to lie around somewhere, and for that, businesses need to have an incentive to put it somewhere where they believe it's trusted, that, you know, that the metadata that, I think most of the time just metadata that's lying around there will not be abused, and that they can then, when somebody asks them to buy it, still assess whether they want to sell it or license it out for a certain time of. So I think the incentives are there. I think Article 11 is exactly why they are there.
Could I also kind of touch upon what Pencho has said? I think it is such a crucial provision in the Act itself. I would consider us as kind of, we are constructors of a living organisms, and the data intermediaries will be the blood veins in the data economy. Or if you compare it with the highways for now, one could argue the highway belongs to one certain company that is regulating traffic on this highway, but do we want this? Do we want everything to happen in this ecosystem controlled by this player? No, I think the way is we're talking here about the necessary soft infrastructures that everybody can use, that are fair, that are accessible to everyone, and where everybody can trust in their usage, actually. And we need to foster this development of this highway network that we once started physically 100 years ago in a physical world, and now we're trying to do the same things kind of in a digital sphere. And just imagine, consent management is hampering further developments. It's not really user friendly. So data intermediaries have a great potential in contributing to consent management. We've been hearing about encryption of data, of data lines, so to say. We're talking about so many aspects where we will actually need data intermediaries for the data ecosystems, for the emergence of the Gaia X ecosystems, so that it is such a crucial step to have, and also to be complemented by further legislation that is upcoming.
Yeah, upcoming is the Data Act next year, and I think next year when we sit here we will talk about that. But maybe as the last point, we have 10 minutes left. What, in your opinion, are the important things we need in the Data Act to complement the DGA and to really create this system you described with the blood veins and then the flourishing data ecosystem?
Was that a question to me?
To all, but yeah, if you want to start. Or Malte, you wanted to?
No, I want to take notes actually, because it may matter for our drafting.
But I do have an idea, and I think
yes.
we've been, this morning we've been talking about data for the public interest, and I do expect that something is upcoming in this Data Act that in handling the pandemic or in handling kind of the grand challenges of our societies, we need data for the public interest on the one hand, and I do want to see interoperability aspects addressed also in the Data Act with regard to business-to-business sharing, business-to-government sharing, and all these kind of aspects. So there are still some legal uncertainties. Yes, those are the first and foremost, the first expectations we have. Yeah.
So I think the Data Act is also the reason why I came to this conference, because I mean all the discussions that we're having, I think somehow can flow into that, and so for me it's really an education. I'm not a competition lawyer. I'm also not a privacy lawyer, and I think it's interesting for me to sit here. So thanks a lot for organizing this. All this is very insightful. But in my view, once we have now created the marketplace, the question is what else is inhibiting companies from sharing data on these marketplaces? And one of the core questions is how do you deal with co-created data sets? So, and it can be data, like it can be a person that somehow has their mobile phone or is driving the self-driving car, but it can also obviously be a company on the user side that bought a machine, a steel cutting machine or something, and then uses the steel cutting machine, and the question is, are they allowed to somehow monetize the data that they're producing by cutting steel, or is it the person who actually sold them the steel cutting machine and put the sensors in and the software in and actually has the data to maintain? So, and both probably have some form of a right, and the question is, beyond the rights that they have to use the data for their daily work, who is allowed to share that? And just to give you one example, I don't even know where I heard it, to be honest, but I love it so much that I have to share it, is the whole question of, I talked about it earlier, the laundry machine. So if you have a laundry machine and you buy that and then you use it, and then it's connected to the internet as a part of the Internet of Things, and that is cool for you because you can potentially see on your app whether your laundry machine is still running or you started, so that you can put as whatever you want to do with that. And for whoever produced the laundry machine, it's cool because they can see how it's running and can potentially improve their production or worsen it because they want to sell it more often. I don't know, whatever. So, but the interesting thing is that what I was told is that maybe, I don't know, Malte, if it was in your context that we discussed this, but that below the laundry drum there is a sensor which is very sensible to seismographic movement. So, which means that there's data being produced that, if you think about it, if you have laundry machines everywhere across the world, you have a super interesting seismographic network to basically, either be early warnings for earthquakes or somehow give you some research data. So, but who is allowed to share this data or sell it potentially even on a data stock exchange? I think that's a key question for me that I want to understand, if we can solve that horizontally in the Data Act.
So Malte, will the Data Act create a network of earthquake warning systems of the laundry from Damien and all of us, or what other things we have to expect and what is needed?
Well, I think the interesting thing about the example, which indeed I whispered into Damien's ear, is because someone else whispered it into my ear from a manufacturer, is that you have so much reuse potential of the data, and the key call is to not lock the data up with exclusive rights, but with additional rights that can be exercised in parallel, which obviously brings the question, sometimes you have conflicting interests, in the data. Sometimes there is a trade secret that is at risk with the data. It's personal privacy that stands in the way. Thinking about a connected car shared by a household, shared by a rental company, by a car sharing. I mean, there are differences, scenarios where you need to be sure that you also manage the conflicts in the rights. But I think the key ambition of the Data Act will be to look at IoT data because of these co-created or co-generated data. And in farming, this is a huge, huge question, debate. And in many industrial contexts, it's really an emerging discussion. Obviously, many companies will tell you, and the business associations present here will tell you, well, contracts can manage all that. But I think we need some clarity on the usage of these rights. And then, yes, we want to work on the government better benefiting from data. And as you know from the inception investment, we also look at cloud switchability, which again in the Gaia X context, I think plays an important role. But yeah, I'm listening also here to just see whether we are capturing the right cases. And yeah, I'm looking forward to the next session in December 2022 to discuss then the Data Act progress.
Andreas.
Thank you. So first of all, I think that interoperability is key. And what it would be very important for us is that you know, we would have this smooth interplay of the legislation and Gaia X. So and maybe it could be that whatever is being created amongst industry actors in the Gaia X community would be supported by the legislation we see in the Data Act. So that would be something we would of course find very attractive. Now maybe 2 remarks on business to business or data sharing in general. We all know that data is a non-rival good. We are not talking about scarcity. Once we have data, it can be copied for low costs, and so the issue I would see is that we do not create exclusive rights, as Malte put it, so that we are not talking about ownership, but who is allowed to use data. I mean, we don't have to clarify who is the owner. We have to clarify who can use it. And I think then it comes to, maybe it would be very spectacular to have a principle, an open data principle with the exemptions we all know. Privacy, business or trade secrets. And I really don't know in what direction this will go, but this is at least the vision I have. Why should companies refrain to share their data? We were talking about this incentive price tag issue, but I mean, if your primary use is fulfilled, why not share it? Because reciprocally, you have the promise that you can use data from others too. And I think this is something I'm really looking forward to. Malte, and talking about trust, I have a huge trust in the colleagues from the European Commission in Brussels, and especially in Luxembourg. And maybe a last comment on business to government. I'm a bit skeptical there. I would say that we need sector-specific regulation, which company should share data for specific reasons with governments. But I'm skeptic, really skeptic, to see horizontal stipulations on that. I think this has to be decided very case by case, on a case by case basis. But of course, at the end of the day, I would like to see that also that data would be shared with public administrations too.
If I may.
One quick, but yeah, we have to continue. And
Malte, Damien, and
super quick.
Martin.
I think we should be very careful translating anything that Gaia X develops into legislation, because I mean, then we have to look at what's the governance of Gaia X, who is represented, how does it work. I mean, we can discuss what kind of need exists in the European market and how regulation can somehow work with that and see what the existing initiatives are. One of them being Gaia X, but I think that is a super quick clarification.
There is a junction between legislation and standards and norms. which is for centuries very efficient and successful. This is all I'm saying, that standards should be left to industry, but of course on the basis of state-set legislation. I was just talking about this conjunction between both, and that at least the legislation should not contradict, or, you know, of course, if there would be great reasons. I mean, I'm supporting lawmakers too, and legislators. But we should really see that we're creating currently something significant in Europe with Gaia X on the innovation side. But of course, I also see the other side of the coin, the regulatory side. Again, interplay, the junction.
We talk about Gaia X later in the summit. So yeah, one final really short remark.
I think we can see that we're all constructors, either legal constructors or down there in the physical or virtual worlds. Let me just be brief about this. I do see great potential for managing pandemic situations and so on, that the government needs data and needs it quickly to react. And so I would be fully with the digital minister of Taiwan in this regard. Let us work with the companies and with the people, and let us build upon this trust in order to create future data spaces. Yeah.
Great.
I don't want to really add on substance. I think it was a great panel. Just to advertise that my colleague Anna Ludin is in the room. If you want to approach her in the breaks and whisper into her ear what you think should be in the Data Act or should not be in the Data Act, she's part of our great team here in Luxembourg. So thank you for having hosted me virtually, and good success for the conference. I really wish to be there with you, but COVID is making things really complicated.
Great, yeah. So
my team, so I'm happy to share Anna now with the Commission.
But where is Anna? She was here. Okay. Okay.
Yeah.
Thank you very much. Thank you, Malte. And we keep your promise seriously that you are going to visit us next year in Berlin and discuss the Data Act and all the other subjects around. It was a great discussion. Many thanks to you. Now we make just 1 minute short break to change the stuff here, and we continue smoothly immediately, because the French Minister Amélie de Montchalin is already online, I've heard. We have already touched upon some subjects that we are going to discuss tomorrow. That's Gaia X and B2G data sharing. So I would be glad if you join us also tomorrow in the representation of the European Commission in Berlin. We can start. Here we go. Many thanks. Ladies and gentlemen, welcome again from the Academy of the Konrad-Adenauer Foundation. It is my great pleasure to introduce the French Minister of Public Service and Civil Transformation, or the full name would be Public Sector Transformation and Civil Service. As we know, France is a leader in Europe when it comes to open data. And we have learned a lot in Europe from the French case, so to say, especially in regarding reference data. Do we have online the minister?
I'm here.
Perfect. Emily, nice to see you, and glad to listen to your keynote, and looking forward to the discussion later with the State Secretary Markus Richter. Please, the floor is yours, virtually.
Guten Tag. I will switch to English because I understand not everybody is a German speaker today, and I will spare you my French, which will be used during the French presidency of the Council for sure. First of all, many thanks for inviting our country also to present both our strategy and also our results so far when it comes to data, and how also the COVID crisis changed not only the vision we had on data, but also changed the pace of change. Many thanks to the Konrad-Adenauer-Stiftung for the opportunity to join this EU Data Summit, and also the joy to have the, along my speech, the one of Markus Richter, which we met, with whom I met very recently. And I must say that the coalition agreement now includes many topics which are of great interest and are a follow-up of many discussions we've had previously. 2021 has been a strong and an important year for our data transformation in France. And I would like to share with you the main both objectives I've set to my ministry, and also how we managed to increase the pace of transformation coming from strategies which were designed and started to be implemented sometimes 5 to 10 years ago. Open data is not the only topic I would like to address, because I think the challenges we face in the public sector are also about data circulation between ministries to break all the silos we can observe in our very complex organizations, and also how to make better use of data when it comes to really define and conduct public policies in many, many different sectors. There are 3 things I would like to share, which are our main objectives. One is quality, the second is openness, and the third is protection and sovereignty, and is a follow-up to the previous discussion you were having on GAIA-X and cloud and other issues. But before to go on quality, openness, and sovereignty, maybe 2 quick words on why we've really increased our ambition in 2021. It's not very complex to say that data is everywhere, that the crisis, COVID crisis, because of the new way we work, the new way we interact, also put more and more digital and data at the center of our lives. But we cannot imagine a society where all the public, cultural, education activities are more and more digital, and the public and administrative life is detached from this movement. We've seen also that during the crisis, opening data, sharing public data was key to restore trust, key to be efficient, key to be able to take decisions which were pertinent and effective. And the Prime Minister, therefore, in this context, gave a very new and strong impetus to public policy on data in 2021. And as a follow-up of this work that was undertaken by all the ministries, I announced and published 15 ambitious roadmaps, one for each ministry, for the opening up, the circulation, and the use of data. This is concretely 500 different actions that will be taken and implemented in the next 18 to 24 months in all the ministries by all the sectors of public action. It will go to opening up 70 public data sets, which were not open yet, but also, and I will come back to this, really increasing our capacity to interact with civil society, with companies, with citizens, and using data also as a new mean to build our public action. If we then start with quality, as I said, it was my first priority. Here, the question, the issue at stake, is to reinvent the relationship between administrations and their users, being them citizens or companies, and to do so by increasing and better using data that circulates. Today, we know that 75% of the relationship between a French and the administration is digital. It is a website, it is an app, it is an email, So the face now of public service, and I think it's the case in probably all European countries, the face of public service is data-driven and is digital. But to be then responding to the expectations of citizens, we must be sure that the quality of the data experience, of the digital experience, is at least comparable to what we experience when we book a travel, call a company service for a delivery. So we have to make sure that the quality is at the level of what we know outside of public actions. So the challenge we have is not only to dematerialize, is not to go to zero paper, it's really to digitalize and to use data at the heart of the public policies we conduct, with one first objective is to individualize. Make sure we can, because we know things about people, not because we are a big brother society, but because citizens give us a lot of data, we are able to really make their lives simple and to have a public service which adapts to everyone. We've undertaken in 2018 a major reform regarding our tax system. Now French pay taxes on their paycheck directly every month. It was not built in that way before, but the way we reformed made us able last year in 2020 to have 12 million French households who didn't have to fill any form for the taxes. They were pre-filled and they were automatically established without any individual and personal intervention. We have an outcome which I want to share, 80% of satisfaction. Okay, we are a country where we pay taxes like everywhere, maybe a bit more even than other countries, but the quality of the service really was a key factor of trust between citizens who pay taxes and the state. Other than quality, other improvements in quality can be coming out of this reform, because we connect now the tax data we have on the income every French has in every month of its professional life or as a retiree, we can pre-fill and pre-detect if you are eligible to certain social support, to legal aid, to pay your lawyer if you are a low-income person and needing the support of a lawyer. Again, without any procedure, without any filling of any form, being it on a paper or on a screen. We also now have a tool which is France Connect. France Connect is our EID public identification system used by 32 million French now. And we're now connecting every local authorities for them also to identify with France Connect. And by doing so, being able to pre-fill with data on tax, on family condition, on all the data that we collect as the state, also to support and modernize the procedures done by local authorities. And it can go to the price of the food you pay at the municipal school, to the subscription to a library or book service managed by a city, and so ever. So it's really data at the heart of daily life procedures that the French know very well and can be very burdensome, that we now derived from our tax reform. Second element in terms of quality is that we have now the plan to have a system that can pre-warn you of procedures that you will have to do because your ID card needs to be renewed, because we detected that you are now a retiree person and that some things are opened for you, but you might not know about them. And sometimes even suppress procedures by having them going totally automatic. In the current movement of increase of price for energy and fuel, we are now having a system where we support a certain number of households, 5 million of them, through direct detection of who they are, what is the condition, and how we can support. I know that this proactive administration is also part of the contract of the new German coalition, and I think it's a very interesting topic on how we think public service in the era of data. That was my first point, quality. The second point I want to mention briefly, but I think is extremely strategic, is openness. As you mentioned, France has been leading the way on the open data strategy. Open data is not about data. Open data is about trust, is about democracy, is about the relationship we can also build with other actors than ourselves, between ministries and between the public silos we might know. Open data is what, for me, is essential to put in the debate so as we can restore trust, increase transparency, and we know that about vaccines and all the COVID environments, how we make sure that we can also give feedback to the citizens on what we do, what are the sources of our knowledge, how we take decisions, and why we take these decisions. We have, with President Macron, published in January 2021, a very innovative way to give feedback to the citizens of what we do, where they live, and we give on 40 priority policy action on jobs creation, on health, on education, on transportation, on all the issues you can imagine, which are at the core of the commitments the President Macron took in 1917. We now are able to give on a quarterly basis, county by county, at the scale of each of our départements. You know, we have 100 of them that are splitting up the territory, on what has happened since 2017 and what we aim at doing, so now in 2022, but to show to the people how we make progress, but also to give transparency on issues where we are not at the level we want to be, and to restore trust in giving feedback. On these roadmaps I mentioned to you on what the ministries will also do, we are now opening up data related to the protection of the population, on road safety, on the fight against drugs. We're also opening up all our research funding to give real access to the citizens, to everybody who wants, which laboratories we are funding, with which amounts, how it's complemented by European funds, and so on. We're also opening up the code, the source code of many of our algorithms, typically the one that put the pupils from the 9th grade to the high schools, for parents to know and experts to explain to parents how the algorithm is built. On this openness, I think the transparency is also essential when it comes to the digital action of the state. So openness on the openness strategy in a way. In that direction, I've also announced very recently a fully revamped ambition on free and open source software in administration. Again, France has been leading the way historically on the use of free and open source softwares in the public sector. In the recovery plan and the European funding that we are developing and deploying in the country, most of the budgets are deployed using free and open source softwares in our ministries and in local authorities. And we also now are working on a bill with our data protection authority, the CNIL, to have a real-time transparency on the data which are shared between administration. Because we had before a very legal approach to know what was authorized in terms of data circulation. Now we will give access to this CNIL, Data Protection Authority, to the actual nature of data circulating and how we are really using data, and not only how we are allowed to use data. And I also launched on Monday a new tool, which the name is Mon France Connect, so My France Connect, that allows citizens to know the data we have on them and to make sure they are accurate, and for them also to have transparency on what we collect and detain. Finally, this openness is also a key condition to work with civil society to enlarge the sphere of those who contribute to the general interest. As I often said, the state has not the monopoly on the general interest, and data is the key factor to make sure we can have partners and we can expand the number of people, type of people, and actors who can support the transformation of public action. Coming now to my last point, we cannot imagine data and digital transformation for the states without thinking about data protection and sovereignty. I think GDPR is an extremely important strategic move. In France, you know, we had as early as 1978 a Data Protection Act. It provided us a culture of data protection, but I think it's very good that now we have a European common framework to also think and create also markets for companies that can respect our values and expand their own activities. Data portability, you were mentioning this before, is, we know, still small compared to what the GDPR allows. And this is why we also recently improved and increased the resources and the positions inside our French Data Protection Authority, because we want to make sure that the balance is kept between how we protect data, but how also we take benefit from this data to respond to challenges in our societies. We also see that data protection is important, and even more important now in terms of COVID. We have had many debates on health data, but I think what we are now working at the European level with the Data Governance Act, with the Data Act, are topics on which we must be very ambitious, very concrete, and be also in terms of training, in education, in how we make European citizens understand what are the goals we pursue, and not just make these debates experts debate. For me, it's very important. And on this sovereignty and protection, for me, a key question is how the choices we make today, choices of hosting of data, cloud providers, algorithms we develop, can be reversible. Not only portable between actors, but reversible. I think at the heart of democracy, there is this idea that an elected government can undo democratically what previous governments have done. And thinking this reversibility of our technological and data choices is absolutely, for me, essential. This is why we have to be clear on the technologies we use, the technologies we buy, that we have a systematic and permanent control over data, that we have to have very strict rules to protect ourselves against extraterritoriality. When it comes to data hosting, this is why in France we now have a doctrine on cloud use. So cloud is the default option of the development of all our projects when it comes to data, but the cloud hosting is internal to the state, or when it's external, we have designed rules which are both cyber crash test rules, technical ones, but also legal ones, to make sure that data given to a public actor in France cannot go to any data servers of any intelligence service on the west of the Atlantic or at the east of our continent. And we have to have this trust established at the heart of our choices. So to sum up, we're investing massively because of the recovery plan to transform, to accelerate on cyber, on data circulation, on data use, on technology and infrastructure. But the key words for me are quality. It must really respond to the need of people in a simple way. It has to be open because we are public actors and we are not companies. And I think even companies can rebuild trust with their own customers by opening up sources, software, codes, and data. And we have to be very strong and strict on sovereignty and data protection. And here is my commitment also during the French presidency, which is coming, to make sure that on these data protection and sovereignty, we can build a European vision on how public actors throughout the continent can have common guidelines So as our European companies can not only sell solutions in France with the French legal framework, in Germany with the German legal framework, but can expand their markets and really build these European unicorns that we are so much all expecting to have partners and providers that respect our values and the legal vision we have on how the societies can work. This is the key elements I was willing to share with you, and thank you again for inviting me.
Dear Emily, it was really great overview. You touch upon not only open data, but the whole area of issues in the European context. As you know, we are discussing tomorrow Gaia X. There is some interesting development, unfortunately, with Scaleway, the French provider that we are going to discuss tomorrow. But what matters today were your statements really regarding the whole spectrum of the digital landscape in France and your view of open data not as a data, but as a democratic issue. So, in that respect, we have Markus Richter. Dear State Secretary, please join us. He is also the federal CEO of the German, on the floor? Yeah, yes. He's also the federal CEO of the German government. As you know, we have adopted the second open data law not last year, but a couple of months ago. That was one of the measures already implemented in the part of the data strategy of the current government, but we know how difficult was it. I remember one sentence a couple of years ago when the UK cabinet office chef was in our foundation. He said, like, he had a message to the German government. He said something like, there is no governmental data, there is only data that is in possession of government. So I would like to congratulate for the new spirit that you brought in the public administration with your work, with your approach, and we are really glad to listen to you. What can we expect in the coming months, in the coming period? As we know, the new government also has some promising stuff when it comes to open data. Yeah, the floor is yours.
Absolutely. Thank you very much. And first of all, thank you to Amelie, because it's always a pleasure to listen to you. And at the same time, it's not just the two of us who are in an exchange, it's our teams. And it's great to learn from each other. There were exchange, for instance, on the question on how to improve dashboards so that decision makers within the public administration can have tools which they put them into a position to really do this data-driven decisions in a more easy way. So thank you very much for this open cooperation, because that's what needed when it comes to open data. We are talking not only about one branch or one ministry in Germany. We are talking about Europe in the end. We are talking about the question on how to improve life for people. So everyone is talking in these days of a booster vaccination. In the end, open data is the booster to make happening the digitization, especially in the public administration. Because when we achieve that the business sides within the public administration sees themselves as the ones who are responsible for using data, for making data accessible, then we are really moving forward and having this kind of booster also by digitization. Everyone tells in these days also that we have a real push through COVID in the field of digitization. I'm not that sure. Yes, indeed, we are doing video conferences and other stuff, and I think for many people it's now easier to understand for what purpose we are doing all of this. But in the end, we will have a real push when we achieve to make open data happening. And indeed, there were just recently in Germany some major steps forward. I don't want to link to the ranking of the EU. I mean, Germany was formerly at the place of 13. Now it's on the place of 8. So a little bit forward the direction, but we are still not there where we want to be. And I think everyone is clear on this. So therefore, I think it's the right step that we undertook with the Open Data Act here in Germany to make more fields of data accessible for open data, like research data, but also to make clear that open data by default is not just a sentence, it's really hard work to make this happening. And also this is a part of the act. And if I see also the question on how to really make it happening, we are talking there about real hard work, and therefore I think it's also the right access that we implement right now open data coordinators in every agency, and that we've got a federal administration agency which is a kind of a competence center for all these activities. So we really have to make an operation to make all these things now happening. And we have also just recently launched a open data strategy. And of course, also this is just a first step, but we have to undertake more action, and we have to be more faster to implement these activities which are now based on these fields. I'm glad that the new government took up really these initiatives, and they are planning to implement a claim that puts actors into the position to go to court if data is not provided in a way that it can be used as open data. Of course, we are addressing with this also the data protection issue. Amelie just mentioned it. I think it's mostly important to make clear about what we are talking here. Even if open data is linked together, and if we try to receive new insights out of these open data, it's still a kind of data which is not directly related to individuals. So this is, I think, something we have to make clear. And let me maybe do the last point by saying what is the purpose? I mean, there are now many new tools on the way. As I mentioned, the dashboard, which was created by the Federal Data Agency called Germany Dashboard. This one makes visible across several branches what can be achieved by open data. There are great examples if we see, for instance, small things like an accident survey, so that cities can see, oh, where do we have in our city hotspots of car accidents, and how can we improve these systems? All of these informations were received out of the open data, and therefore it's really about helping people, helping the economy, making research better, and especially making the decision processes within the public administration faster and more efficient, because the world is getting complexer, and still, especially in crisis, but also out of crisis situations, we have to be faster by making decisions and keep the quality of these decisions great. And therefore, I think it's important that we implement more open data, make it machine readable, and having a transparency. And therefore, I'm also thankful for France that we cooperate in these fields and bring these open data together. And my vision is really to create in Europe a data lake, especially maybe also for the public administration, because many of the big challenges of our times will be only solved if we have best access to data across Europe and maybe abroad, because I think in the end we are all standing together. So thank you very much, and I'm really looking forward now I think we all do, for the new government. It's great that they took up many of these initiatives, and that there will be also a data institute which will also help by making all these different aspects come together, to link them together. And I think it's the right way, it's the right time, and we have to be pretty fast.
Many thanks. Please take your seat, dear Markus. Indeed, the Konrad-Adenauer Foundation issued many times political recommendation when it comes to Open Data Institute and a claim for open data, because we truly believe that it will make the difference. You are addressing, you and Emily, the issue of leadership. Actually, I would like to say that open data is a matter of leadership. When the message comes from the top, then open data works. Otherwise, it doesn't function. Dear Emily, you have mentioned that I hope I have understood you right, that about 75% of your digital services are digitized. Does it mean that also 75% of your decisions are data-driven?
So there are many percentages on which we can talk. Indeed, we have taken the commitment to digitalize 100% of the 250 most common administrative procedures that the French do on their daily lives, if they are citizens or if they are companies. This commitment of the 100% is at the end of the mandate of President Macron, so we still have 7 months to go. And at the moment, when I'm speaking to you now, we are around 86%. So we are on track to have put on digital the most frequent and commonly used procedures of French in the administrative life. We have invested a lot to make sure that all people, if they are having disabilities, whatever type of disability, can also use these digital tools. It's a major investment. I think we are not so many countries investing on this inclusiveness of the digital tools for disabled people. And I will finish now the year, we will finish the year with around half of our digital procedures being also open and accessible to all people, whatever the disability, if they have one. In this idea, indeed, because it's digital, it can then improve the public policy behind the procedure. This is where these roadmaps of every ministry is absolutely essential, because if I'm speaking a bit in a way which is a bit simple, but administrations today have treasuries of data. We are opening up a lot of this data, but we are not exploiting data always in a way to really make our public policies functioning, performing, and addressing issues better. So this is the next step. But indeed, with France Connect, this ID, sovereign ID, public ID used by 32 million French, we are now more and more using data in the heart of public policies. And I can give you the commitment that in 5 years now on, in 2027, I'm sure we will have solved a huge number of small problems, but which become big problems because of the knowledge we are now having.
5 years is a realistic term, and we will follow you, definitely. But what about the situation in Germany? How far are we from a data-driven government, or how close?
Well, my point of view is that we undertook quite efforts now, and we undertake great efforts to improve it, because we are not there where we want to be. I think it's mostly important to see that we want to digitize all our public services by the end of next year. I know it's quite ambitious. The federal level will achieve this, but the question is how do we scale all these services within Germany? And behind all these services, there are of course coming more and more data together, and it's the question about transparency. so that we have transparency and could be in the position to predict developments out of these data. And secondly, how the business sides within the public administration really use these information for better decision. And this roadmap is the basic for implement also open data really for a purpose within the public administration. And that's our aim. That's what we are working right now on. And I think we did great step that we have now this open data strategy. I know we have to improve it further. We have to say more clear which really steps are within the strategy, because a strategy is always a framework where we're working within, and we have to be a little bit more ambitious. But I'm really grateful that there are now so many actors coming together on the federal level, the states, and we are working on this together. And therefore, it's really about the question to have also the infrastructure coming up, what we are right now working on, because you always have to have also kind of a marketplace which should be linked to other ones within Europe, as I said, and at the same time to have a standard for the open data, so that it's really machine readable. And all these activities are a part of this strategy, of this action plan. And as I said, it's great to see that now with the new government there is coming a further push through governance, because all of what we are talking here are at many points really governance questions. How do we organize this process? And it's a question of cultural change, because it's not possible anymore in many fields to do the work as we were used to it. There's so much data available, so much information. No one is in the position to read all of this. There should be machine readable, there should be tools to assist, and therefore I think it's the right access, and to also improve our agencies in this direction. Yeah, that's what we are working on.
You have both mentioned the COVID crisis, and you said it could be a booster, but it's not a real booster yet. In the context of the COVID crisis, we had the discussion, you remember last year, regarding the use of personal data. And I told the digital minister of Taiwan that I'm going to ask you this question, that I asked also her. And that is, do we need a socially functioning compromise between personal data on the one hand and innovations and public interest on the other hand? Emily, maybe you would start?
Yes. I think that opposing protection on the one end and sharing and openness on the other is a risk. And for me, it's not the right balance. I think we should find, I don't know if it's a compromise, but we need to show how we can use and really use data in a efficient and serving way, because sometimes we lack concreteness in these debates. When I want to help a very old woman having a very low pension to give her access to a social support aid that exists, well, I need to use personal data on her, but not to track her, not to control her, but to support. So I think the idea in GDPR is, what is the purpose you are looking at to use and collect and retain data? In the public sector, I think we have to be very clear to find the conditions under which we can use really data to really respect protection and privacy, but to serve public goals that democratically were voted and are seen as legitimate goals. This is for me the real question. It's not about data, it's about the objective we pursue and the means we give ourselves to really, in a way, achieve what we say to the people we will do. And this is for me, the most important question. Then we have lots of possibilities. We have pseudonymization, we have aggregation, we have anonymization. We can notify people, say, do you agree that, if we think it's a bit touchy. So I think the technical options exist, but for me, the key question at the moment is, are we clear that given the tools now that technology offers to us, can we better serve people in the way members of parliament and ministers make promises to the people and take commitments? And for me, this is at the heart of the trust or the mistrust we have now in our societies, because people are not foolish. They listen to us, they see the outcome, and they realize that probably we can do better. And we can also do better thanks to technologies and data, that we have to make very transparent how we do it, what we know about them, why we cross data, and what is the objective to pursue.
So trust matters when it comes to this issue. By the way, closely related issue to this issue is the issue of business to government data sharing, and I'm glad that we have a perfect collaboration with Simon Gignard from ETALab, who is really regularly attending the European Data Summit, and we have learned a lot from him. But Marcus, what do you think about this compromise? Is it a difficult issue, or are we on the wrong track?
Well, first of all, let me make it clear that when we talk about open data, then open data per definition, there we are talking about data which is not directly linked to an identity of a single person. But I think we in Germany have to undertake more discussions about the value of data. We see it in many cases when we talk about the Corona warning app, for instance, which we implemented here, or also when we look what kind of data are shared from individuals with the public administration to receive services. I think we should have a discussion, a cultural discussion in Germany, first of all about the question, what is the purpose of digitization? I think we have a great common sense there in Europe, because we just recently launched and decided all together on a Berlin Declaration, which puts the values into the center. So the purpose is important, and to have a discussion about digital first. I think we are moving now really good forward with the digitization of public administration, and there will be more and more services available in the digital way. And I think to have a discussion about should this digital way should be the first one, the prioritized one, and should the other one maybe cost a little bit more because there are more people involved to work on this, is an important discussion which will come up in Germany. And a part of this is also the question, how do we deal with data and for what purpose? I think transparency is there the key word. Amelie just mentioned a cockpit. We are also implementing a cockpit right now regarding the question of one-stop government, so that people know and can see on their mobile device where is my data stored and who is having access to this. And we will improve then the system so that people have the possibility to also agree on the data use through, for instance, public agencies for a specific topic. And I think, therefore, transparency is the basis for acceptance, and I'm pretty sure we are moving now forward in the digitization, and there will be this discussion, and I think we need it in Germany, and to make clear for what purpose and under which circumstances we collect data to improve the system.
Are there any?
If I may, maybe just have a
sure. I would like to make the notice that there is also possibility for a question from the audience. So if you want to ask the minister something, please let me know. Please, Emily.
There is a very interesting parallel with the discussion we're now having. citizens in all European countries during many, many years filled paper forms on which they were giving a lot of information. But as it was papers, it was seen as, you know, bureaucracy doing its work, and people were giving a lot of data. But people had the impression it was going to one person, to one then a big paper form archive system, and that it was fine. The parallel I want to make is, because it's digital, now people reflect a bit more. Do I really want to give this information? How is this going to be stored? Who will have access to it? Can it be reused in many, many years? That's the new debate emerging, and I think the corona crisis, in a way, because all our lives became more or less digital for a while, people realized this exchange of knowledge, which was not based anymore on paper, but on digital. The parallel I want to make is hate speech on social media. We now tolerate on our social media anti-Semitic, racist, extremely violent content that if it were on a newspaper, on the walls on our cities, in the tube or whatever, people would be extremely shocked. So there is a strange sense of things that were seen as normal in a non-digital world now as raise questions, which are legitimate ones we have to answer, and this was a discussion of data. But there are also things that were not seen as normal in a non-digital world that are now tolerated in the digital sphere. So I think we have to be very clear on the new debates emerging, but also to be very clear on we cannot tolerate that because it's digital, it's less important and it's more tolerable. And I think it's an interesting parallel that we can here think about.
Thank you. We have one question, I believe, from the audience. Please, Lucas.
Yes, thank you very much. My question touches upon the actual implementation of the open data strategy. So it would be, how would you actually implement it, and which role would take the states, so in Germany the Bundesländer, or in France the Département, and which role does the federal government take? So how are the competencies distributed, or who's actually responsible for implementing the strategy? And then for the citizens, would the services differ, for example, from state to state, or is it a unified service that would be offered in all over Germany, or what are the approaches in that sense?
Please.
Yeah, thank you for the question. The strategy in Germany is a federal one, so it's the one which addresses in the first step the federal ministries and agencies, and these are the actions which are within it. We have within the strategy this competence center linked at or located at the federal Office of Public Administration, which is located in Köln. And then we've got these coordinators, which are just, we implement them right now within all agencies on the federal level. And through this, we get a real task force to make it happening, because there are obligations. There are already obligations, but let me say it like this, I'm not sure if everyone is aware of this, and therefore I think we have to work on this. And of course, there is a link to the states within Germany, because it's important, of course, that we are not only working on islands, we have to work closer together, and therefore I'm happy we are in an exchange with the CIOs of the Länder, of the states, and to also link together the actions which are there. I think we need a framework and which is then enforceable for everyone. So when the new coalitions now implement such a claim possibility, then this is something which not only addresses the federal level, of course, but also the states and actually every agency, and therefore we need this common action plan, which we should elaborate on the basis of the coalition contract, which is now on the table.
Many thanks. Dear Emily, Would you like
Yes,
to comment on this?
so in France, we have a very simple law article saying that every administrative structure, being it a city, a department, a region, or whatever you want, a ministry or a state, if it covers more than 3,500 inhabitants, this structure, whatever its size, has to publish in open data a quite infinite list of things that can be published in an aggregated manner, because indeed, as Marcus reminded very clearly, we're not publishing individual data, we're publishing outcome data, aggregated data. But to be very clear with you, not all the cities of 4,000 inhabitants in France are putting all the data they should or they could open. So we're now, and this law has been voted in 2016. We have now a quite diverse situation. Many collectivities, local authorities have implemented this move, others not yet. We are investing, giving money for them to speed up, and so that's for the local authority part, and for the governance at the federal, so in France, the national level, as we say. We have now chief data officers in every ministry. We have a governance on open data which is very strong, very clear. We have norms on how data should be published. So as Marcus was saying, they can be machine readable. We have also frequencies on which we need to update a certain number of data sets for also businesses or civil society to use them on a trusted manner. So France has been on open data working now for more than 10 years, very actively, and we've learned. We had some failures, we now have some successes, but yes, we are pushing all local authorities above 3,500 inhabitants to publish data, and we have lots of networks helping these smaller entities to achieve these objectives.
Many thanks. As we know, open data is a costly issue. It costs money as well. And I think the debate a couple of years ago, claiming open by default, create also a bit damage in the public administration. And now we move more in direction publishing with purpose. What do you think regarding this?
Well, actually, everything what we are doing in the end costs also money. But I think we have to make clear that when it comes to public sector, it's not in the first step a question of how can we improve the system that we save the most of money. What we are talking about is making the life of people better and the life of economy better. And therefore, it's an obligation to use the information which are available to make the decision-driven process more quickly and having out of them results which are out of the quality which we need for good decisions. And therefore, yes, I'm convinced we will save money by the end. And it's hard to predict how much it will be and how it will be. And I think this is not the first question. The first one is, how can we make in this complex world decision-making processes quicker and faster and having good results out of it. This is what we are dealing with. And therefore, I can say that all these people who are dealing with this, we need more people who are able to deal with it. We are implementing now these coordinators. We need also education of the staff members within the public administration. And all this costs money, is an investment, but in the end, there is a purpose. And I think we have to be open to these arguments and to be also transparent and clear about that there is money needed to do all of this. And in the end, it's not just one direction, that within the public administration we create data and we receive them, then out of them open data. It's also about the question, how do we use data which is there available by companies, also for the public administration. So there is a big exchange, and also, of course, with the academia. So we have to really identify these sources of data and to make them accessible through standards, and then to share these informations. And I think everyone is clear on this, that this is also an investment.
Back to my question, so you have nothing against open by default?
Absolutely. Open by default is the key issue within the strategy and the Open Data Act. So this is a big shift within the culture. We say everything in the first step should be open data. There might be acceptance in specific areas, but you have to argue why these shouldn't be open data. So open by default is a very important principle.
Many thanks. Having in mind the time, Emily, you can comment also on this issue as well, but maybe something what's really more interesting to us is we have, like, in 4 weeks the French presidency. Could you tell us maybe what can we expect in the field of digital sphere? Or I'm asking too much.
Just coming back on the point before, in one line, since 1789, I'm lost, with the French Revolution. So since then, with the Declaration of the Rights of the Human Rights and the rights of citizens in France, Déclaration des droits de l'homme et du citoyen, the Article 15 states that every citizen can ask for feedback and transparency to the state. So it's a long-lasting process, and I think the cost of doing it is very small compared to the efficiency it creates, as Marcus was saying, but also in the cultural shift it puts in the hands of those in charge of public action. We need to give feedback. We cannot do things without making sure that citizens can both understand what we do and know how we do it. So for me, it's a big HR cultural fight, and the cost of, yes, putting data out is very small compared to the cost of not doing it in the indirect manner. So what we will do, what is the objective we have for the French presidency in the field of digital and digital in the public area? There are 3 main topics for me which are very important and which we can make progress at a European scale. One is mobility in the civil service between member states, including when it comes to our tech, data, and digital men and women, and I insist on the and women, because we also need to make sure that the whole society in its diversity is also included in the way we build data and digital services. So we are now, as you may know, in France, conducting a very profound reform on our top civil servant system to make it more attractive, more connected to the issues of the 21st century, more efficient. And in that area, we have built with the Portuguese presidency, another Slovenian one, and I want to thank Marcus Richter to the openness also he signaled to make sure that our teams can learn by each other, can spend time in other capitals in Europe, and that we learn by human exchanges and not just signing papers together on commitments we want to act together. Second priority is how we can share technology, tools, code, open software, all the things we do. We have each of us weaknesses and strengths, and if we can mutualize our strength and make our successes be also helping others to accelerate, we have to move really in that direction. We have now a small group of 10 countries, more or less, the coalition of the willing, where we try to have our teams and ministries giving access to the neighbors. We are all together to things that work in our countries, and when it's free and open source software, it's easy. Third objective is the transparency. What we mentioned just now, particularly on how we conduct reforms and how we can, all of us, have tools and not dashboards just for the internal use, but also tools that can give feedback to the citizens on what we do. We had discussion with the European Commission, with also European institutions on how this barometer, as I described to you, where in France we give on a quarterly basis the actual vision on what we produce in every department for every citizen, how we can expand this view to other countries and also European policies. These are three objectives which are, I think, things we can do and not, reaching too far, but things we can achieve and give concrete outcome to European citizens.
Many thanks. Dear Marcus, do you have some final remarks?
No, I just can say it's really interesting. Maybe I can say something to France.
Sure.
Because I learned a way on how organize governance, and it's quite impressive. Amelie told me once that she's got a survey, what's going on within the departements. And then she's visiting also the departements and see what is doing well, for instance, in the field of digitization, and what is not working so well and why. And out of this transparency to see where are the states standing, this is also quite interesting, I think, for Germany. I know we've got responsibilities on the federal level, on the states, in the cities, but in the end, everything has to fit together, and we've got common contracts within Germany, and to make this visible and to create more transparency where we are standing, it's really quite an interesting instrument. So thank you for the insights there.
Dear Amelie, we wish you lots of success for the French presidency. We are really happy that we had the conversation with you virtually. I know that you have met with Marcus a month ago, but we thought it would be a nice opportunity to discuss open data before the French presidency again. Many thanks for that. We wish you a lot of success in implementing the open data strategy, and we are here to support you in your work. Many thanks.
Thank you.
Vielen Dank. Tschüss.
Ich hoffe, es hat Ladies and gentlemen, welcome back to the European Data Summit after the break. We have a great pleasure to have someone representing the global industry. Gary Davis. Gary Davis is Apple's Global Director of Privacy and Data Protection Officer. He will talk to Apple's general approach to privacy and data protection and how it relates to current debates. This includes the issues of user tracking and giving users ways to better control and manage access to their data. He'll try to explain to us why collaboration between or within industry, but also policymakers, is important to further raising the bar for privacy in Europe. Dear Gary, are you with us? Nice to see you. Hello.
Hi, Joe. Hopefully you can in fact hear me. Good afternoon from Laois in Ireland. And it is a real pleasure to join you all. And thank you very much for giving me the opportunity to speak. As you indicated, I'm Gary Davis, and I'm Apple's European Head of Privacy. I have noted on the program that my fellow Irishman, Johnny Ryan, will take the floor after me.
Exactly.
So we Irish are certainly monopolizing your time today, I must say.
We don't have any conflict in monopolizing Irish speakers. So, but,
well, that's okay.
But we are really glad that you're with us. You have nice weather, I see, in Dublin, much better than I think in Berlin. And yes, please, the floor is yours, the virtual floor.
Great, thank you very much, and thank you for providing this virtual floor from me. I also see that Johnny will be joined by Carolina from the European Commission, and I do think that their topic on real-time bidding is certainly of interest to us all. And in many respects, I'm somewhat foreshadowing their session. I'm very much looking forward to it. Our joint work to protect and strengthen privacy could not be more important. Because the reality for many people today is it's still very difficult to keep your personal data under your own control. We all face constant pressure from trackers, data brokers, and other businesses that look to exploit personal data and other online activity, very often without the user ever knowing. This is something that our CEO, Tim Cook, has called the data industrial complex. Whether it's the government, business, or those of us in the data protection community, it is something that we must all do our part to counter and remain vigilant. Now, in Apple's case, we start from a position that privacy is a fundamental human right. That's kind of an easy thing to say, but for us, it's not just a matter of compliance or staying on the right side of regulations. It's about doing the right thing. And that means designing privacy into our products from the very start. In fact, something that all tech companies can and should do. Indeed, governments could and should also be doing it when they seek to collect data, which I know is a focus of sessions here today in terms of how to operationalize the Data Governance Act. Our culture in Apple is built around creating the kinds of products we want for ourselves, for our friends, and for our families. As individuals, we all want our privacy respected, don't we? And so Apple wants the same for every customer. And our work is guided by 4 key principles that I think it is useful to run through quickly. First, we always start by seeking to minimize data collection. I think we can all agree that collecting data that you don't need or don't currently have a purpose for, on the basis that you might have a purpose for it in the future, is dangerous, no matter who's collecting it. And importantly, we see ourselves in no different light in this respect. We believe Apple should have as little data about our customers as possible to provide our services. Second, to avoid the risks that can arise from moving data off of your device, Apple processes as much of your data on your device as possible. Data that stays on your own device is data that you can control. It's kind of a simple principle, in fact. Third, when we seek to use your data, we make that transparent and we help you control how it's used. And finally, we make sure our hardware and software are secure. If your data isn't secure, it's not going to stay private. And so this is fundamental to ensuring our privacy protections. If you take, for instance, the design of iPhone, we've always known this would be an incredibly personal electronic device. Today, we plan our lives using this technology, whether it is speaking to loved ones, getting directions to your medical appointment, or understanding if you might be stuck in traffic while taking the children to school, if you cannot walk there, of course. Given the iPhone's potential to enhance different aspects of our lives, we knew it would need to have the strongest possible security and privacy protections. That is why, for instance, iMessage and FaceTime were built with end-to-end encryption. I'll just return to that in a few minutes also. It is why our Maps app does not collect your personal data at all. So Apple, and therefore no one else, can have a history of where you have been while using the app. It is why we do not allow apps to know your location without your explicit say-so. And even then, we make sure you have granular choices. Our focus on privacy and security protections are not just for our devices, but for all parts of the Apple ecosystem, including apps available via our App Store. On the App Store, apps come from known developers who have agreed to follow our guidelines on things like privacy and are securely distributed to users to minimize interference from malicious third parties. A secure experience is, in our view, undoubtedly a more private one. We are constantly focused on the 4 key pillars that I outlined earlier, but the reality is the threats are always there and forever evolving. Take the issue of tracking, which Johnny will, I'm sure, add real color to. In many respects, one would expect people to be even more exercised over what has been going on. Perhaps the sector is almost too complex for a real understanding to emerge. And until recently, we relied heavily upon people like Johnny to lift the veil. His work does continue to be extremely valuable for us all, of course. We, of course, first introduced blocking of third-party cookies in our web browser Safari as long ago as 2003, so nearly 20 years at this point. Since then, we have constantly introduced advancements to Safari, including intelligent tracking prevention to detect and block covert tracking on the web. This year, we have brought in the latest phase of tracking prevention with app tracking transparency, giving users the power to ask apps not to share their data across companies' apps or websites for advertising purposes or sharing with data brokers. With every new privacy innovation around tracking, we hear the argument that a particular privacy feature will fatally damage online advertising or otherwise harm the user. Yet, the industry seems to adapt to provide great advertising in less intrusive ways while the user gets more control and more privacy. This is not about stopping advertising, but about giving users a choice. In all of these cases, I think it's important to point out that we've taken these actions not to respond to a specific law or legal obligation, but instead because it is simply the right thing to do for our users. I do also want to say that sometimes we can perhaps focus only on those who noisily oppose our efforts to empower users and try to distract from those efforts because they wish to maintain the status quo. But it is important to recognize that many advertisers and developers immediately embraced the app tracking transparency framework, as they also saw that we all benefit from increasing the trust of our users by giving them the choice as to how they wish for their data to be used, because that's what it's all about at the end of the day. I applaud them for doing so, as we have a joint responsibility in industry to show leadership in this space and build trust and not take actions that erode it. But our work is by no means done. In September, we shipped our latest operating system for iPhone, iOS 15. And we again have included new strong privacy protections which help users better control and manage access to their data. They include mail privacy protection, which allows users to choose to stop senders from using tracking pixels to collect information about them in emails, on-device speech recognition for Siri requests, as well as iCloud Private Relay, a new internet privacy service, allowing users to connect to and browse the web in a more secure and private way. Again, some have sought to oppose these efforts because in some cases it means they will no longer get access to data that they have perhaps taken for granted. Now, they will have to ask users what the user wants, and perhaps they were taking the views of those users for granted up until now. Looking forward, we have an exciting future update to iOS 15, which will contain our new app privacy report. This is something we've been looking forward to for some time, and many have been looking for us to innovate on. This report will allow users to see at a glance what their apps have been up to. A section in settings will show users how often their location, photos, camera, microphones, and contacts, and so on, have been accessed during the previous 7 days. It also crucially reveals which domains apps have contacted from their devices. So it will provide our users with a deep insight into how often an app is accessing data to which they have granted permission and more. This builds upon our privacy nutrition labels, something we were talking about around about this time last year when we launched it. The labels give users access to developers' self-reported summaries of their privacy practices in an easy-to-read label. This shows how developers are collecting and using your data, including information again like your location, browsing history and contacts, and many more categories, including analytics. This is all part of our ongoing focus to increase transparency and control over user data. But we understand that privacy is not something that you can take a break from. You certainly cannot stand still. We have seen that with the updates we've been making to Safari since 2003 and all the recent announcements we've made. We feel we have a responsibility to continue to innovate in this space through building new measures to deal with the challenges users are facing in today's world. We know our actions can help lead change. We fully understand that. With privacy nutrition labels, we have seen apps in fact compete on privacy for the first time ever. We saw this happening almost immediately with messaging apps and email apps, for instance, using their nutrition labels on the App Store to present simple, clear, side-by-side comparisons to users so users could easily assess for themselves the different practices of apps. No longer did the user need to try to pore through a privacy policy to work out what those practices were. They could actually see immediately what data was being collected by one app as compared to another one. And it was very interesting to see apps immediately respond to that. And that kind of action lifts all boats and raises standards for everybody. And of course, we welcome the fact that others are now following our lead in this area by announcing similar initiatives. We all benefit by working together and setting the highest standards for ourselves and by competing on privacy. I know that preparing for competition is in fact the overall theme of this conference, and so competing on privacy should certainly be a part of that as we think about it. Our experience with introducing all of these features has taught us that it is a false narrative to argue that there is a choice between incredible technology and great privacy. I think it is probably instructive to examine the motives of those who claim that. You can have both. And I think that is a very important point for us all to reflect upon. Introducing more choice and more privacy did not stop us providing even better and more advanced experiences via our devices. Technology does not need vast troves of personal data stitched together across dozens of websites and apps in order to succeed. To raise the bar for privacy across industry, we do all need to continue to work in partnership. That is within the technology sector, but also in collaboration with all of you and wider industry. Germany and the rest of Europe has shown what is possible in terms of building great privacy into law. There's no question that GDPR has truly set a world standard, and we've already called in Apple for similar privacy laws in the US and elsewhere. We also believe such laws could be strengthened further, and we hope the e-privacy regulation will soon be finalized. But we must also be incredibly cautious around any proposals that seek to weaken important privacy protections like end-to-end encryption, for example, in the name of interoperability. In this respect, I was very heartened to see the protection of end-to-end encryption in the Federal Coalition Agreement last week, and we must ensure others understand its importance to privacy too. Business must also play its part to build on that framework in a way that is not just about staying on the right side of regulations, but to challenge itself to innovate on privacy. For Apple, it will always be about delivering great experiences and great privacy, constantly innovating to empower our users. I hope it is something we can all reach for together. And with that, thank you, Pedro.
Dear Gary, thank you for your time. I hope there will be opportunity in near future to have you in person in our academy.
I would love that. Yes.
It would be a pleasure indeed to have a discussion with you. And indeed, competition and privacy is something what we would like to achieve in Europe. And maybe that could be the subject on our next discussion with you. Wish you all the best and many thanks for your time.
Great. Thank you, Pencho. Cheers.
Cheers. So, ladies and gentlemen, we have, I think, 10 minutes till our next keynote by Johnny Ryan and real-time bidding. So I'm using this time to make some organizational remarks. Having in mind the COVID situation, the 2 keynote speakers tomorrow will be only virtually with us. It means Axel Voss and Francesca Bria are going to open the next day only virtually. But we have a full panel when it comes to B2G and when it comes to cloud computing services. And we are really looking forward also to the keynote of Francesco representing the Gaia X association. So I would say we make a small cut here, like 5 minutes, and then we continue with Johnny Ryan and the real-time bidding together again with Carolina from the European Commission. Many thanks.
worse off.
Dear ladies and gentlemen, we apologize for the technical problems, but I think nothing can stop us from telling the story about real-time bidding and the biggest data breach in history. Johnny Ryan has testified in the US Congress telling this story, and he was a week ago in the European Parliament also explaining the story behind. Dear Johnny, the floor is yours.
Thank you, Pencho. Okay, let me get my slides up here. Right, so we should have a big logo appearing on the screen any moment now. And we'll just wait to get started. What I'm going to show you is very visual, so we need to... okay. And the people in the room can't see the slides? Okay. So you will all have to imagine that you're seeing what the people online are seeing. This is the intimate experience you get to enjoy by coming in person. Actually, it might be an idea to turn that screen around. I'll just remove this in case anyone wants to do that. There's a big screen here that could work inside the room perfectly. Okay, so let me start off by saying thank you for having me again today after yesterday. I work for the Irish Council for Civil Liberties, but a few years ago, I had a role inside the online advertising industry, the tracking-based advertising industry. And in that role, I got an insight into how this system works. And the first thing that you need to get familiar with to understand this system is acronyms. So the first acronym of the day is real-time bidding, RTB. Now, I want to play, thank you for doing that. I want to play a hypothetical game with you today where we are all marketers and we're trying to sell something for a brand. So I'm showing you this chart here, and you'll see there's a bunch of acronyms in the chart. And here we have us, the marketer, with our money, and we're going to try to target some people. Now let's imagine, amazing. Let's imagine that we know maybe 10,000 of our customers, and we have data about them. We might have their email addresses. We store that data in a DMP, a data management platform. Now a DMP puts order on the data. Thank you, Pencho. It puts order on the data, and it will also very often say, okay, Johnny, you've got 10,000 email addresses of your customers. Would you like us to talk to some data brokers and find out where they live and what their disposable income is? And of course, I will say, yes, please. So now I've got really good data on these 10,000 people, and I'll also have data about people who are like them. Now we want over here to participate in auctions for people's attention so that we can decide which people we're going to show an ad to. For us to participate in those auctions, which happen billions of times a day, we clearly cannot be present ourselves. So what we're going to do is we're going to pay this company, a DSP, to be our agent at the auction. So the DSP is saying, Johnny, you want to sell these blue wristbands to hipsters. Whoops. You want to sell these blue wristbands to hipsters, and you've got 10,000 of these people. Will you tell us which 10,000 people they are and how much you're willing to spend on them? And so our DSP, our DMP, will give our agent information. Now the DMP is basically a Cambridge Analytica type of company, and the DSP is ready to participate in these auctions. Now along comes Pencho, and unsuspectingly he loads, think of any commercial website or app, pretty much anyone. When he loads it on his browser, for example, on his laptop, in milliseconds, the editorial content that he went to the page to view appears. But the rectangles, which will contain the ad, are still empty. And that's a problem, because we need to fill those rectangles with money to keep the lights on. So the publisher makes what's called an ad request to a supply-side platform. Now, poor Pencho, he's an innocent young man. He does not realize that he's being supplied to a demand, but he's being supplied. Now the publisher, this is a euphemism, the publisher sends a lot of stuff, a lot of stuff, but let's just say cookies, to the SSP. And now we're ready to get on an auction. The supply-side platform, working on behalf of the publisher, packages up information about Pencho, who has just loaded this page, and says, okay, does anyone want to send this guy an ad? Now my clicker has died, or, oh, whoops, I've broken a head there. Or okay, I'm going to jump ahead. So what has happened is the supply-side platform has sent a bid request, a request to companies who might want to show Pencho an ad. It has sent that to at least one auction, probably many. These are called ad exchanges. And each ad exchange sends that bid request on to tens or hundreds or thousands of DSPs. But remember, in our hypothetical company, we're looking for young gentlemen like Pencho who want to buy this amazing wristband. And so we say, that's the guy we were looking for, or he's very like him. So we bid more than anyone else, and our ad is put into that rectangle. Now, Pencho will notice this as he's loading a page. Just for a little tiny moment, an ad will appear, and it might even push the text down. This is all that has happened. And often there's an opportunity for the sneaky DMP here to perform what's called a sync, to learn about Pencho and update its profile about Pencho so that it knows him better next time. Now let's talk about incentives first. All of these cogs, the DMP, the DSP, the ad exchange, the SSP, they represent different bits of the market, the supply, the demand. They are distribution, but also they are very, very often owned by the same company. Even if it's not Google, very often owned by the same firm. So they're all kind of working together, right? It's not very clear where the money's going. Now I'm going to show you this system 3 more times, but much quicker so that you definitely get it. Pencho wakes up in the morning, he visits the Daily Bugle. That was his first mistake. The Daily Bugle wants to figure out what ad to show him, and so it puts out a bid request to at least one ad exchange. Each ad exchange, in this case 4 of them, sends that bid request to 4 or 5 different DSPs, and one of them makes the winning bid for Pencho's attention, and its ad is put onto his browser. Now that's the promise, relevant advertising. The right person, the right time, the right ad, the right context, right everything. But the problem is, we have no idea where the data go. No idea whatsoever where the data go once the information about Pencho is being broadcast. And we can only imagine the kind of crazy stuff Pencho is reading in his private time. So let me give you an example, because this is not abstract. Let's take one DSP, Vectory. Tiny, tiny, tiny company. No one in the industry had ever heard of these people. They're so small, they had 3.5 million turnover in 2017. So they are tiny in the industry. When the CNIL, the French Data Protection Supervisory Authority, investigated Vectory in 2018, they found that these guys had hoovered up 67.7 million people's data just by sitting in on these auctions, just by being present. Now, if today, even today, I checked a week ago if this was live, if you go to Vectory's website, this is what you will be confronted with. Hard-coded in our DNA is privacy. Nonsense. This is the normal industry spiel. But if you scroll down the page, the claim is actually a little bit better than their competitors. They say, we only store 30%, and we dump everything after 12 months. But you can do the maths and ask the question, does that mean they actually had hoovered up 250 million people's data? Now, I say that to tease out the scale, because we're going to get to scale in a moment. Okay, 3rd time. You, brave people, decide to go onto the internet today. This is what happens when you land on a commercial website. Very similar to what happens when you land on an app. Get ready for it. You load the website, request the page, ad server kicks in, supply-side platform, at least one ad exchange, and then a broadcast of information to tens or hundreds of companies. And then a sync under the table, so the people know you better next time They want to sell your attention or bid on your attention. One of them sent the winning ad, bid, and it takes a whole lot of stuff for the ad to actually be shown. Now, none of this is necessarily a problem, unless the bid request is a problem. So what is in the bid request? That's the question. Now, we don't have to be brilliant investigators to know. We can know because these documents are open. There are 2 industry standards. Although there are hundreds upon hundreds of companies in this industry, there are only 2 parties that set the rules. Google operates its own system. It used to be called DoubleClick, but then they changed that to authorized buyers, which sounds much more legitimate. Then there's IAB, who aren't as good at the press, and their thing is called AdCom Specification 1. It's part of what's called OpenRTB. To confuse things, Google also uses OpenRTB. So these 2 documents are very, very similar. They're public. You could find them on your phone right now. Let's take a look at one of them. This is the IAB version, as I said, very similar to the Google version. Now, this is a 14,000-word document from which I shall spare you. But if you were an engineer, you would read this to know what you can and should put in those bid requests. It's a technical document. At the end of this document, they give what they call an abbreviated example, a summary example of what is in a bid request. Now, there can be, in the IAB system, 595 different types of data in a bid request. This is just a few of them. Many are benign, but this one gives an example of some of the problems. So I'm going to go through it with you and pick out some of the issues. The domain, the name of the website. Now, normally you would have the full URL, so let me remind you what a full URL is. Pencho has visited embarrassingwebsite.com/really embarrassing category /excruciatingly compromising article. That's a URL. Shame on you, Pencho. Now, we also have Pencho's ID. The identifier is what the ad tech company has called him. The buyer identifier is what our DSP has called him, because we're looking for that guy for the bracelet. Now we see that Pencho is a young lady, born in 1990, gender female, interesting. And we've got more stuff about his or her, I should say, device, IP address, mobile device identifier, and so on, and operating system version, and more stuff about the phone he's using, so that we could guess that we're seeing him again, even if we didn't have the IDs. But take a look at those IDs. They are far more specific than your social security number, really long, unique strings. And finally, we have where this person is standing right now, their GPS location. Now, Google system doesn't give you the latitude and longitude. It gives you what are called hyperlocal coordinates. Make of that what you will. Now, this is not a complete list. Other things can be in there too. This system has recently been slightly reformed, but it is actually still in use. This is the context or content taxonomy, and it describes the content that the person is currently looking at. So if you are a victim of sexual abuse and you're reading material to help you with that situation, IAB says you can put in a code IAB 7-28 in the bid request broadcast that goes out to tens or hundreds of companies, along with your GPS coordinates. Google, slightly better, after a lot of pressure from me, has removed this particular part of its specification, but it still gives the full URL, which gives the game away anyway. Okay, so that's what's going on in the industry. What does the law say? Some people think the GDPR is complicated, some people think it isn't, but there's no dispute about the name of the law, right? General Data Protection Regulation. It's actually really simple. You're supposed to be able to protect the data. And Article 5.1f says, if you cannot protect the data, you're not supposed to have the data. It's a really simple idea. It's not even remotely complicated. Without security, nothing else is real. But let's look at what the industry has acknowledged in public documents. Okay, so here's about to be the industry view. This is a public document. You'll find it if you do a search for it on your phone right now, pubvendors.json. In it, it says thousands of companies get the data from showing a single ad, potentially. I don't think that would happen normally. You wouldn't be talking about thousands, but thousands is possible. Whoops. And there is no way to limit how the data are used once they are broadcast. Now that is a data free-for-all. It's a data breach, unquestionably. Now, this system was so terrible that even the IAB realized they needed to put out something new. So in August 2019, they came out with version 2, where they said, we may adopt, we may in the future adopt, now they're talking about it more, an attempt to audit what thousands of companies have done with trillions of data about hundreds of millions of us. So this is not data protection either. And Google is no better. If we all wanted to, get involved for our bracelet company in Google's RTB system, we would have to say okay to a notification, to a message that says we're not going to use RTB data, they call it call-out data, for any other reason. And if we plan to break the rules, we have to tell them before we do so. Now, this is a very romantic story. It's a picture of what happens when self-regulation walks into a bar and meets other self-regulation and has an inbred child. That is what you're looking at. Think the Deliverance soundtrack. So what is the scale of this disaster? And a disaster it surely is. Before we get to scale, I want to remind you of what you're looking at here and every time you use your device. You're looking at a MIRV. Think about nuclear weapons here. Multiple re-entry vehicles. A MIRV of a data breach. It's a data breach of data breaches. And I want to bring you to a single ad exchange to give you a sense of this mess. One single ad exchange. Now, we've litigation going in Hamburg at the moment because the enforcers haven't lifted a finger about this after 3 years, more than 3 years. In our litigation in Hamburg, we're going after the IAB, but we're also going after other parties too. One of them is this particular ad exchange. It's called Xandr. We're scrolling through 156 pages. This is a list of all of the third-party partners that Xandr's policies, public document, say they are entitled to send your bid request data to. The full count is 1,647 partners. Now, Xandr is just one of these jokers. Google is by far the biggest. This data breach is by far the biggest data breach of all time in a single day, and it's repeated daily. So let me bed that with you. Luckily, the industry has a solution. It's called the rectangle with rounded edges. It's incredibly effective. This has kept regulators at bay for more than a third of a decade. Behold the majesty of the OK or I accept button. The only honest consent message I've seen in the last little while is on Chris Hufnagel's website. He's a professor of law at Berkeley. That's a good consent message. I understand what's happening here. I can get with it. Back in 2017, the IAB wrote to the European Commission, and it said, in the worst piece of lobbying ever, it said, please give us an exception under the e-privacy regulation, because they thought it might happen, to the GDPR, because consent is incompatible with our system of real-time bidding, because we've no idea where the data are going. And if we had any idea of where they first go, we've no idea what subsequently happens to them. Now that was March, I think, 2017, could have been April. The next year, to celebrate the arrival of the GDPR, the same organization, the same person, in fact, launched the Transparency and Consent Framework, which plagues you every day on all of your devices. Maybe not your watches, but it's everywhere else. It is a charade. This idea of using consent to a data breach is obviously ridiculous. And yet, we're not seeing much happen. Now, something might happen quite soon, but it's taken quite a bit of work. Now, let's talk about consequences. Why does any of this matter? It matters. We know, you all know, that you're being tracked online. You did not need me to tell you. But we don't really see what the result of that is. Why are these companies tracking us? And if they're building profiles about us, what do those profiles look like? What's in those profiles? Well, now we know. Now we know because of this document. Our friends at the IAB celebrated the GDPR in May 2018 by introducing another technical standard, yet another illegal technical standard called the audience taxonomy. We're going to go through this document because this is the Rosetta Stone that lets data brokers trade what they know about you. There are about 2,000 different fields here, but I'm going to pick a few of my least favorite. We're going to spin through this document pretty quickly. So let's start off. A data broker that knows about your religion can tell another data broker that, if they've hoovered it up, for example, through RTB, by using one of the codes over to the left. By using one of the codes over to the left. Are you Buddhist, Christian, Hindu, and so on? Are you concerned about mental health, infertility, STDs, weight reduction, and now the taxonomy gets into the most intimate things. Does your child have special needs? It's not just you who's being profiled, it's your children. So if you have a child with special needs, IAB says the code for data brokers to know that and pass it on efficiently is 357. This is how they celebrated the GDPR, same month. And these people, by the way, are currently still lobbying everyone here probably with a straight face. What are your political views? Are you conservative, green, independent, liberal? Note, by the way, note what's on the screen. This is the fate of our democratic system here, and this is the level of thoughtfulness that goes into this thing. Now, you may have seen this story. It came out a week ago in the Wall Street Journal. It's a good story. It says there are two data brokers, Mobile Walla and Uber Media, not related to Uber. And what they were doing is they were using RTB data and other data to get people's location and profile them. And that data about all of us that leaked out from the RTB system, which has no technical control at all, by its own admission, ended up in the hands of these data brokers, and then it was passed or sold to the Department of Homeland Security and to other to parts of the US military, and it was used for warrantless surveillance. Now, we told the Irish Data Protection Commission about those data brokers 14 months ago, and we copied our Minister for Justice on that letter. Exactly these brokers. In that same batch of new evidence, we also told them about another company, and this one is European and has received European Commission funding. It's owned by Cloud Technologies based in Poland. It's called OnAudience. You won't find this online now. These segments are no longer online because this was a big media story and it embarrassed them, rightly. I clicked on Ireland, and then I went and I tried to find out which segments, which people could I buy. And it turns out I could buy people who had chronic pain, which is from the audience taxonomy. And you remember our incest and abuse support, I could get people there too. And I could reach those people through, let's call them out here, 200 people from their trade desk, TTD, their trade desk. Google's got a bunch of other stuff it's in trouble for too. 2,300 people for chronic pain. Right now, this is where we are. We have the biggest data breach of all time, leaking what we're all watching, reading, and listening to, and where we are. And we're allowing a system that allows that data to be vented into a data broker system. And the net effect is that everyone you've ever met, everyone you will ever know, almost certainly has been exposed to this system. But this is not just a data protection problem. It's a market problem too. And it's an information and society problem. I want to move this conversation to the market and the effect of data leakage. And let's start off where I like to start things sometimes by looking at a big company's privacy policy, because we all love to read privacy policies. This is Google's privacy in terms. If you zoom in to the maximum amount, this is how big the small text gets. But even still, it's not entirely clear what this paragraph means. So let me clarify it by moving the text in the middle that is part of this sentence out of the way. You ready? Here we go. You get it? So when I was working for a newspaper and we had Google plugged in on our system, we were leaking our audience data to that competitor who could then use those data on their own properties at a much higher margin. Now, this issue of leakage of audience data in the real-time bidding system, it goes far beyond Google. Let's pick on Pencho again. Pencho visits again the Daily Bugle. No, we'll call it John. John visits the Daily Bugle. John reads about business, politics, and then starts to look at reviews of really expensive electric saloon cars. The bid request goes out and it says this person is an auto intender, a person who wants to buy a car. Everyone wants to reach auto intenders. They're the most valuable audience on the internet. So all of these parties who receive the bid request are thinking, auto intender. I'm waiting for this slide to update. We might have a problem here. Is that okay? Is that showing? Oh, okay. Yeah, okay. So everyone in the middle is seeing that John is an auto intender. Now, in the short term, the Daily Bugle gets a payout. An ad is shown. But later on, John visits destroytrust.com or bikinibabes.com or crappywebsite.eu, whatever. And they send out a bid request, and all of these parties in the middle realize that expensive Daily Bugle reader, who's really pricey for us to reach in the Daily Bugle, we can get that guy again at a massive discount by going to destroytrust.com. Now, what happens here is that the Daily Bugle is no longer able to charge for John tomorrow what it was able to charge today, because I can buy John really cheaply over here. But the second thing that is happening is that these people are the ones who can now give the brand, the advertiser, the discount. But the advertiser doesn't know what the difference in price is. So they can take an enormous percentage, and it's all built as a parasite on legitimate media's business. It allows websites that otherwise would not have a business model to exist and to profit by arbitraging on legitimate media. Now, how much do the tech firms, who are IAB's members, how much do they take from publishers? The answer is, we have no idea, but the estimates are terrifying. So let me pick the biggest one, because I don't like them. Let's give out about this industry. The Guardian ran a sting operation in 2016. It masqueraded, it pretended to be an advertiser, and it bought ads through this system with all of the bells and whistles switched on. It bought ads on its own properties, on the Guardian's websites. For every pound sterling that the Guardian spent as an advertiser, it received 30p as the publisher. 70p had disappeared into the tech industry. Now that's bad, but what is much worse is if John is not a human being. What if John is a bot operating on a smartphone in a warehouse with thousands of smartphones? So a criminal enterprise tells a bot, go visit legitimate publisher, build up behavior as though you're an expensive auto intender. The ad gets shown, but these people are all now trying to retarget and track this bot. They don't particularly care that it's not a human, but they may not be able to tell. Now, the criminal website says, great, you've done a good job. Now, bot, come home and bring those advertising euro with you. Now, this is how you divert billions of euro from legitimate media out of the hands of advertisers and away from the newsrooms that keep the system honest. And again, Our estimates on this are absurdly different. Now, some of these things are measuring different types of fraud or in different markets. So there's a good reason why they're very varied, but the best reason they're varied is that no one has a clue. We know it's billions. The question is it double, single, or triple digits? It's not really clear. So back to our earlier diagram. This is what I showed you at the beginning, but if we spin it so that it looks like a market, the buyer, the advertiser, is subject to massive fraud. The distributor is taking a huge invisible tax and allowing a business model for the bottom of the web, which, okay, it can exist, but should it have a business model that eats as a cancer on legitimate media? And legitimate media is allowing its audience to become a commodity and to be arbitraged. Now, if you strip out the personal data from these bid requests, which is a simple solution in my view, a lot of these problems go away. And this is the same discussion we have had in many other industries. How happy are we to have dirty technology, and don't we want clean technology? We have the same issue in the automotive sector. 100 years ago, more than 100 years ago, the petrochemical engine won. It won in the contest between the electric engine. That did happen. And if we could, we would drive these things until the world burns, right? But luckily, the technocrats among us have told us you're not allowed to do that. The negative externalities are too massive, and we've now decided to start measuring them. That was the important thing. So we're going to start incentivizing this thing. That's what happened in the automotive sector. But if you've got a Ford Mustang, 1976, blah, 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 that's unusual. You're allowed to have it, special dispensation. The same is what data protection law basically says. And if it were enforced, this would be the same thing. If you can keep the data safe and run an ad system off it, maybe there's a way to do that, right? Let's talk about it. But if you're going to have a data free-for-all, you got to not have personal data involved. Now, the industry is aware that a change is coming. There's so much pressure. And so in July this year, the IAB again produced this report. And in this report, their own figures say 81% of consumers prefer content that is targeted by context of the material. And they say the market for this in 2025 is going to be, and they say in dollars, $412 billion. So the future looks bright if we do this correctly. But let me conclude, and I'm a little bit over time here, of course, with the problem. It's not just that this stuff is happening. It's that it's been allowed to continue. That's the problem. And it's an enforcement problem. As I said yesterday, we have the tools, but we are not using them. Let me give you a brief chronology of my complaint to the Irish Data Protection Commission, which has been duplicated across the EU in, I think, every jurisdiction now, to other enforcers too. I had blown the whistle previously, privately, but finally on the 12th of September 2018, I filed the complaint. Now, the DPC spent 8 months and 11 days doing something, I don't know what they did, but they launched an inquiry after 8 months and 11 days. Clearly, they did not share my sense of urgency that the next election might be played with, used as a plaything by people who had recourse to that data broker data. Now, we had correspondence. We have a lot of correspondence with the Irish DPC trying to get them to take action. And the last bit of correspondence before I testified on this in Dublin, I found that by the 19th of March, in a letter from them, it turns out they had not yet, even at that stage, written for themselves a statement of issues. A statement of issues is a very brief document where the enforcer sets out what they plan to investigate. Now, that's 2 years, 6 months, and 8 days after being told about the biggest data breach of all time, which has a bearing on health data, political data, yada, yada, yada. And the latest update is nothing. So time to completion at last count is infinity. Maybe a statistician might quibble over that, but I'm not sure. Now, this isn't some small complaint. This has been on the front page of the FT not once, but twice. Right? This is not a thing that's going to go away. And in the time since they've got the complaint, It's got worse. So I'm showing you here just 3 of the exchanges for which I could get data over time. This data breach has grown since the enforcer has been told about it. So let me conclude, Pencho, I know I'm over time, with a question for Carolina, if she's still here. Hopefully she is. She was great earlier, but I'd like an answer to this question. When does the European Commission step in? When is it acknowledged that this is a crisis? This is a crisis. Is this not a crisis in the Commission's view? What is the criteria that the Commission uses to decide whether to launch an infringement procedure? If this is not the time, when is the time? If the stakes here are not high enough, have I left something out? I cannot imagine a reason to not act now in a hurry. So let me summarize with 4 points. First, real-time bidding, which you have now been told about in exhaustive detail with lots of arrows, is the biggest data breach of all time, and it is repeated daily. Second, this thing is what feeds the system of disinformation. It is a cancer eating at the heart of legitimate media. It allows voters to be profiled, and it allows them to be micro-targeted. It's the trifecta of a breakdown of the communications that allow society to function. Third point, for some reason, those who are in a position of responsibility to fix this problem, the supervisory authorities, the states, and the Commission above them, feel no urgency whatsoever about this problem. I do not understand that. And let me just conclude by saying there is an industry waiting for its moment here. There are fantastic companies that can do this safely. There are Teslas all around us waiting for old Detroit to be told you are not allowed to pollute any longer. Thank you very much.
I have not enough listening to Johnny a couple of times, and I'm sure that I'm going to see it many, many times also after this event. I hope that Carolina had enough patience and is still with us. She's smiling, and that's good.
Oh, good.
It matters to us. Carolina, actually, I had a question for you, but actually, I hope that you have listened to the question of Johnny. Do we have...
Very carefully, of course.
Yeah, do we have an enforcement gap, and why that?
Well, just the first thing here. Press release from the Belgian Data Protection Authority. Belgian DPA sent its draft decision in the AIB Europe case to the European counterparts. The case concerns precisely the Targeting Interactive Advertising Bureau Europe, AIB Europe. So all the practices which were addressed now by Johnny and on which he so eloquently and elaborated, it was very impressive, are being now, were investigated and are subject to a decision from the Belgian Data Protection Authority as the competent one. And they are submitted to the counterparts, European counterparts, in beginning of the last week. And they will be subject to Article 60 GDPR procedure, and we will have a decision hopefully very soon. So this is the first thing. This is as much as there is to say about lack of enforcement, about Commission pushing individual independent data protection authorities to take up a certain case and to deal with a certain undertakings. It's a frontal attack on the independence of the data protection authorities. And I think a mere glance on the conditions of the independence, even if not anchored, so even if we do not want to look at the GDPR, but at least at the case law of the Court of Justice, will convince everybody that it's just completely impossible to do that. Now, this is also not particularly fruitful to copy in Ministry of Justice or whatsoever when one pleads for a data protection authority to take up the case. Should it be possible for the any kind of ministry, for the state to influence the data protection authority to take up or not a certain case, then we have a case of a breach of independence of the data protection authority. I think we have to make up here our mind a little bit. What do we want? Yeah. So first of all, as far as the real-time bidding is concerned, the issue was investigated and is tackled at the appropriate level, but appropriate data protection authority is tabled to the within the cooperation mechanism, and the decision is about to fall. Now, this decision, since it affects the practices agreed by several undertakings as far as the real-time bidding and the cookie setting practices are concerned, will affect not only one undertaking, but all those who participate in such practices. I think it's much more effective. So much this is the comment.
Johnny would like to reply.
Yes, I'm glad you've taken note of the Belgian draft decision, but I must correct you, Carolina. The Belgian draft decision relates only to IAB Europe, which is a controller only for it's called a TC string. It's data that is created for the consent system. So the controllers for the RTB, in addition to the various companies involved, would be IAB Tech Lab, which is based in New York, and Google, which is, of course, headquartered in Dublin. So we haven't seen actually any action on real-time bidding. The Belgian case, and I've been the lead complainant on it for quite a while now, the Belgian case is trying to deal with the consent spam. It's a problem that is very closely related to RTB, you're right, but it's a slightly different problem. It doesn't get to the whole. But it is welcome, and it is good to see that the APD has made progress there. On the question of independence, the states have a role. Data protection is an objective of the Union, as we all know, and the states have an Article 4 responsibility to see that data protection is upheld. Now that's a broad general thing, but it is real. And although the supervisory authorities are independent, and they must be, I think, for example, in the Irish case, the state has two things that it can do. The first is, in the Irish Data Protection Act of 2018, the minister is the one who can decide, the Minister for Justice, whether to appoint additional commissioners. So there could be a college of 3, for example, and the minister can decide which among them shall lead. Now that is quite a lot of power to have, and she does have that at her disposal. The second issue is whether, and I think it's essential, the Irish Data Protection Commission now should have an independent review of how it can be strengthened and reformed as a general exercise. And I know that the Commissioner is sympathetic to that. So we're not talking about in any way minimizing or degrading what should be independence. But the states have a role. They have a responsibility, as does the Commission.
Well, if I may. Thank you very much. Thank you very much, Johnny. Concerning the content of the decision, I didn't see it. The Commission will be able, as a member of the European Data Protection Board, see the content of the decision only should it reach Article 65, so the consistency mechanism. From what I understand, and you are much more knowledgeable about the RTB protocols or not, precisely the open RTB protocol will be is what is investigated here, and even if it's not covering the whole practices, a big chunk of it is covered by the decision. So to the thing, we cannot speak about a complete failure and these big words. There is no enforcement in Europe and so on and so on. And I think the facts speak for themselves. Now, concerning the situation in particular in Ireland, I would think that the system, we are here in the area of fundamental rights. The system of enforcement of these fundamental rights is provided for in the light of the Charter, which requires independent data protection authorities, is set up in the GDPR in such a way so that these authorities are truly independent. One. Now, the responsibility of the state is to preserve this independence. Who is and how is pre-selecting the candidates, and according to which national rules the candidates are pre-selected, as long as there is a transparent procedure which is set up in accordance with the GDPR. I'm just looking for the article. The Article 53, and the members and the DPAs are appointed by the means of a transparent procedure by the Parliament, government, head of state, or independent body entrusted with the appointment under the member state law. There is this rests with the discretion of the member states. So how the candidates for the position are pre-selected, how many candidates they are, how the data protection authority is organized. This is not, as long as it complies with the conditions of Article 53, this is not something the Commission should say that much about. And having said that, even if the Commission, as the guardian of the treaties and a body which, an institution, not a body, sorry, which ensures or monitors a correct application of the EU law in the member states. We step in when we see that the situation is not being addressed at the national level. Now, the situation in Ireland is completely different. We have the report from the Cross-Party Justice Committee of the Irish Parliament and Senate, which made 17 recommendations addressing some very interesting issues. And we find that very positive and appropriate steps are being taken at the national level to discuss how to address possible questions of the GDPR implementation. And indeed, from the position of the Commission, it's the first place for the member states to ensure the application of the EU legislation. And if the actions, should there be any problem, if the actions taken on the national level are insufficient, the Commission's intervention could be necessary. So, yeah, this would be my reply to.
Okay, maybe just a short follow-up. Have you considered in the last 2-3 years starting of any infringement procedure concerning GDPR against any member states? Could you tell us?
Of course, we have several.
Okay.
We have several infringement proceedings, and we just started one against Belgium concerning the independence of the Data Protection Authority. We had proceedings against other member states, and I wouldn't like to name and shame here. But
okay.
Yes, it's clear, yes, we did.
Okay, Giorgione, just short remark because we have to close the session and we are over time.
So two important clarifications. The cross-party report from the Irish Oireachtas is not from the government. They are beseeching the government to take action. So this is not and should not be interpreted as action taken. This is a list of requests that concerned parliamentarians in Ireland are making, not evidence of action. Quite the contrary. Second, I want to make sure it's clearly understood by the Commission that Belgian procedure, and we were heavily involved in it and know what happened. It is focusing purely on the consent system. The personal data involved are purely the data in the consent string. Now, part of that I dealt with in my presentation. We do not get into the underlying data breach except to say that because that data breach can't be fixed, the processing of the consent string infringes data minimization. It doesn't, for example, the Belgian action does not touch even slightly on Google. Right? Google's authorized buyers is not addressed. And hopefully it might make an impact on OpenRTB, but we have to wait and see.
Well, I think very much, because as I said, I didn't see the content of the decision. I don't know exactly what is addressed in there, but establishing the lack of existence of a valid legal basis for the processing is a precondition in order to be able to speak at all about the data breach. And as I understood your presentation, precisely this lack of a valid consent, in your understanding, is the reason we can speak about the data breach.
No, we can speak about a data breach because of a lack of security. So security was the sin from which all of this flowed. It was then impossible to get a lawful basis or to have transparency, accountability, or anything else.
But we are offering more space for discussion in the coming months, years, and I hope that, Carolina, I hope that at least some arguments also help you in your daily work. I hope this discussion was useful, and we really appreciate your time. Dear Johnny, it was a pleasure listening to you.
Thank you, Carolina. Thank you, Pencha.
Thank you very much.
And now it's time for a small break. Many thanks.
Thank you.
Thank you, John.
Hello, we're back again to the European Data Summit. As you know, data sharing is one of the priorities in the data strategy of Europe. And we would like to ask how to move from strategy to execution. It's my pleasure to introduce Katrina Doe. She is a representative of MICO. She is in the industry, in the data industry for more than 20 years. And she is one of the prominent voices when it comes to data sovereignty. Dear Katrina, the floor is yours.
Thank you, Pencho. And good afternoon and welcome. I'm joined today here with 3 of us in person, and I believe, I don't see the monitor yet, we also have 2 other panel members joining us virtually. So I'm going to just dive into our scene setting, and hopefully they will, here we are, terrific, with Oliver, Oliver and Ronnie, that's
Hello.
as well, fantastic. And joining me here in person, we have Anna Lundin. Welcome, Anna, thank you for being here. We also have with us in person Aline Blankets, if I've said that correctly, and of course Marianne Terven. Thank you for being here. So I just thrown out my preparation notes that I've been working on for the last couple of weeks for today's session, following the session that Johnny has just presented. So that's a hard act to follow. In that, one of the things that we want to achieve in the session this afternoon is to look at this move from strategy to execution. What does data sharing in Europe really look like? And what struck me in the session that we've just watched, and in a comment before we started, is there was this suggestion of moving to clean tech, that there is an alternative, and maybe that's one of the things we can discuss today. Well, what does that even mean if we started to use this term? So there's no doubt that the EU government is going to play a role in shaping the digital world that we are living in now, and the future. And why is this so important? Because we now have a generation that is fully born into a digital world, in what I would call a phygital world. They're constantly living in the physical and the digital. And so many of the rules, regulations, the way society works has been shaped for the physical world, and many of the challenges that we're dealing with right now is this hybrid as we moved to what will eventually be a fusion between both. We also want to look at redistributing the balance of power in the digital economy and being able to compete. We want the EU to be able to compete against the US, against China. We want to be able to look at ways of being competitive and fair and continue to foster a democratic society. We're more than 2 decades into this current digital experiment as we look at the socially connected world, the outcomes of living on social platforms, of being connected 24/7. And we're starting to understand the impact that that is having across the way we live, the way we vote, the way we connect, the way that we operate with each other. And yesterday, I think it was Tommaso Valetti, one of the things that he said that really inspired me from yesterday's session. He said, all of the brilliance of humankind, and so far we've really only come up with one business model. So when we think about all of the incredible achievements over the history of time, whether or not that is across art, literature, architecture, building cities, democracy, building organizations, building communities. It was a thought that made me feel inspired that there is actually a possibility for a new way forward. A campaign that I've been involved in over the last year alongside Marianne is Data Sovereignty Now. And one of the things that the group did recently was take a survey and publish the first data sovereignty monitor. And one of the interesting things about the findings, overwhelmingly, is there's an interest in finding new business models. There's an interest in understanding a way forward, but there were more questions than answers. And the questions were around what alternatives. The current business models revolves around extracting data without you and I, or organisations that we represent, knowing, and this is no longer sustainable. But what are the alternatives? So some of the things that we would like to explore this afternoon are what steps can be taken from a European government perspective in facilitating these new business models. What's the role of soft infrastructure, data interoperability, standards that will foster and enable some of these new models? Which new business models do we foresee for organisations to ensure that we can actually embrace data sovereignty? And what are the issues and challenges for front-runner organisations in starting to show these alternatives in terms of data strategy? And if the opportunity exists for us to think in these new models, whether or not those things actually, if we can start to define what clean tech or what some of these alternatives might be. So Anna, if you don't mind us kicking off with you, a little bit about background, Anna's background. Anna is the policy officer for DigiConnect, the G1 unit responsible for the data policy and innovation. Anna is a lawyer and joined the Commission as a national expert from the German Federal Ministry for Economic Affairs and Energy, where she previously worked on AI and the data economy. And Anna focuses on policy questions around data access and use. One other thing I would add is that there's been an opportunity to catch up with everybody over the last couple of weeks. And I often find when building these kinds of panel discussions, you have incredibly interesting discussions in the preparation. And my wish is that today's panel is as much as interesting as those individual conversations. And Anna, starting with you, I think the key things in our discussion were around the availability of data in terms of access and sharing, the role of the EU Commission in terms of publishing the strategy in 2020. Maybe you want to start with what the aim was and where we stand now, and what are some of the problems that the Data Governance Act is hoping to address.
Of course. Thank you very much first. Thank you very much for the kind invitation for this extremely interesting conference and summit, Pencho, and thank you very much for the kind introduction, Katrina. Yes, I would briefly start, I guess, to recall what the European Data Strategy was actually about in February 2020. I guess everyone in the room and probably all the online listeners are very well aware of the strategy, but maybe to set the scene for our panel, I repeat a bit what it is about. The aim is, of course, to make the EU a leader in the data-driven society. So one of the first things that were new with the strategy compared to earlier Commission's communications was really this overarching aim that doesn't only look at the data economy, but really at the society as a whole. And with that, we combine a vision of creating a genuine internal market for data, where we have data that freely moves across borders, of course, but also across sectors and benefits all actors, as this aim is so overarching, as I said. So as every political strategy, basically, also the EU data strategy has, of course, a range of measures announced, which you can cluster probably in legislative framework, investments, and also it's, of course, a tool to communicate what we will do in the upcoming years. And one main element you might be also very familiar with is, of course, the creation of common European data spaces. It's part, of course, also of the investments. So with all that is planned in the European data strategy, we of course want to move ahead very quickly, and we've heard it in the earlier discussions already. I think one big milestone has just now been achieved with the political agreement on the DGA. Thank you again to all the hard work from the negotiators. And if I can focus for a moment on what was announced with regards to the legislative framework, it is indeed two major new horizontal legislative initiatives. One, the DGA, that you were asking about the problems, focuses on making, facilitating basically the voluntary data sharing by setting up frameworks for it. And one very interesting aspect of the DGA is, of course, the chapter on intermediaries. And this chapter focuses on the lack of trust that Malte has been talking earlier about this issue that is addressed with Chapter 3 by trying to create more confidence with neutral actors intermediating between data holders and reusers. The second major legislative initiative will be coming up soon. Everyone is waiting for it. I know it's the Data Act. I guess it has been mentioned earlier already. This one is rather looking at a fair allocation of value in the data economy and in the society. So we will, of course, with the Data Act, in contrast to the DGA, not only look at voluntary data sharing and how to facilitate this, but rather also look how do we actually deal with situations where data is co-generated by several users, as we know from IoT objects. You know, there has been an Inception impact assessment in May this year, and also an online public consultation that ended in the beginning of September, and everyone is now waiting for the proposal, which is being conceived, and you will have a look at it soon, I guess. I'm very excited for this discussion, because we need this discussion to go ahead with the implementation of the data strategy, because we need to move ahead from vague concepts to clear ideas how to implement good ideas.
Thank you, Anna. That's a lovely segue into the comments, Aline, from you around incentives. But first, a little bit about Aline. Aline is the applied economist with ample experience in analysing developing policies for digital markets. She's the co-founder and co-chairwoman of the Zinner Foundation, and the Zinner Foundation promotes confidential data collaboration by bringing together technology and governance. She also works for the economics consultancy Axera, and before that led a project on the data economy at the digital policy think tank Stiftung Nu Während Wurzang, and I've just completely butchered the German language there, so my apologies. Aline has published on the intersection of data privacy and competition, particularly with data trusts and other topics. So this idea, when we chatted in preparation around incentives, would you like to pick up on how we start to get this balance where we want to have the trust, we want to have the incentives, and we want to find this new way forward?
Yes, sure. And also thanks from my side for the invitation, Pencho, and for the very kind introduction, Katrina. Yes, I think it is important to think about and talk about incentives, because we had a lot of talk about, well, what we don't want. I think we have some idea of, well, we want to do something as Europe, but you know, and then when we talk about, okay, so what can we actually do, a lot of people go quiet. And also, I mean, we have these legislative measures, but this is not enough to actually bring about change. So we talk about open source. It was even mentioned yesterday evening, we were actually talking about competition. Like, everybody loves open source, but how do you actually get to open source? How do you get to interoperable markets? Something you can regulate, as we do now with the DMA, but if we want to scale it further, we need to think about other mechanisms. And that's something that has been quite missing from the debate, also from the Data Governance Act, for example, that if we want more data sharing, then we need to provide incentives. And I think we are quite there is a fairly broad consensus that we want more data sharing, for example, in health, in sustainability. Zina has been involved in or supporting kind of developing a standard and a technological solution for basically sharing emissions data along the value chain. Like, everybody agrees that's a good thing, but building it open source is tricky. Like, turning open source into a business model is something that, well, a lot of people would like to do, but then when we come into the nitty-gritty of how do we make it happen, there is some reluctance, and there are now demands, for example, for a sovereign tech fund to actually help provide this basis infrastructure so that the state doesn't have to build it itself, but can source it from the market. But we have to be aware that this is not something that we can get for free, but it needs to be maintained. But there are positive examples. For example, in the UK, now all software that is being sourced by the state, if it's not open source, there has to be a very clear explanation why this is not the case. So the governments, as a starting point, have a lot of leverage with their demand to bring about certain change. Also, for example, in the Netherlands, by requiring data on emissions in public construction projects, they also drive more transparency in the market. So this, one would think this is really the least we can do, because the public demand is something that politics can control and currently are not using for the best benefit for these different business models to emerge.
So do you think transparency or the governance could be mechanisms to create the environment for some of these new business models to emerge? It's sort of creating the conditions for different parties to act together?
Well, yes. I mean, we are at a fairly early stage in the sense that I think we sometimes, as I said, like we try to regulate certain business models into the market, but I think this, then we risk not seeing any change at all. I think there is a lot of interest, for example, in using privacy-enhancing technologies to allow more data collaboration without infringing, for example, privacy or business secrets and things like that. And a lot of this is still kind of at the academic stage, and we need to bring it together. Like, there needs to be also then, some knowledge sharing, some exchange between academia, business, and so on, to make this happen in a productive way. And certainly we need transparency, because otherwise it's very difficult for one side that could make use of data to find another side that might be able to provide the data. That's something, for example, in health data. Well, I think we also saw it yesterday, like, in the proposal by Luisa Specht and Wolfgang Kerber. Like, we need more transparency, we need more openness when it comes to data, so we can facilitate productive collaboration.
So the word collaboration is a perfect segue into introducing Oliver. And the key thing that I took away from our conversation was you saying we need a new way. Oliver Ganser began his career at BMW Group in the technology office in Silicon Valley back in 2001. Since then, he's gone on to become the head of program for industry platform at BMW. And since November 2020, the chairman of Cantina X, as well as the head of the consortium Cantina X Automotive Network. Oliver, the key thing that I took away from our conversation when you said we need a new way is we've got to find ways around value creation and collaboration, but in really, really practical ways. I was inspired by the framework that you mentioned, which is around taking real use cases and looking at solving problems in very practical ways. Would you like to tell us a little about how you're approaching both this collaborative, things from a collaborative perspective, but also in a very pragmatic way?
I try my very best. Thank you for the kind introduction. First of all, I think it took us as an industry a long time to find this way how to collaborate, because if you would have asked me 5 years ago if this would have been possible, I would have said no. Why did it work now? Well, we had major crises in our industry, and there are things ahead of us that we all understood now we cannot solve on our own. Take a CO2 footprint calculation, take a circular economy business model or collaboration model. We all understood that a peer-to-peer collaboration, what we had in our industry for the last 100 years, was not working. So we started out with Catena X a year ago, and we said, let's take those problems that we have right now, like how do I calculate a CO2 footprint? How do I make clear where my semiconductors are missing? And how can I quickly adapt as a system, not as an individual, but as a system to that new challenge? And we found breeding ground with 6 companies. This is, yes, exactly, that's what we need. And once we shaped the idea around 10 use cases, and we shared that a little bit more, suddenly we had 28 behind us, companies like a Volkswagen, Mercedes, peer-to-peer competitors to my company right now at BMW, but also other companies like Siemens and SAP joined right away. Said, if we want to change the way we do business, we have to start it as a team and not just outfitters and adopters. We have to join forces from the beginning, that if you build a new system, everybody has to be on board and find its own business model. And secondly, we understood fairly quickly that over the last couple of years, everybody wanted to monetize data. It doesn't work right now, or not yet at least. So we said, let's focus on use cases. And that's what we said. We focus not on monetizing data. We do not focus on what's in for me, but what's in for us as a system, because the system, we're banging against the wall right now if we do not change it. And so what we're doing, and I think some of those statements have been already made, in order to be open, we built the main system on Gaia X, which is basically we need this European trust anchor and framework, because no one would believe is that BMW says, we BMW offer this great open system. So we use Gaia X as a framework and IDS for the industry data spaces. And the second point is we built the main elements of that system. We built open source. The data models are open source. The interfaces, the user experience is all created in an open source environment, that it's not owned by one, but that it's owned by everyone. And we use the talents to say, we need to share, use that as a shared service. And where we differentiate ourselves, let's use the rare and scarce talent we have on the differentiating maybe applications somebody wants to offer there, but we have to join forces. And I think this so far, we have an association now with 65 members. This resonates. The open source aspect, the focus on the value creation by right now as a beginning, 10 straight use cases. And we're all talking on an eye-to-eye level. It's not the OEM versus the first tier or X tier. We are all in one boat with the suppliers, with the outfitters, like a Siemens, a SAP, ETIS system, whatever, and we work on that in a collaborative way. But we needed stimuli at the beginning from the government as well to kick it off. But the majority of the money is coming from the industry. But it took a little push. That's what the colleague said before. How can I stimulate a system?
Thank you, Oliver. The idea of took a little push, or putting that infrastructure into place, Ronnie, that's a nice introduction to what we discussed around the work that you're doing right now as a facilitator. By way of background, Ronnie Kahn is currently working on the European Digital Identity Framework at DigiConnect. As a seconded national expert from the Norwegian Digitization Agency. He has extensive background from user identification, authentication, payments, and financial fraud area in banking, and as a developer, product owner, and as the CTO, CCO officer in a banking-owned startup. So, Ronnie, one of the things that you talked about was the tool set, and if I just draw on a few things that Oliver just mentioned there, and also from Anna and Eileen, open source is coming out, transparent is coming out, incentives for collaboration. You talked a lot about a toolkit and the ability to facilitate new outcomes that could build data transparency and trust around digital identity, but also could facilitate a more open and trusted digital economy. Would you like to talk a little bit about some of the things that you're doing and how you see that fitting into these new models or facilitating these new business models?
Sure. First of all, thank you very much for having me here. So what we are working on is what is called the European Digital Wallet. And that is kind of, it might make me the odd duck here because it's not really about data. It is about everything. And the purpose of this wallet is to move from what we have today in terms of digital identities that barely works in country and does not work across countries, to something that works both inside the domestic sphere and also cross-border, and where you are able to enrich your identity or do what we call digital validation, where you can express more things about yourself than just who you are. So those things might be different things, that they might be, for instance, a proof of my role and my job and my authority to actually give consent for releasing some data into some project, or consent for sharing my health data, for instance. So it's kind of it's really about building a digital ecosystem for both natural subjects and legal subjects. So that's the framework we are building.
And we talked a little bit about putting soft infrastructure. You just mentioned health data, the COVID certificates, payments data. Would you like to expand a little bit on, and one of the other really interesting use cases you mentioned was around power of attorney or digital trust, in taking some of the things that we have in the physical world from a legal perspective into the digital with a framework. Would you like to expand on that a little more?
Yes, so we are making a framework, or we are making a house, and we don't tell anybody how to make the rooms inside that house. So it's a legal basis for instance, expressing power of attorney within this framework, and deliver that to somebody, and they have to accept that. At the same time, we are not mandating exactly how that should look. How does a power of attorney look? That will be up to the sectors to do. On the same token, we don't give consent for somebody to access my health data. We don't tell exactly how it looks like, but we're given the framework, the legal framework on how this should be recognized and accepted, given that there is some sectorial laws regarding the content, exactly how the content should look like. So in that sense, this is facilitation. We're making a framework, but the rest of the sectors and the industry needs to fill these frameworks with content that are accepted both cross borders and cross industry.
Okay, so the focus there on this soft infrastructure and the interoperability, which is probably a great segue to you, Marianne, yes? So I know that this is something that is very close to your heart. So by way of introduction, Marianne Terven is the Director, Lead Data Sharing and Public Services at the consulting firm Interpay. She believes in a world where trusted data exchange is key to unlocking new business models and reducing costs. And we've had the privilege to work together closely over this last year or so on data sovereignty now. And I know that you've been at the forefront of helping policymakers, industry appreciate what soft infrastructure can do and how it can be a multiplier and a massive facilitator towards this new data sharing economy and this new value creation.
Yeah, thank you, Katrina. Yeah, indeed. So actually, what is soft infrastructure? Huh? So for a lot of people, it's still a abstract word, but basically for me, it's something we do for ages already. So I mean, we built sewers back in the years, and we developed cities and countries with it, and we built roads and railways, and with that we unleashed enormous development for everybody. And now I think we need soft infrastructure for data sharing. So that is soft infrastructure is a set of agreements that you make. And it's not just about the hard infrastructure, but it's also, if I drive my car, it's not just about the roads that we have, but it's also, if I'm in a collision with you, I know exactly what to do. I know which EU form I have to pick up and fill in. So for me, soft infrastructure is a way to tilt the data benefit balance, in that you can make sure that not just the organizations get benefits of the data, but also the users. And I think what happened in the past decades is we gave that away to the private companies. And we have to get it back. The building of a soft infrastructure, it needs to be at least a public-private endeavor. And why is that important? Because it's about the values and the data benefit balance that we want to bring back. And we had some discussions yesterday as well, and today, where people were saying, do we need horizontal regulation or vertical? And for me, I think if we would have data sovereignty, true data sovereignty, which means people and organizations would be able to control the data that they generate, would be able to know where the data is, under what conditions it is kept, and that will enable them to use that data in other contexts, then that would really unleash a lot of value.
And how do you see that with the initiatives that you shared with us in terms of the objectives that the Commission is trying to achieve, this idea of soft infrastructure? How do you see that as an enabler from a policy point of view?
Yeah, when we talk about interoperability and standards, this is a topic, of course, that will not only be in the DGA, but probably also in the Data Act, as it has been announced also in the Inception Impact Assessment. In the DGA, we have this idea of a European Data Innovation Board in Chapter 6. And now I do not know how the latest text looks, but from what we know, from also the original proposal, there will be a Data Innovation Board that will be also, among other things, looking at standards and at how to prioritize standards, especially with regards to cross-sectoral standards, because this board was also thought of as an enabler for the building of the common European data spaces. And as I said earlier, the common European data space is also closely probably linked to the work of Katina X. It is much about building ecosystems, basically, bring networks together. And then these networks, of course, are also of a need of an architecture of standards to enable the actual interoperable exchange of data. And there are a lot of initiatives looking at this right now, as you know, but we still see the need to observe if the industry-led standards will be enough or if there is a need for more. And I think both legislative proposals, as much the DGA as the upcoming Data Act, will have a close look at interoperability, as it is key, as we all know, to ensure this well-working data exchange basically across sectors, especially. That was, I think, also the new idea with the data strategy, that we don't only look at really the data exchange, the sharing within a sector, but also beyond it, because we know that data can be so valuable when we think outside the box and use it in a different context.
And also when we bring the data subject or the individual, whether or not that's the passenger in a car or whether or not that's a patient in a hospital or whether or not that's an employee, we all fulfill these different roles. So as individuals, we find our data moving across these data spaces and moving into the different sectors. Oliver, that's probably a question for you to follow on in terms of the standards and the interoperability. If you would talk a little bit about, as you work through these use cases in a collaborative way, where you're seeing the adoption of standards or agreeing on things that are shared, this idea that we've had a few decades of the rise of the platform with enormous lock-in and walled gardens. And what we've heard a lot in the language, starting from yesterday and through today, is this move now, as you say, Anna, to networks or networks or networks. So we're kind of moving to where the value is created in the way that we connect and collaborate rather than what we try to keep within a walled space. So with the use cases you're working on, would you like to talk a little bit about how open standards or open source or agreeing common frameworks, how that's helping you solve some of those practical problems?
Yes, sure. For us at the beginning, it was really important to understand what could be the most limiting factors to take off. And I must say, as Germans, we'd like to understand the problem. We'd like to create a system around the problem and then define the system of the problem and see what potential problems can cause the problem. So I said, before we have a normal discussion group in Catena, because it's a high risk in Germany, let's put it like this, or in Central Europe, we said we'd like to create those standards not on paper and not a discussion group. We would like to create those standards in code. So put your best teams in there and let's see who can code the fastest in open source. We opened up an Eclipse space and said, okay, so rough consensus, running code. And the code that sticks, that will become the next step, what we will build the next release upon in Catena. And interesting enough, it changed the way how we were discussing. It's becoming from a discussion culture more into it, does it stick culture? And are we 100% there? No, for sure not, because we just started. But the point is, people, we had to put them out of the routines and, oh, this is mine, this is yours, and find a piece of paper, how it could work and leave the execution to someone else. Now we put the execution right at front, that you write it in code. And if we find a data model that sticks in code and that we can agree on that and that we have the data, then it takes the next step. But we do this, what's relevant right now, and then we try to scale it from there. And for us, that was really the basis, because the interoperability is only possible if you have a shared data model, if you have the shared interfaces. And this is all open, and this is what we do together. And funny enough, we do not have problems right now finding talents to work on the open source element, because every, I would say now, proprietary software solution provides, I would like, because if I want to use that, I want to make it the best for me. So I send in my troops to help to write that code. And so it's really a perpetual system right now that we are seeing that it's going to evolve, because everybody has an interest. We have an interest to say, this is the code that's or the data that we can share right now. This is the SAP and Siemens say this is something what our machines can share and what we can use. And we do this in a collaborative way, because there are no boundaries. And we have even companies or people right now we do not even know from our consortia who try to help us in our data models and interfaces and shared services. And I think this is, for us right now, the secret ingredients. Don't talk about it, put it in rough consensus and running code.
And it's very inspiring to hear you say sending in your best people, because you know that may be code that you will want to use in the future. And I think if you think of both the combination of that from a collaborative, innovative perspective, but also de-risking the use of that code further down the track, that is incredibly inspiring from a design point of view, from a design principle point of view. And Ronnie, I know that a lot of the things that you're doing in the identity space and everything that we're every use case that seems to be touching us in any kind of digital way, whether or not it's the technology we're wearing or the technology we swallow or the way we move through the physical world, whether or not it's showing that we are able to enter a venue. Identity is at the heart of that, being able to prove who we are or that we have some right of access. Would you like to talk a little bit about what's happening specifically in the standards world around those identity frameworks? Because what I've seen, having worked across identity for more than a decade, it's really this last couple of years that we've seen a massive acceleration towards cooperation globally to come up with some interoperable standards that can work. And maybe you'd like to talk a little bit about the self-sovereign or the self-managed identity that sits at the heart of that as well.
So I think that's a big area here. So standards are developing, but so far they are still a little bit early days, I would say. And there's a kind of a big gap in the philosophy from this kind of egalitarian identity to something that is actually backed by the government as the root of trust. So what we are obviously looking at is what is backed by the government as the root of trust. This can still be self-sovereign to some extent, but you won't get this kind of free party for all environment. So standards are slowly developing, but it is still early days. I think we'll probably do some more mistakes before we get it right. But this is basically what we're trying to do in the toolbox process, to work both on the core identity case, but also look at more use cases like payments, like having a driver license in your wallet, like having a passport in your wallet, like having a patient summary in the wallet, and also to release this kind of information by proving consent by something you have in the wallet, and at the same time expressing terms and conditions for giving that access. So again, it's early days regarding standards, but I think we're getting there. But it's still some interactions to do.
And the proving consent, would you like to talk a little more around how you see that working? Are you saying that is something that will be embedded in the framework so that whether or not it is proving something or it's making a payment, or some of those use cases you talked about, the consent will actually be hand in hand and will actually be able to support and underpin the use case?
Yes. So in its simplest form, you might see consent as kind of click to consent, which is basically you prove your identity, and that gives you also a consent. But that's not proper consent. A proper consent would be something that can be picked up in 2 years and prove that you actually did give consent to that actual thing on that actual date with these terms and conditions. So that would basically be some kind of signed artifact document, which the user can produce in the wallet. So again, back to the sectorials here, somebody needs to define exactly how such a consent looks, because we are not doing that. We are building the framework for expressing the consent, but there's other domains that needs to basically decide how should a consent look like in terms of the payload inside the kind of signature and all of this legal stuff. That is for other sectors to figure out, and I hope this work will start soon.
And Marianne, that's something you talk about quite a bit, the peer-to-peer aspect of it, yeah, where there's volition to share and have that consent. Would you like to expand on that a little?
Yeah, thanks, Katrina. Yeah, so I think, you know, if you look at what Oliver said earlier about the need, you know, we hit a wall and we need to collaborate, then for me, that's also a really important point. If you look at the data spaces that you were talking about, this is going to be ecosystems like Catena, like other systems, and we build trust frameworks. And what you see is, I think if you look at new business models, it's not just about the data monetization per se. It's about the value you can get from services around those data. And I think in the transaction of data, there's a lot of value. So let me give you one example that I've used before. In one of the trust frameworks we built in logistics, there's this famous example of somebody wanting to import something, let's say bananas, and they want to let their transporter know. So you have this at the port they're docked, but they can only let the importer know when it's docked or not. But now, with this trust framework, which is actually kind of a data space before the term was coined, you can, the port can let the transporter know the container is docked. Now, that data, I mean, it's an interesting example, but what is really where the value really lies is that it offers a new business model, because now they have more customer intimacy. they can compete with other harbors because their time to market is quicker. And that is where the real value is. And I think you need to start with the use cases. And we've heard a lot of problems these days. And I think if we start with the use cases, these kinds of use cases, and really try to look into them and start with a data sovereign view on it, because that's the only way these parties in an ecosystem or in a data space are going to be building trust. I mean, that's also what Oliver says. So I think with that, you start. And I think I wanted to say something about the Data Innovation Board that you were mentioning. So what Ronnie is saying is really interesting, but we're not there yet. There's a lot of things that need to be happening. We need to focus on interoperability and how are we going to manage decentralization. And I think the Data Innovation Board is going to be extremely important. And that is something that really interests me, and maybe you can say something about it. What are we envisioning? How are we going to make it a powerful thing, this Data Innovation Board, so we can also leverage the synergies with other fields like digital identity and AI? Could you say something about that, maybe?
Happy to try. I mean, that's basically the road ahead. How is this going to evolve and what's going to be the role? But you know, the tasks and also the constitution of the board is of course in the DGA itself, so that's already a brilliant step, I would say, that we have the basis for it. And then, yeah, we need to be now as quick as with the proposal to make it into action. There are a lot of tasks, you know. It's about the monitoring also of the implementation of the different parts of the DGA. But so this part about the prioritization of standards, what I was mentioning earlier, is only one of several tasks that is mentioned, as you know. And then, of course, looking at the constitution, it will be interesting to see how stakeholders have their say and what their role is. And as you were saying, mentioning AI as well, we've seen that in several legislative proposals we now have these kind of boards. We also have an AI board, I think, in the AI Act. And so maybe it is also interesting to see how these boards will interact with each other and where there are synergies, as you said. And of course, I think also, yeah, the data protection authorities will probably want to have also their say and be heard. And so I think that will be a truly interesting work, but that's the road ahead. I don't have more information for the moment.
I think one of the things, Anna, that you did mention, though, is that if we are able to get this architecture right from a policy point of view, it has the potential to shape the second wave of industrial data and its use in terms of EU competitiveness. So the idea that do you think the focus in the short term from some of the things we've been hearing today is really understanding how this cooperation and how this how these ways of working around standards or interoperability, is that where we need to start, or are there things that we need to be doing in parallel in from a competitive point of view? Because, I mean, there's a lot, isn't there? I mean, we're at this danger right now as we want to be doing the practical, we want to be doing the experiments. I see Oliver would like to comment as well. We need to be running and walking and building and flying. We need to be doing all of these things in sort of concert.
Yes, you're completely right. That's what I tried to explain earlier, speaking about the strategy and how it, of course, like every political strategy, has different measures and yeah, different goals of different clusters. I would say legislative, non-legislative actions. You can differentiate as simple as that, and it all needs to come together, of course, because if you think about an access right to data, in the end, it will not be meaningful unless you also look at skills, for example. So you need to invest not only in infrastructure, but also in tools and in skills, so that everyone is, in the end, really sovereign and able and literate to actually do something with the data. Yeah. So, of course, it needs to come together somehow, in harmony. And yeah, I'm happy also to explain then how the DGA and the Data Act can probably be linked to the common European data space. But maybe Oliver wants to come in first.
Oliver, you had a comment around how we do everything all at once.
Exactly, just do like this and then it happens, genie. No, but I think what we have to understand, because we were all trained the last 20, 30, or 40 years in our businesses, it's about me, myself, and I to compete. And I think what we have to slowly adapt in this collaborative way, that's what I try to instill in the Cantina spirit. It's if we are successful as a network, as a collaboration unit, it's a systemic copy protection. I think it's easy to copy an individual company with one dedicated product maybe, but if we are able to really collaborate together in a systemic way, this is hard to copy for an individual company. So I think this is going to strengthen our region, our industry, and then the individual company. But this is exactly the opposite thinking right now. If I'm successful, my industry can benefit from my success, and then the region I offer workplaces or labor, etc. And for us, it's right now what we're trying to instill in Cantina. It's the other way around. If we are successful as a team, my industry will benefit, and I are part of that. So that's a systemic approach what we're trying to instill, but it's a behavioral change. It's not about technology that we need more. It's about the people have to step by step gain the trust that it's not bad for them. Actually, there's something better in for them. But this is learning.
Marianne, you had a comment?
Yeah, actually, it was a comment about something Anna was saying, you know, so it is a complex thing, and I really value it. So, I mean, what we are seeing now is the execution of the data strategy, yeah? So, and what I really value is that we have the legal house to do such an operation in Europe. And sometimes we forget that, but that is something, you know, we have a human value, a humanistic legal house, which enables us to do this. But having said that, it's really complex. I mean, we were having a discussion earlier around the coffee that even for us who are at the center of this topic, sometimes we have trouble understanding each other. And I was thinking, but you know, it might even be time for a bill of digital human rights to give impetus and a direction of what this is really all about. So this is, of course, everything is in the meticulous of each law, how we should do it. We talked a lot about GDPR, we talked about the Data Act, we talked about the DGA. But if we go outside here, outside the building, and we ask the people on the street, it's very hard for them to grasp. Whereas if you look at the Bill of Human Rights, that's easy to grasp. And maybe that is something we can throw in the mix. Maybe we need a bill of digital human rights.
What's interesting about that is if we think of it from the citizen perspective, the data subject and our roles. So we have the data spaces, we have the data strategy, we have these enablers, but each of us play different roles in society. We're bringing together our physical self and our digital self, the things that Ronnie described around getting this common framework for identity and being able to do things across Europe. And so that sort of brings in the physical digital self with some rights, which brings us into a sector, with that sector collaborating from a competitive point of view. And if you think of it from an architectural point of view or almost a tech stack, I mean, I don't know, maybe this is the beginning of this clean stack, if we can start to think of what that might look like. You know, what are the principles and foundation? How does policy then reinforce that and create the market conditions? How do you then incentivize that collaboration, and then how is it that we participate? So we've got a few minutes left, and we have this imaginary new stack that is starting to emerge. If we're here a year from now and we've been able to go off and focus on the things that will make a difference, Anna, what would you like to see a year from now, looking back on from all that you've accomplished over the last couple of years to get to this point? A year from now, what would some of those successes look like from your perspective?
Well, a year is not much time, I would
Yes.
say. But okay, we want to be ambitious, and we'll continue on our way to implement the data strategy. So 1 year from now, I hope that we have a proposal of the Data Act, and we've started good negotiations and fruitful discussions like these. We'll continue, hopefully, on the topics of the Data Act. I hope the continue on high-value data sets will also get going and have insights from different perspectives. And also, of course, for example, the European Data Innovation Board has probably, or hopefully, started their work. Yeah.
Oliver, a year from now, you've been doing your experiments. They've turned into code. That code is proving to be valuable. The use cases are validated. Where are we a year from today?
I would hope that we are in the market for 4 months then, if you take it a year from now, and that we have a network of networks, because we're already building it right now, that we can connect to existing networks. And what Ronnie said before with the identities, that we do not have maybe 100% SSI, for sure not, because most people do not understand it yet, but at least that we have a good portion of 20-30% of the companies who joined Catena by then are the pioneering for SSI, for single sovereign identity or self-sovereign identity.
Yeah, that's great. And Ronnie, where would you like to see the things that you're working on a year from now? If we have the opportunity to present a retrospective of the work that you're doing around the frameworks and these really important building blocks.
So what I would like to see is basically skills and understanding that industry at large, also the public sector, understand what kind of opportunities lies there if they catch this opportunity and use the tools to the best of their abilities. That's the most important thing now, because basically the tools are there and they might have been there for a long while, but we are already slow people, we humans, so actually executing on them, that's what I would like to see happen, and that builds on skills and knowledge. So that's the most important thing.
And Marianne, that sounds like somebody needs to educate and help people come to understand over this next year the value of soft infrastructure. So what would you like to see achieved a year from now?
Yeah, I think I'd almost had to answer awareness, awareness, awareness. It would be great if data sovereignty would be a key design principle. Yeah, let there not be any new products or services that doesn't offer data sovereignty to their users. And yeah, I think the awareness is dawning upon us that data sovereignty is just as important as CO2 reduction. You know, if you talk about the green stack. So in a year's time, I would hope that the awareness about this and the importance about this has even grown. And soft infrastructure is a word that more people use than just we in the room and you online.
Thank you. So our time is almost up. I think there are a number of things that I found very inspiring in listening today. And the thing that struck me the most over this last hour is almost all the rules of dominating from a platform point of view. We've talked about flipping those in a network perspective. We've talked about the possibility of what a new stack might look like, which is a combination of how we work together, how we use policy, how we collaborate. And we're starting to find new tools around interoperability, new frameworks, which create a common language, and with a common language or a common approach, together with a strong vision, there is a lot that can be achieved. So I'd like to say a huge thank you for joining us this afternoon, Anna, Marianne, Oliver, and Ronnie, and also to Eileen. Thank you so much. And I don't know whether or not we might negotiate an invitation for a year from now to be able to say these were the things that we aspired to do, collaborate and co-create, and these are the things that we've done. So thank you so much.
Thank you.
Bye-bye.
And I believe we're going to go straight into the next section.
Okay, 1 minute break and we continue with the last session with the usage of data during the corona pandemic.
Yeah, welcome to the last session on data usage in the pandemic. I'm happy to be here again this year and also like in real, although the pandemic is still going on. And we have three great speakers. Stefan Hulst, which will be joining us from New York. Simon Ginard, which is originally located in France, who is live in Berlin. And also André Golles, who came from Switzerland. And normally the saying would be going, may you live in interesting times. Now we are now going through almost like 20 months of like pandemic where we learn a lot of data is used. For a data geek, it's probably the best time, the first time in history that so much data was used almost like on a daily basis, more than the weather report. And we learned there like how data is changing, what the policies should be doing, how people don't understand the policies, and also that behind the data and the policies are like real people, real experience and real tragedies. So my first speaker online will be Stefan Verhulst. He is the co-founder and chief research and development officer of the government laboratory of the New York University. They're doing awesome work over the last couple of years in that area. And his mission is like how the advances in technology and science can be harnessed to create effective and collaborative form of governance. So that's exactly the sweet spot. We are looking into it for the pandemic, how to figure that out, how to get out of the pandemic with the use of data. So thank you so much for joining us. Good morning almost to New York. And Stefan, the floor is yours.
Part of this panel that travel plans scout for me to but delighted to.
Can you turn up the volume, Stefan? Because you're really slightly come across here.
Can you hear me now?
It's really quiet. Hold on, I'm asking the technology. Kriegt ihr einen Pegel oder? The technician said that your volume comes in really, really low. So if you have somewhere.
Is that better?
Perfect. That sounds good.
Good. At least I won't have to shout in order to be heard here. But again, thanks, Walter, for this kind introduction. And as I was saying, delighted to be part of this panel. And again, apologies for not being there in person. But what I would like to do in the few minutes that I have here today is to share some of the work that we've been doing around data for COVID-19, which obviously is the topic of today's session here as well. And I will go quickly through some of the projects that we've developed in order to get an understanding of what was actually happening in the data space, but then mainly reflect on a few takeaways and especially challenges that we have identified that we really need to start addressing if we are if we want to be prepared for the next dynamic threat that likely will emerge in similar kind of unexpected ways. And we do need to make progress on a variety of areas in order to really anticipate the use of data for societal objectives. And as mentioned, I'm the co-founder of GovLab, and GovLab is an action research center. So we are based here in New York, part of the engineering school, and our mission is to improve the way we go about making decisions in order to improve people's lives by leveraging new technologies and new science. And specifically, of course, that means that we also have done a lot of work and are doing a lot of work around the use of data, specifically unlocking data, both in the public and the private sector and in the scientific environment, in order to address critical public needs, such as, for instance, the pandemic. And so we have a whole range of initiatives, not only focused on the pandemic, of course, but they focus on how do we accelerate open data, how do we establish new kinds of partnerships with the private and the public sector and with people involved in order to leverage data that can be used for social objectives. And with regard to COVID-19, we initiated a distinctive range of initiatives where we helped set up data collaboratives, where we hope to provide access to data in order to inform the response to COVID-19. But we also started, because we realized that a lot was happening in the space, we started a whole range of repositories of examples and repositories of initiatives, which are all available at our website called dataforcovid19.org. And so I will go quickly through some of the examples and some of the findings, because much of the in-depth analysis can be found on the website that I've just shared as well. And there you will find, for instance, also one of the largest repositories of examples on how data has been used, and more importantly, how different actors have come together at a time of crisis in order to provide access to data that can inform the pandemic moving forward as well. And so if you go to our repository, there we have 200 plus curated examples where we can learn from on how we can structure a data collaborative environment for instance, addressing COVID-19. Now, I think the important element when we start reflecting about the use of data for COVID-19 is that we do need to anticipate that this is a dynamic space, and that if we are really trying to become smarter about how data is being used, we really also have to become smarter about at what stage of the pandemic is data valuable and for what purpose. And I think it's really important to, if we start talking about data, to really pinpoint at what kind of stage of the cycle of the pandemic, anyway, do we need what data for, and how do we then use that data for informing? And obviously, anyway, typically in the crisis management, which also applies to pandemic, we have the response stage, we have the recovery stage, we have the reform stage, and then subsequently the readiness stage. And I think it's going to be really important when we reflect on data for COVID to really start becoming more sophisticated about understanding what data is needed at what part of the cycle. And unfortunately, one of the big headlines of our work is that we've become kind of sophisticated about the response stage, but the other stages are really still out there, and there is not that much, from my point of view, really investment and thinking about how do we actually cross the full cycle. We also, of course, need to be aware that when we talk about data, we in essence talk about insight, and we talk about the different types of questions that data can answer, ranging from becoming smarter about the situation to becoming smarter about why is it that we are in the current situation? Why is it that we have a fourth wave, for instance, of the pandemic? But also being able to predict and subsequently translate that in prescription. And again, big headline from our work is that we have seen that most of the initiatives, unfortunately, were focused on the situation analysis, which is of course crucial because you do need to have a baseline of what is the current situation. But then we really need to move beyond descriptive analysis and also have to invest more and more in actually the diagnostic, i.e. why is it that we are in the current situation, and then subsequently the prediction and of course the prescription as well. And that's the second, I guess, big headline before I go and share some of the initiatives. So one initiative that we developed was together with the OECD, where we tried to document how open data, by which we mainly mean open government data, has been used for the response with regard to COVID-19. And this is the report that we developed. And again, it's freely downloadable at the OECD website as well. But again, big headline here was that open data was indeed used in a variety of ways, but it was mainly focused on the response. And we still see that in today's environment, where obviously we still have the pandemic with us, but that we also, of course, have moved on and really start looking into recovery, is that we still see that most of the initiatives are supporting the response, but not per se the recovery. And we really need to start thinking about how do we actually use open data as an asset for the further stages of the pandemic, including becoming more ready for future dynamic threats as well. What was clear is that data has become, and especially open data, has become a main public communications tool. And I think that was a realization that we didn't have at the beginning of open government data, where actually open data became a way to communicate with the audiences and the public at large on the current situation, and also how ultimately things were evolving over time. And I think open data as a public communications tool became central in the way governments were thinking about open data. More importantly, also, after, of course, years already of advocating that open data is not only a tool for the wider audiences, but actually a tool for government itself. I think I think COVID-19 really made that a realization within government that actually open data is a tool for themselves on how to actually go about leveraging data. I was also, anyway, interesting to see that while, of course, there are a whole range of issues that data can inform, that public health was and remains, of course, the main priority of using open data. But as we will see later on, there are many other questions that are not per se public health questions, including questions with the impact of certain kinds of interventions on employment, on ultimately the well-being of businesses, that also needs to become more and more data-driven beyond purely epidemiological kind of questions as well. Now, the major takeaways, and again, it's a 100-page report, so I'm not gonna or not gonna go into full detail here, but one of the main purposes, or one of the main takeaways was that data was not always published with a clear purpose. There was a lot of putting open data out there, but then towards what end? And I think that's a key challenge that within the open data space we still have to grapple with, is that we have to become more demand driven. There was limited collaboration across the open data initiatives that we saw happening worldwide, which would have helped instead of duplication. And then more importantly, what was interesting is that every country worldwide set up a crisis, quite often agency, in order to deal with the pandemic. And in most cases, those that were in charge of open data were not invited to be part of that crisis team. And from our point of view, that was a lost opportunity to really align open data better with actually the crisis response that was happening within society and worldwide. And I think an important tool or an important element moving forward is going to be who from the open data or the data community within government needs to be part of those kinds of crisis management, so that we actually have a better purpose-driven kind of release. Other project was really focusing on private health data and how that has been used. And we indeed have seen a massive increase in experimentation on accessing non-traditional data sets, such as, for instance, mobility data, ranging from call detail records, of course, which are collected by mobile phone companies, to ultimately geotagged social media data that allows us to understand, for instance, anyway, how what message was delivered from where, so that we have a better understanding of geolocation driven communication as well. And again, we developed a report here together with Cubic for the Open Data Institute, where we had several detailed case studies ranging from using mobility data in Canada to, of course, what has happened in Europe with regard to accessing call detail records to understand mobility patterns, to ultimately Facebook data for good mobility data as well. And again, we have a dedicated repository with 51 curated examples where, again, public health was the dominant use, and situational awareness, i.e. being able to map where people were at particular kinds of events and particular kinds of days, and how that related to, for instance, interventions with regard to social lockdowns, general lockdowns were the main kind of uses. I also, as editor-in-chief of Data and Policy, initiated a special collection with Richard Benjamins from Telefonica and Janine Voss from GSMA, where we had about 14 dedicated and detailed papers on how telco data was used for COVID-19. And again, very rich material. But I think one key takeaway from that was that most of those efforts were basically voluntary and pro bono, which meant that most of those efforts will likely go away, will not be systematic, and there will not be a persistent use of telco data, which leads me to reflections on what do we need to do to make the use of data, both government data and privately held data, more systematic, sustainable, and responsible. And from our point of view, there are at least 7 areas for policymakers and the data community to make progress so that we are better prepared, because frankly, in March 2020, we were totally unprepared to start using data in a more systematic way to inform COVID-19. And my fear is that if we don't learn from what anyway, and how we need to become prepared, we will actually not use COVID-19 in a way that we could use it as a forcing function for progress. The first one is that we really need a better governance environment for accessing both public and privately held data. Many in the space were actually confused, especially in Europe, with regard to GDPR, whether they actually could share data for public health. And so we need to really have clearer guidance, but we also need better data sharing agreements that are streamlined, that are standardized, so that we don't have to, anyway, have the lawyers suddenly look into, all right, so we are sharing data, but then hold on, we first need to have a contract or a data sharing agreement before we can do that, while people are dying as a result of an infectious disease, for instance. So we need to make progress there as well. The other element is that we really need to become more sophisticated in making priority questions. I mean, there's a lot of data being shared, but it was quite often unclear toward what end and to inform what question. And so here on our left was an effort that we've done where we basically mapped the topics that are important to be informed with data, for which we need data for. But no one in the public environment actually came up with their own priority list, let alone globally, would have helped if we would say, okay, these are the questions we need at the different stages of the pandemic for which we need data for. And so the demand was actually poorly defined, which means that the alignment with the supply of data, both in the private sector and the public sector, was quite often hampered. And so we really need to have more sophistication in the formulation of questions and the prioritization of them as well. The other question is that we need to professionalize the supply. We had many in the public sector come to us and says, well, we need data with regard to call detail records, for instance. Who should we talk to? And in most cases, our answer was, good luck finding out. There is no dedicated function within the private and quite often in the public sector that really can respond to solicitations around data during a crisis such as the pandemic. And that means that we need a new profession, which we call data stewards, that really can respond and formulate the questions and formulate the response with regard to access to data. And absent that human infrastructure, it's really hard to make progress. We need funding. It's remarkable with all the funding that has been made available around COVID-19 that data is quite often an afterthought. We did, anyway, in Africa, a challenge where we funded several initiatives together with, well, through AFD, but we need more of that kind of public funding channel to really become smarter. And we need to build the business case for actually data reuse, which was also mentioned in the previous panel as well, is that actually there might be incentives for creating data collaborations ranging from reciprocity to ultimately perhaps even developing models that can be monetized as a result of new experiences as well. And then we also need a social license for doing so, because what we're talking about is really reusing data that was collected for one purpose, and now we're going to use it for the pandemic, which might create real concerns with regard to trust and concerns with regard to misuse. And so we need, and consent quite often doesn't really address that kind of reuse for crisis situations. And so we need to establish, like we did in New York, citizens' assemblies to really think about what is appropriate, how would we go about this, and what is a way forward. And then lastly, a lot of the initiatives that we've seen were all about creating insight. But of course, the value of data is only as good as we actually use it. And so we need to turn data intelligence into decision intelligence much more than what we've seen. Quite often, the initiative stops at a dashboard, but what does that mean with regard to how that can be used for decision support, or for instance, simulations on how different decisions will play out. And we need a lot more, like anyway, with our colleagues here at ASU, a lot more of those decision theaters that really uses data for decision support across the decision lifecycle. With that, Walter, I'm going to stop here.
That's good. Just was on the way to cut off. Thank you so much, Stefan, for your presentation. If you don't mind, I would share your slides because I got like a request, if that would be okay. And also, if you still have time, please stay on the line for a possible Q&A after 5:15. And otherwise, thanks again to New York. And our next speaker is Simon Ginard from France, Open Data. He's one of the cornerstones between German and France Open Data Alliance, and he will present examples from France. Thank you so much.
Thank you, Walter. Thank you, Pencho, for the invitation. The day has been quite long for all of us, so I'm going to try to make it quite short. Actually, I would like to focus my presentation on a specific use case and a specific country. And as you can easily guess, the country will be France, and the specific use case is how we used open data during the pandemic. So my story starts, at least this one, not my personal one, my story starts in March 2020 when we... Okay, can I get the feedback presentation on that one? Thank you very much. So in March 2020, Stefan actually mentioned that particular date. In March 2020, all over the world and in Europe, it was the beginning of the pandemic. And this is a screenshot of a press conference of Prime Minister Edouard Philippe and the Health Minister Olivier Véran. Giving information to the population about the dissemination of the COVID-19 in France. Actually, Edouard Philippe back then was my boss in a way, because as Pencho mentioned this morning, I used to work at Etalab, which is the French Prime Minister task force, but he is no longer my boss, firstly because he is no longer the Prime Minister of France, and second, and definitely that's a different reason, I'm no longer working for Etalab. So back then in March 2020, the thing is, as a population, every day, people in France, we had a lot of data going on. We didn't miss data at all. But the thing is, we had data from very different sources. First one, we have official reports, not only at the national level, but also at the regional level. We had data published or spoken during press conferences, such as this one. We had data published on Twitter feeds, and we also had data directly from local hospitals. The fact is, we had a deluge of data, of course, but I should say that we had a deluge of poorly structured and non-reusable data. So that's the first point, and it comes back to March 2020. And March 2020 is also a date really important because that was the first time that the country went under a lockdown, a national lockdown. Basically, that means that everyone was stuck at home, maybe as you were stuck at home back then, including a lot of data scientists working for the public sector, for private organizations. And given the fact that back then there have been no official open data about the pandemic and the situation, they started to say, okay, we are going to build our own repository of open data about the pandemic. So they used a lot of quite modern tools such as a GitHub repository or a Slack channel, and they started an initiative called Open COVID-19 Effort, such as France. And they first started by designing and launching a new data standard, a way to describe and to get the number of people infected at the local level by the COVID-19. So it started like that, and then they, I think, made a very good job at putting a kindly but still strong pressure on the government to publish open data, saying, okay, this is the data that we need. If you don't want to publish it, let's do it by ourselves. And it proved to be quite convincing for the government, at least to try to do something. Among the many different initiatives that we have seen during these times, the most famous one is COVID Tracker. And I'm going to just focus on that one. There have been numerous initiatives, but that one is quite interesting because COVID Tracker right now is today the most trusted source of information in France regarding the COVID-19 situation. It's a quite basic website, and no critics at all about saying it's quite simple, but it's quite effective. Basically, this website is using only open government data and is giving users a very clear view about not only the dissemination of the pandemic, but also the situation in public hospitals in France. I have to say that listening to the really interesting presentation from Stefan, and he said that most initiatives focused on the communication, and I think he's right. But in that case, that's not only a question of communication, but also a tool to take decisions, because we had numerous reports from managers of hospitals all across France saying that they use COVID Tracker to take decisions, because they can, for instance, using that website, they can compare the different waves and saying, okay, is the new wave coming slightly different from the previous one, and to use the data on a very, very clear view. COVID Tracker is also a very interesting story because it is built by a not-for-profit and a small team, and at the head of this small team is a guy named Guillaume Rosier. He's not as famous as our president, but still he's quite famous, and he soon became the public face of the pandemic. Guillaume Rosier is 25 and is a data scientist. He works for a private company, but when he started, he was just about to leave schools. And he first started by sharing some data visualization on his own Twitter feed, and then with a small team, they designed this website, who became COVID Tracker. Right now, you can see Guillaume Rosier invited on many TV shows as an expert of the pandemic, okay? So basically, TV journalists come and see him to ask, okay, Guillaume, how is the situation going? Is the government right to ask people to get a third dose of vaccination, and so on and so on. So it has been really, really interesting, because basically this website is fully powered by official data, right? But in a way, many people tend to trust more a third party, such as this one, than the official source. And it is no surprise that, and this is the Twitter that you can see, tweets that you can see online. He has been awarded the National Order of Merit by President Emmanuel Macron in the recognition of his very good work. I don't know if you realize, but he's only 25. Usually you get that kind of honor when you are much older. The fact is I am 45 and I'm still waiting for my medal. So that's just a joke for my president, if he can hear me. And this is a quite interesting story, I think so. And last but not least, if we look at the situation now, when I said back in March 2020, there have been no central repository of open government data about the pandemic. The fact is, if you go right now on data.gov.fr, which is a national open data platform, you could find more than 70 different data sets, not only on health, but also I think on the recovery phase that Stefan mentioned also, not only on the response phase, but also on the economic situation, on the impact of the pandemic on many different economic activities. Some of these data sets come from local public authorities, but maybe more interestingly, some of them come also from the private sector, including a French-German company called Doctolib. I know that they work also in Germany, and basically this is a website where you can take an appointment to get your dose, your vaccination. And this is today also the most powerful source about the progression of the vaccination program in France. So to conclude, what have we learned so far? Because I'm afraid that the pandemic is not coming to an end right now. So we not only must prepare for the next one, but still also have a lot to do to confront to the current situation. And as you can see, some of my lessons are clearly shared by the GovLab and what they said before, what Stefan said before. The first one is, of course, that question of data governance, in itself, but also more focusedly specifically on that question of data governance. Data governance has a cost, of course, but the lack of data governance is even more costly. And that's what we have learned the hard way. The second thing is, this morning, Pencho, you asked the federal minister about there will be any potential impact of the open data in Europe. The fact is, the impact is real, and it's real now. I think the example of COVID tracker and so many different initiatives from civil society organizations shows that we have a clear use case for opening up data today in Europe. Last but not least, I think this is a story also of data collaboration between civil society and governments. It's not that so easy, I must confess, having been part of the government before. But I think it's quite interesting when a government is able to work with others and to accept that civil society can also impulse new solutions to problems. And that's very good lessons. And last but not least, I think that the pandemic also shows that some data from the private sector clearly have some public interest, or there are a clear public interest to share this kind of data. And that's linked to a discussion about B2G data sharing, but I'm just going to end on that point because I think there is a panel on that specific topic tomorrow morning, and I will be happy to meet you again tomorrow to speak about B2G data sharing. Thank you.
Thank you so much, Simon. And last but not least, André Gauliès, our speaker from Switzerland, who will shortly give us an overview what going on in Switzerland with fighting pandemic. Sorry, pandemic data and data donation.
So thank you, Walter. Thank you for the invitation to make here the last speaker. I'm not the speaker. I just was invited for a panel and to share some experience from Switzerland with you. I first have to say I share what the previous speakers talked about from Stefan, hi Stefan, and from Simon, and what I can tell you is maybe something like a footnote to what they already told you. And I would like to shift the focus on data away from open data and open government data. As you know, I'm an open government data, open data activist now for over 12 years, more to the personal data. And one of the experience, of course, of the pandemic is that there's a lot of personal data around that cannot be used of different reasons to help fight the pandemic. This is, I think, from the first hour of the pandemic was a very interesting subject. And of course, there is an alternative. We can't change regulation during the pandemic so quickly to share this data, but of course, this is one of the lessons, as Stefan also told. But there's an alternative, and the alternative is, of course, to ask the people if they are willing to share the data on a voluntary base, so-called also data donation. And what we did in Switzerland, and I want to quickly tell this story, is that in summer of 2020, we did a large survey in Switzerland to test how willing the people are willing to share their personal data when it helps to fight the pandemic. And the result of the survey was quite encouraging. Over 60% of the persons said they were willing to share their personal data to help fight the pandemic if, but only if, the data is collected by a governmental agency. So we had this result on the table and said, well, what we want to do now? And there have been also experience in Germany, where I think the Robert Koch Institute started with collecting data as data donation. But we say the important point is, what is the purpose? Also a point that made Stefan before, what is the purpose? Who is going to use this data really? We need a use case. That was also in the previous panel. Use case, use case, use case. I love use cases. And so we need to have a use case. And then we looked around who could be the use case, our government or the cantonal government or large companies. And we found one institution quite close to us in Zurich, the University of Zurich. And the story goes like this. We started to talk to the government, to the directors of the university, and we explained we would like to do a data donation use case project or something like that, helping to find the pandemic. And the first answer was, no need. We are fine, we have our data, we know how to do, we handle that, everything is fine. This was in, I think, spring 21. And we had some meetings, and then suddenly they called us after the third meeting and said, now we have a use case. We need urgently data donation. And what happened in between? In early summer of 21, the head of pandemic management, it's called pandemic, pandemic management of the University of Zurich, got the order from the director of the university that the university should go back to normal during fall 2021, and he had to prepare that. And suddenly he realized he doesn't have the information. He doesn't have the data. He doesn't know what is the vaccination status of the students. What is the vaccination status of the collaborators? Have they been affected? Have they been tested? Where do they move around? So he absolutely knows nothing and has the task to prepare a normal execution of the university in September. So. We designed very quickly a project where we asked all the collaborators and the students of the University of Zurich to share their health data, their COVID data, and other aspects with the university to help them to prepare. To prepare the operation of the university during the beginning of the semester. And the interesting point was we didn't have the response of 60%, but we had the response of between 7 and 8% of all collaborators and students of the university, about 2,500 persons who were willing to share their personal data during 6 months. So they are surveyed every week about, are they vaccinated, are they infected, have they symptoms, where do they move around on the university. And we have this data, and this is really a great experience, I have to say, and it helps the university to manage the pandemic situation. So I come to end. The lesson learned is here, we don't have to wait. until regulation is there, we can do on the micro level also. Data donation projects, we have to ask the people, but the most important thing, we have to have a use case owner, a data user, and it's not the end user, it's of course the management of the university in this case, who knows what are the questions and knows what is to ask the people who are willing to share the data, and then we have an excellent data donation use case.
Yeah, thank you so much. I think this is a great example because in Austria it was like rocket science to send out letters to the unvaccinated that they should get vaccinated in fall 2021 because of whatever GDPR or data compliance. It's 5:15. I don't know how much time we have. Otherwise, we would take questions from the audience. And I don't know if we have Stefan still there.
Thank you, Simon. Thank you, Andre, and Stefan, especially Stefan, for pointing out the benefits for GOVs themselves in open data to have them flowing. And beside that I think we need oversight technologies for enforcement of open data laws, which is very important. I ask myself if in Germany the open data laws are sufficient enough for really cross-level open data. And I watched what's happening in the USA with the Foundations for Evidence-Based Policymaking Act, where they have put open data in the central place of this act. If this, I ask especially Stefan, if there are any experience, what are the effects until now from this act, and if this is maybe an interesting thing for Germany too, for open data. So where we catch the governments and the politics in their core responsibilities for having foundations for their decisions. Thank you.
Do we have Stefan still on the line?
Yeah, can you hear me?
Yes.
Yeah, no, good question. And indeed, within the US, we have a new legislative basis around evidence-based policymaking that also transforms the way to think about open data. And I think it's still fairly early days to a large extent, but we have already seen a variety of progress being made by government agencies. And I think the biggest progress that we have seen so far is that as part of the Act, government agencies are obliged to develop a learning agenda by which they have to actually indicate these are the questions that we really need to seek answers to in order to be able to have evidence-based policies or evidence-based public services. And that in itself has already been a transformation of thinking about data, because in the past it was always about, anyway, we need data or we don't need data or we cannot share data. But if you have a learning agenda and says, look, if we have answers to those questions, by making data available, we will be able to become more evidence-based and as a result have better policies and better public services and perhaps even more cost-effective ways of actually going about some problems. That in itself has been a cultural change. And I think that, from my point of view, is a positive. Now, there's a lot of talk about creating a national data center. And again, there is some progress being made there, but I think what was discussed in the previous panel, that we really have to start thinking about more of a network model in a decentralized way. I think that's where I hope the US will listen to what's happening here in Europe, because I think that's exactly probably the way forward, as opposed to having some kind of a centralized way of sharing data, which I know is not the way they think about it, but at least I think there has to be a lot more thought about how you actually architect that in a way that matches the demand.
Yes, I just, maybe it's just, I think there is an elephant in this room. and it's about the use of personal data during the pandemic. The fact is, you gave us, Andre, a quite interesting example, but the truth is we have seen an unprecedented level of collection of personal data for green paces, for digital COVID certificates, for contact tracing and notification apps, and so on and so on. And the fact is we are still waiting for proof of effectiveness of these different applications. I'm not very aware of the situation right now in Germany regarding the usefulness of your contact tracing application, but in France, the Data Protection Authority, the French Data Protection Authority, CNIL, asks the government to prove the effectiveness of these green paces on contact tracing application, because they said we agreed on the fact that you will collect many personal data, but only if you are able to prove that it has been effective, to prove that it is effective right now to reduce the dissemination of the pandemic. The Data Protection Authority asked once, they asked twice, they asked 3 times, and last week they published a report saying, we ask for the 4th time the government to publish data and to give us proof that it has been really proportionate and effective in a way to fight the pandemic. So I think it's important also to have a view on that point.
I think that point is like expected everywhere. As far as I understand at the moment, the expectation in the contact tracing with digital apps or whatever you're using didn't match the expectations. On top of that, I think having personal data is one thing. I think we're still like having big issues of like really like small data things, like how many beds are available, who are the people in the hospitals, are they vaccinated or not, and so on, which took like now the 4th wave of a pandemic, and we're not even close there where we probably should have been already like in the 1st wave, like on really like basic data, and the learning process is way behind the curve. Like there was like almost like 1.5 years lost. Some people, cynics would say it's probably maybe it took the 4th wave just to realize it's like how a pandemic is moving, especially like this learning curve of like exponential growth for people in the decision making clearly didn't work out. After like a national-wide math lesson in 2020, it was forgotten by summer 2021, and now we are there. And the question is like, will now this situation in these countries, some of them are like DACH region, German-speaking, and for various reasons it's even more complicated there, do we make then actually like the learnings to get out of it like for the next fall? Because this season is already over, it will not be pleasant, the boosters won't be coming in on time. And then there's like a lot of other like questions, I think, which has nothing to do with data itself, like on the medical side, and also like how to transfer this knowledge, and like they're putting out policy, which is understandable for the people, coherent over the time, so people actually stick to certain rules, which will be some point necessarily. And then the other big question is like how to turn that back to get to whatever the new back normal life will be, but basically roll back those measurements once they're not being used anymore. Nobody's talking about that we should have measurements like with an expiration date, just in case we don't need it anymore. Because everybody knows once you give like something out, people will get used to it. You create bureaucracy who is like happy to build up on top of it, and then you would have to reduce it. I think that's one of the questions not there. And we probably will see not even like in the spring how is like the halftime standing of the pandemic, and probably like a lot of things could changing there, like who will be actually, if it's over at a certain point, how the score will be, what measurement actually did a great job, what not, and who guided a population through, with especially with the data where we should have told people how they should care about themselves. I think nobody really had a plan at the beginning of the pandemic for themselves, what that means to be there in 20 months. Maybe that was for a personal level too much, but also like for governments. Now we're in somewhere, and we still like in that thinking in the same stage. So that's, I think, will be a great question for the future to figure out like who surfed those waves with what things, the best way to get the population on board, because we have like major crisis on healthcare sector, or like people who don't want to get vaccinated and causing demonstrations in front of hospitals, which is also crazy.
Well, if I can, Walter, I don't know whether I'm still, I can't see myself and how I positioned in the room there. But I think it's a great question because it refers, anyway, the previous question was about evidence, using data for evidence-based policymaking. And I quite often make the joke is that we should actually use data for evidence-based data policymaking. And it turns out that quite often that's an afterthought. And we don't really have much data about the use of data. And I think for whatever data strategy we develop, we also have to actually start using data about data. And I think this was a clear question that indeed we quite often, anyway, jump in, assume that it will work, but then we don't have really a framework to understand what's the impact of actually having data infrastructures like the ones that we focused on here today as well.
I think the last word from Andre.
Yeah, of course, I agree with everything what has been said. I just want to add one point, because this is also a bit impression of me from this great conference. We, of course, look at the governmental level, of the national level and the policy level, and that's obviously it's very important. But I would add, and that what I wanted to do with the short story about the University of Zurich, we have also to look at the local, at the regional level, at the level of each institution, and the question is there: how are they able to use data? Do they get the data they need, and what are the use cases? So I think this is a long way to go, and also an educational process to bring the responsible people in all these institutions and communities, etc., to take their role as data users to answer questions like how to fight the pandemic.
Yeah, then I think that's the time to say thank you for your attention at that time. Thank you so much for Stefan. Thank you for your presentation, Simon. Thank you, Andre, and also thank you, Penche, for running Open Data Summit, because like in this whole pandemic, what's missing out is like national, international, local cooperation across the boards, and we are like still like also in that direction, way behind the curve from the pandemic. Thank you so much, and I don't know, Penche, if you want to make the announcement for the next day, or
just invite the guests to follow us tomorrow.
See you tomorrow, same time, same station. Bye.